to watch jury deliberations that we can't even watch. What's wrong with you? Why would you do this? Why would you? Oh, I'm just kidding. I'm just kidding. I'm very appreciative that you are all here. There is so much. There is so much to do. It's not a fresh haircut, actually. It's just I combed it a few minutes ago, and I haven't had time to ruin it yet by like going bigger. None of that has happened. What's wrong with me? Oh, that's a long list. We don't have time. We don't have time for that. Oh man. Ooh, what is happening backstage? We have I didn't know we would get one so early. We've got a guest. Hello, good sir. I cannot hear you at all. Well, welcome to the stream when he gets on mic, Mr. Uncivil Law. Very, very glad to have some company on this day of bashing heads against walls, waiting for juries to come to a conclusion. Hopefully the one that I came to so many months ago. Things have been a little weird the past day as as I'm getting like text messages from friends and stuff because they saw what happened yesterday, right? And if they may not have, I don't know if they were here live or not, but they certainly saw what happened yesterday today from places like Breitbart and other sources that mentioned the show, that mentioned what happened. They talked about YouTube shutdown, which was entirely bogus. Obviously, it's hard to have a copyright violation on a public broadcast of a public event. You know, court is not typically going to be copyrightable. That's not a thing that we would normally expect to see because you know, it's a public proceeding. It's factual. There's nothing artistic about it. In fact, I'm pretty sure they're using the court cameras. Oh man. Let's see who we got. There's not a ton of live stream coverage yet. Court TV, or wait, Law and Crime has it, and so does Live Now with Fox. Who do we choose? Who do we choose? Oh, I'm not going to do the Fox one. That's got a bunch of commentary going on. We'll just do the Court TV one. I don't know how they get the courtroom camera feed specifically. I mean, I'm just rebroadcasting it. Yeah, the reason I'm not going to do Fox is because they've got like a reel going, and that's different, right? Like, this is Law and Crime. This is not copyrightable. Hold on. Like this? I mean, what was that? Show me your artistic impression of what's happening there. Nothing, obviously. But Fox is running reels of the Kyle footage. There's probably some commentary. Oh, goodness. Some commentary going on in the background. So I'm not gonna do that. That seems a little much. But today we are going to watch jury deliberate. Well, we're not going to watch. We're going to be present for jury deliberations. I am seeing this thing through to the end, and I pray that the jury deliberations are short, because sleep apnea confirmed. I pray that the jury deliberations are short, because I don't want to sit for like 8 hours or days doing this. That would be silly. So we want is short jury deliberations. I think short jury deliberations benefit Kyle for the most part. I think they indicate a quicker finding, a finding of not guilty. But we will see. I'm still getting woken up. I'm getting woke. You heard it here first. But yeah, so I'm hoping it's quick. With the quickness would be ideal. That way we can move on to whatever the next thing actually is, and Kyle hopefully will be going home. Havoc. Man, Richard's voice and Wisconsin mannerisms have been one of my favorite things in this trial. Your Honor, they're unleashing havoc on the city of Kenosha. I just that very, very thick, like Wisconsin Chicago mixed accent is beautiful. It's a thing of beauty. It's a thing to be treasured. And to see that really come through and put Midwest on the map, I mean, in a way that has not been done since Fargo, right? And I'm glad Wisconsin is finally getting its due, because Fargo really torqued off a bunch of Minnesotans.
Hello again. Now I can hear you fine.
Oh, hey, how's it going, buddy?
I had to turn it off and turn it back on again.
That's how it goes. That's it. Welcome to the live stream of Hurry Up and Wait. It's
Very
like we're
much
in the
so.
army.
Very much so. Yeah, so we're going to do the tumbler thing at some point with the lotto balls, which I think is just kind of a hilarious way to do this. I mean, why not? I
Yeah,
suppose, but I've never quite seen it done that way before.
I wonder if they're gonna like sit there and do it on camera and be like, juror number 51.
Yeah.
Right? Like,
And what result am I hoping for at this point? I guess to be on the jury and be deliberating if I had to go through all that mess.
Yeah, because otherwise you're just gonna be sitting there literally all day, watching anything but the news. So you're gonna be what are they gonna have them watch? Because like
For
there
Disney
could be
films, maybe let's watch Frozen. Let it go. Let it go. I don't know.
yeah, because if they have just the court said TV stations or whatever, but if they have TV stations, they could even get
You're gonna have to have a bailiff in there with the remote or something. No
an
CNN for
errand
you.
ad. Yeah, just click. Like, just in case a commercial comes on. If that were the case, like in a hypothetical, I would love to buy ad spots on each channel at the same time that just says Kyle's innocent, so that when the bailiff goes to like change through the channels of the courthouse, he's like, oh God, oh God, oh God. Like, just trying to get there.
Any reasonable jury, yeah.
Yeah. Let me show you the standard for, or let's talk about jury nullification.
Absolutely. Well, we don't need jury nullification in this case because, of course, he's actually innocent of all the charges.
That's true. That's true. Let's just talk about the jury's duty to follow the law, not their
That'd be
feelings
good. Yeah,
over
let's
and over
just
and over.
we just actually follow the law all the way through, and it leads to this result.
Yeah, it'd be anyway. So what are you thinking, man? Do you think this goes fast? Do you think this goes over a day?
If I were a betting man, yes. My bet's a day and a half.
Why would you say that?
Just because it's well, I'm basing it off a couple different factors. I'm principally basing it off the fact of what Robert Barnes said when he said that when he was doing his work jury consultant, that he found that Kenosha was one of the most favorable counties to Kyle, But even though it's one of the most favorable, still 2/3 of the population had a starting premise against Kyle, and a third of the population was dyed in the wool opposed to Kyle. At least the
Right.
way he says it, there's a third of the population that is dyed in the wool, cannot be convinced. So okay, I'm just trying to base it off probabilities. I'm saying to myself, okay, what's the probability that this defense team did their jury consulting right? What's the probability that they made sure to vet themselves on the jury? Might not particularly great. All right, so what's the probability that there's going to be someone who's going to be a complete hard nose and not want to do anything? I'm like, okay. And then what's the probability that this person might try to wear someone down into some kind of compromise verdict? So I'm trying to like calculate all these things in sort of the back of my head, a back of the envelope math, as it were. And that's why I say a day and a half. How about that for an answer?
That was a lot of answer, but it's all right. I hate that it's right because I don't want to sit for a day and a half. I want the trial done today. I want to know. I want to know the answer, right?
I'm ready to
Don't
go. Let's
you?
see, how long do we need? Do we need to elect a forbid? It's like, I'm ready to go. It's just not guilty is fine.
Yeah. It's like I imagine I imagine me. It's like put me on a jury like this. I'm like, I know the answer.
Yeah,
I know
I
the
know the answer. That's right. That's right. But I'll tell you what, man, when they were reading those jury instructions yesterday, the thing that went through my head is I wanted to raise my hand and say, teacher or professor, this is not a fair question for my final exam in crim law. This is not fair to have the question this complex. It's like I was having bad flashbacks to law school for some reason. I'm like, I cannot go through this all. Yeah.
Yeah. There was just so much to process. But they'll have they'll have a printed copy of all of the jury instructions and they can
Oh, that
take it.
helps.
Yeah, they can take it one count at a time though. That's I think the key, right? They just start and they say, "Okay, we're going to go." I mean, this isn't how they're going to do it because they're going to get in there and they're going to be like, "Well, let's talk about it. He's guilty." Or, "Well, let's talk about it. He's not guilty." And that's how that's going to go.
Their
But
their
what they
approach their approach might be better though, because if it was a room full of lawyers, how long do you think it would take us just till like we were arguing over, we were just basically arguing over the law because we wouldn't
Oh
get
yeah.
past page 2, man, before we're starting to argue over the nuances of words. I mean,
You'd be
how much?
pulling it out. These jury instructions are actually incorrect.
Yeah, that's
I'm
right.
going to
How much?
take umbrage.
I mean, how much time, for example, did you spend on just the issue of the minor in possession, which is basically a sentence, which incorporates some other things? But how much time do you spend dissecting all that? And now we have 36 pages of stuff that's like that, and I have to dissect this. It's like, who can do this?
Yeah. Well, normal people can because they're
Uh
not
huh.
lawyers.
Oh,
Uh,
that's probably the answer. It's probably why it's good for lawyers not to be on the jury because, like, I don't know how to go through all that. That's so much.
right.
I'm just like self defense, good, which is all
Lawyers
I
go.
need. So maybe I'm better. Maybe I am a reasonable juror. I don't know.
Yeah, because lawyers going through the jury instructions would be like Rain Man going through a supermarket. It's like, all of these words mean the same thing and are worth the same amount. And oh my goodness. Yeah, my dad said to super chat, he says, "Shouldn't the substitute jurors have to watch Roadhouse?" Oh man,
12
take
Angry
me
Men is
off
good. I just see 12 Angry Men's a good movie.
take me
Recommended.
off the jury then. Like I just want to sit and watch Roadhouse all day. That would be good.
Jury Duty. It should be exclusively movies about juries.
Yeah, Dad, wouldn't it be better if it was Runaway Jury that they had to watch all day? Just over and over?
There is one thing I wanted to talk about, which is the one screen, two films effect that we seem to be having with ourselves and some of our brethren over on Twitter, for example. I find it mostly disheartening that we have such divergent perspectives because I try to, as best as I'm able, get outside my own mind and try to look at things from different points of view, sometimes to the annoyance of the chat. But I'm like, I don't know how you guys are getting to where you are, where it's like, well, he's clearly guilty, the judge is a white supremacist and all the rest of it. I just don't understand. I guess it's just so barely clinging to the narrative, but I at least try to put narrative aside, as I have during these analysis, where I'm like, well, suddenly Richard sucks or Richard's is good. So I don't know what to say about that, except it's disheartening, and I want to raise the issue.
Real quick, guys, I will answer it, but I put up a poll, and the options are guilty, not guilty, hung jury, and then a compromise verdict. So someone said, what's the difference between a compromise verdict and not guilty, and a hung jury? A hung jury would be there's no guilt. It'd be a mix of votes on all of the charges. So there's no guilt assigned, but he's not guilty because it's not unanimous. A compromise verdict would be not guilty on most of the charges, but adding one of maybe the lesser included charges to guilt as they compromise on the fact that they want him to be punished for something, but they don't want him to be punished for the full thing. So these are limited options because it's a YouTube poll. There could be tons of different results, like guilty on count one. We'd have permutations of poll results if I tried to do everything. But no, yeah, the one, what did you call it?
One screen, two films.
Yeah, one screen, two films is actually, you know, they have TVs that do that.
Yeah. So maybe it isn't quite the same as it used to be when that phrase was created.
Well, no, because it kind of is.
Maybe
though,
it is.
right?
Maybe exactly that. Maybe
Yeah,
it's even more appropriate.
you have to put on glasses, and basically they use interpolation, and they display on one set of pixels because it's like a 4K TV. You have one set of pixels playing a 1080p version of what you want, and then a 1080p version of what someone else wants. But you put on your glasses, and each one sees a different thing. Because
I saw
it
what
out.
was it? Land Rover had a screen in their car that did it by witchcraft, where it didn't require any special glasses, but somehow because of where you were sitting, you literally could see two different things. So the driver would see GPS, and the passenger could see a movie on the same screen at the same time, just because they're in different positions seating. It's like, okay, there's some witchcraft there.
That's why Land Rovers cost so much. But no, I think. Oh, we've got. Oh boy, they're treating us with a judge right away.
Oh joy! Is it a motion to dismiss so that we can just all go home?
They did file the motion for mistrial yesterday.
Yeah. That'd be nice. Can we all go home now and just end this thing? That'd be great.
I don't think he's going to grant it.
No, he's definitely not. But one can hope.
Oh, turn on the audio. Come on. Oh wait, I have it muted. It's my fault. Although there's still no audio, so
that's okay. Well, we stream strike in 3, 2, 1.
I'm alleviated from fault now that I found out that there wasn't audio. Whoa, Sheriff Feasty has a clone. Do you see him in the back with glasses? What's he doing there? It's his stunt double.
Yeah, there you go.
He needs to go to the bathroom. He's like, you just don't worry. You don't have to stand up and object. It'll be fine. Come on, Court. Get that audio feed up.
Are you sure it was the person sitting at the defense table? Are you sure it wasn't the person in the back row? Dun, dun, dun.
That's I think that was a Chicago lawyer that did that.
Yeah,
right?
It definitely happened once for real.
Yeah, and he put like his assistant who matched the basic physical description of the guy. It was a traffic stop, and he had his assistant. Who's like, it was like the description was like 6 foot tall, brown hair, brown eyes, or whatever. And he noticed his assistant looked about the same, so he had him sit at the counsel table with him. And the defendant was actually in the back of the room. And so then he asked the police officer, "Can you identify the defendant?" He's like, "Yeah." He points to the counsel table, and come on, judge, get on the mic.
He pushed the button. Did he?
Oh my gosh, this is insufferable.
Is long crime failing us?
Let me see if I can get someone else pulled up here.
Well, he's having sound problems too, so I can't be too hard on him this morning.
I can.
All right, fine. Yeah, you with the boomer tech, sure.
Okay. All of the tech issues so far.
Communicate in any way or access any site respecting the case. And
there we go.
Let's take the...
he sounds terrible.
Strike the jurors as necessary. All of the jurors' numbers have been exhibited to the defendant, I believe. And
His
they're
voice
paper
like
clipped together now.
a half octave
please
lower.
Put them in the tumbler. And
The little tumbler.
bailiff will rotate it, and then the
Tumbler.
defendant will draw out.
Oh, the
6
judge
of
has
the
a Tumblr
numbers.
account confirmed.
No, just separate them. And
The little pieces of paper, so it's not the lotto balls. That's annoying.
the names which are drawn out will be the juries who will be dismissed.
Oh, please.
Oh,
Just reach in there. Yeah, reach in there.
oh, do they make the defendant do it?
That's what they said. That's what they said. Oh my god.
Choose your fate.
This
What?
is one of the more bizarre moments I've seen in my life.
I cannot believe it. I gotta tweet that out.
And also, the crinkling noise reminds you of a jail cell. Just so you know, with the oil, it reminds you of this classic sound of a jail opening it up and that. So put that in his head. That's great news. Wow.
Wow.
I've never seen that in any courtroom ever.
That is
Wow.
very strange. I can't believe that you have to pick your own jury. Oh man. What a weird process.
As I call your number, you please stand up.
They are going to do
11.
it. 11.
Number 58.
Shouldn't they have had him draw
Number
a 6
14.
instead of 12?
They
That's
did.
what I
He
would've
did draw
done.
six.
Number
Oh, he did.
45,
Okay.
Number 9, and number 52. And then
You
if
are
you'll
not
follow
the
bailiff
imposter.
into the back room.
You're not sus.
They've been ejected from the airship.
We should have gotten the numbers so we could have tweeted them Lost style. You know, we definitely need those numbers so we could redo the Lost memes with those numbers in place. Damn.
All right, members of the jury, it is for
Everybody
you,
in the chat got a
to
bingo
determine
just
whether
now.
the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count in the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged on one count must not affect your verdict on any other. As I indicated, I think yesterday, that you must return only one verdict for each count of the information.
So who all is buying a lottery ticket on this one?
Did you get to see the drawing?
I did. That's bizarre to me.
If you need to communicate with me while you are in deliberation, please send a note through the bailiff, which is signed by the presiding juror whom you've elected.
I would send the note to the
In the
judge a
event
note.
that you have
Do you like
questions,
me?
I will
Y
talk with
slash
the
N.
attorneys before answering, so it may take some time. You should continue your deliberations while you await an answer. I will answer any questions in writing or orally here in open court.
Oh. The paper rustling
When
is
you agree
brutal.
upon your verdict, have it signed and dated by the presiding juror as to each count, and all of you return with the verdict to the court.
I think the judge does have a cold. He, I mean, he's been indicating sinus issues the whole
You
trial.
solemnly swear that you will keep all persons sworn on this jury together in some private and convenient place, and that you will not speak to them nor permit anyone else to speak to them concerning the state of their deliberations or the verdicts upon which they have agreed to occupy.
Oh, he said bailiff, but it wrote it as Phyllis.
All right, folks, you can retire to consider your verdicts.
Unless that guy's name is Phyllis, I guess I shouldn't, assume. Phyllis the bailiff.
Going back to my earlier topic as well, I'm just waiting for the tweets from whoever, because I don't know this for sure, but maybe it's the case that the numbers he drew are such that it makes it even more white supremacy in nature, and this is just further proof of bias because somehow they they tag the paper or whatever. You know, it's part of the system of white supremacy.
I
Just
mean,
waiting for that little note.
Bingo is white privilege. I mean, that's what happens as you get older as a white person. You eventually, traverse into bingo. I mean, that's how it goes. It's a math formula. A function of X as age approaches infinity.
So
X
it would be
equals
it would be
bingo.
wrong. It would be wrong in the courtroom after they're done to just yell out Yahtzee, right? That would be a bad thing to do.
Almost always a bad idea. But yeah, I'm sure it'll be the oh wait, Corey Shirafisi, he wrote the juror numbers
Excellent.
on the he wrote them on the cards, and Kyle got to pull them out. So we know that they rigged the jury, right? Like we know that happened. He just wrote down only the jurors that they wanted gone on the things. And Kyle knew not to pull duplicates.
Yes, that would be
because he textured
trick.
the paper.
Yeah, that'd be good. No, that's what I'm saying. Yeah, why not mark the paper like a card counter? You know, just slice just the thinnest edge off the edge of the card, like when you literally cut the card, so that you can feel the difference in your hand, like a card mechanic. And then, bingo, bango, you got the jury you want.
God, it would be amazing if they actually sat down and did motion hearings.
Parting, as they say, is such sweet sorrow.
What?
You've been wonderful jurors, and we couldn't have asked for a higher quality jury, better jurors.
I'm sure we could have.
You could. I mean, you could always ask.
And it is, with this. And then when you take them up, you can take that up too.
Tell us about the Bible and juries.
Sometimes in cases you'd recognize by their importance, where jurors have been restored to the jury after having been dismissed. So that is conceivable it would happen in this case. It's not likely, but it's quite unlikely, but it's possible. So I'm going to ask that you continue with the instruction that you not discuss the case with anyone, not even amongst the six of you. You can't deliberate at all or discuss the case in any way. You can't read, watch, or listen to any account of the trial. Did some of you bring laptops? No. Well, I feel badly about that because I had a jury some years ago that was just in a similar situation, and the extra jurors were, all they had to watch was daytime TV, and I'm afraid I can't even arrange that for you. But I don't know, maybe there was something about some movies or something, wasn't there?
We got some recommendations.
Appeal to everyone.
Laura, I don't know. Becky's gone this morning.
The movie lady's out.
Well, anyway, we'll see what we can do to give you some kind of entertainment. And
join us over on Nick
but in the
Rekieta's
meantime, please
Twitch. We'll be watching
adhere to those rules and
watching a movie together.
You will be. We're not going to sequester anybody or anything at this particular point. So, and I hope that they have.
All we have is Anaconda 2. Search for the Blood Orchid.
Any questions?
Sorry.
Yes, ma'am. Yes, in fact, I'm having the bailiff escort you up there now. And while you're there, you're not to have any conversation with the other jurors, okay? Anything else? Okay, fine. Thank you very much. And give those to the jurors, yes.
Mad Max. Liar. That's a good one. Yeah.
What's a great self-defense movie? Just super pro self-defense. Or wrongful conviction movie. Just make them watch Shawshank Redemption over and over.
Shawshank is good. It's a great movie.
Do you really want to put Kyle Rittenhouse through this? Do you want to send him to prison? He's not an accountant.
Or anything
He can't
else now
make it.
before,
Game of Thrones. Time to Kill would be great.
Anything? Stay within 10 minutes from here.
Rambo.
In case there's questions or something. Okay. Thank you.
Man, the chat's got a lot of movie suggestions they could watch. I mean, if they need to source some movies, I think the chat's got them. What about Con Air? You just watch Con Air.
But they have to watch Con Air though.
I know. Why am I getting phone
My cousin
calls?
Vinny. Sure.
Oh God.
We forgot that one. That's sad. So that's unforgivable.
The Punisher. Just, oh yeah. Just Judge
Legally
Dredd.
Blonde. Hmm.
Oh man. Well, I mean, it looks like they're not going to do any motion hearings. I guess the judge is just seems like he'd be efficient, but maybe he's giving the state an opportunity to respond. I wonder how many on a motion for mistrial. I guess the state's going to get, they'd have a week or so to respond, or 2 weeks, maybe.
So what's the final demographics of the jury? They said one of them was a woman. Do we have final demographics? That just might be interesting.
I have no idea.
All right. Well, if anyone happens to know.
Yeah, I never saw like the jury numbers.
Yeah.
There's a report on them somewhere.
Yeah. So while we're waiting for nothing, can we go back to my earlier question of my sadness of the polarization of reality?
Yes, we can. Where were we? Was I talking?
Yes, you were talking.
Okay. I mean, I think the main takeaway from that, and this is something everybody should know, is that lawyers in weird ways, like everybody hates them, but then they get this vaunted status at various times, right? Like suddenly they're imputed with a bunch of authority because we went to school and we learned a lot of words and we learned a lot of history in a particular way. But at the end of the day, they're just people, right? And so they bring their biases and their preconceptions and their political interests and their ignorance, just like everybody else, into a topic that they're not specifically studying. So if a lawyer, knows a whole bunch about a topic that's broad, sure, because maybe they specialize in law around that area, or maybe a lawyer has researched deeply into a particular thing, and we could be pretty good at researching deeply when we need to. Then we might have a lot of facts. But other than that, I mean, you're going to come in with the same preconceptions that you would otherwise, right? Like, just like anybody else. So I think that's a big part of maybe our comrades, and I use that with all of the Russian I can muster over on the Twitter side of things, is that they're bringing in a lot of preconception into this. I'm sure that as busy practicing attorneys, they have probably not watched 60 hours of trial on the subject, and they're getting summaries just like anybody else would. So that's my apologetic answer. If you want my brimstone answer, I can do that.
I'll take brimstone too.
They're a bunch of communists, Kurt. They're a bunch of commies. There's the brimstone answer. Here's the reality.
It's really just that simple. It's really just that simple.
Yes.
It's anything to support the narrative, and whatever supports the narrative, everything else be damned.
Yeah.
Okay. That was the simple answer. Yeah.
I've seen tons of these lawyers out there, purported lawyers. I mean, I don't know any of them, who are out there saying that he's a white supremacist out shooting black people. And it's like, the only black person around involved in the shootings, he missed. And I like to think that was him being consciously not racist at that point. He's like, oh God, I can't shoot this guy, right? Like, that would be bad. I can only shoot the white guys. I'm joking, of course, but no, I mean, there are people who've been running the false narrative. There are people who suggested that the gun charge was not only like a proper charge, but that he was surefire guilty of the gun charge from the get-go. No question. Like, you could propose the alternative reading to them, and they would never even consider the possibility that what the law said was what the law said. It must have meant, and you'd say, but it's kind of weird to impose hunting regulations on someone who isn't tagging a deer. Like, that's a strange thing to do. And they'd be like, nope.
Well, I did like where you tweeted out yesterday. Was it PolitiFact of Wisconsin or something had at some earlier point said that he was in legal possession was just false. And then you tweet yesterday, it's like, well, that held up well. It's like, we actually did some legal analysis.
Yeah, it was like, and that was the thing. These a lot of news outlets who have lawyers on staff to handle to help them with these things. They apparently didn't read the law. And when they wrote their articles, they never mitigated with the possibility of, and because that was a confusing law. It's a very confusing law. It's confusing to the judge who's been practicing law in some way, shape, or form for 44 years or whatever. And he's like, I don't even want to tell you how much time I've spent thinking about and trying to think through this law. It's very confusing. And so, you can give a mitigating idea of it. You could give that. And maybe as self-reflective, maybe I didn't mitigate enough, but I think that I was pretty fair when we got to trial to say, you know what, if the jury instruction is under 18 and deadly, a dangerous weapon, he's going to be guilty. Of course he is. But we have this exception. And I still don't think the exception's an affirmative defense. I mean,
that doesn't
weird
make any
to me.
sense. It doesn't make any sense. That's an
But,
affirmative defense.
But maybe that's how Wisconsin does statutory interpretations on criminal laws.
Fair, maybe it is.
And if that's the case, I just don't know. But to me, it seems like an exception written into the law is a matter of law to determine. And they could have just picked up the gun and measured it when they got it. They could have measured the barrel length, because they never asserted in their complaint or anything that this was a short barrel rifle. That was actually, it was a little incorrect of the judge, in my opinion, because he said, as pled, there's probable cause. But the pleading should require it to be a short barrel rifle, right? Like that should have been necessary for the pleading of a 17 against a 17-year-old. Now, if they had said he was 15 at the time that he possessed it, different story. But since he's 17, pleading should have included short barrel rifle. So he should have dismissed it outright. Even based on probable cause standards.
The chat is saying seven women, 5 men, and 1 person of color in there. So that means 11 white. So at least it's not an all white jury. So we got that going for us.
Oh, well, yeah, I'm sure the token narrative isn't coming.
Isn't it kind of insulting from their
about
point
that.
of view to call that guy a token? I mean, because they're dismissing him and lowering him.
Testing.
Yes, you're here.
Yeah, you're here,
Oh,
buddy.
good. Sorry, I
We were just ignoring you for a second. Sorry.
I've been having audio problems for the last couple of days, so
Well, that's okay. No, that hasn't happened to anyone else on the panel.
I was just, there's already articles about, there's only one black guy on the panel, and I'm like, if Kyle had managed to, by it's random chance, but if he'd drawn that guy to send off, they would have been just freaking out.
Oh,
Kyle intentionally gets the one black juror off the panel, would have been just
That's what we were saying earlier. Since Sherfisi put the numbers in the tumbler and Kyle drew them out, there would have been some accusation like, oh, the black guy had a textured card or whatever, right? Or the black woman. I don't know. Person of color doesn't actually particularly describe anything. So I'm jumping to a conclusion by saying black, and I shouldn't jump to conclusions. I should walk there slowly.
You're good.
Let me get a couple of these big super chats real quick.
You can go full screen since we're watching nothing as well, too, by the way.
Yes.
And I'm mostly in court today, so I'm probably going to be.
Yeah, I'm going to have to
popping
bounce out in a minute. I just want to pop in for the drawing, which I'm glad I didn't miss.
Yeah, I just wanted to pop in and be like, "What the hell?"
To the wonderful chat, you're going to be stuck with me for probably some long stretches today as everybody else catches up on their week. But Britt Cormeyer says polarization of reality is 100% due to the media, both social and historic. When you only report the points that support your story or only see those reports, we cannot agree on facts. I think that's apt. James says free Kyle. And PZP says in their closing, why were Binger and Krause allowed to lie about what written law states? Does anyone want to tackle this one? The answer is simple.
Objection.
The defense has to object if they want to address the issue. And strategically, I think we got a lot of insight into Richards's mind when he said, we've had nothing to hide. They had Kyle turn his phone over without a search warrant. Or not with, they had him turn over the password to his phone when the police were unable to access the data on the phone. They had him turn over the password. They had him testify in court. They've really held off on objections. They have they've been extremely permissive with the evidence. And I mean, they're phrasing that as they've been open and have nothing to hide. And so maybe it's that rather than laziness on the objections, but that's how they've done it. And if they just didn't want to quibble over this stuff because they think their case is strong, it's a strategy. I don't
It's
know
a bold
that
plan, Cotton.
Yeah, I'm not sure I that I fully agree with that. I think matters of law that are misstated by the prosecution are just ripe for calling out. Your Honor, he's lying about the law. He's lying about what the law actually is. It just and then let the court overrule the objection, but with a clarifying instruction, to say, okay, you should be instructed that this is what the law actually is. And
It's Richard Hogue.
Yeah,
And,
hi, gentlemen. I think I could only pop in for about an hour or so, but I figured I'd say hi.
Did you get to
Yeah,
see the
welcome.
Tumblr? Did you get to see the Tumblr of Destiny?
I saw the picture that was sent out. I can't believe they have him do that himself.
It was fun.
All right,
Yeah,
I got to
it's
pop
wild.
out again here, but I'll be watching.
Yeah, welcome. Anytime you want to pop back on, go
I
ahead.
might as well pop out too. It can be you and Richard. Richard doesn't get enough airtime. Let's hear from Richard
I
for a
popped
while.
in and everybody left. Okay.
Well, thanks for clearing out the panel, Richard. It was getting dusty.
Well, I can see they love me. No,
How you doing?
I saw you all talking, and like I said, yeah, I think I've got a noon call I got to prep for. But for right now, I thought I'd pop in and chat. I don't even know what you're talking about. They're just going to be silent for hours now, right?
Yes, I have a plan, and the plan will probably get it might get boring for some people, but I have a bunch of super chats. I've got a
Oh, sure.
backlog of them that I'm going to read through at some point because I assume I'm going to be alone for a significant portion of today is my guess. So I'll be doing some of that and answering questions as I'm able to. But while I have people, I want to discuss things. Oh, hey, look at this. Look at this. Not everybody is disgusted with you.
Like we're in tiers. We come in twos.
Yes, perfect. What's up, Joe?
I'm great. How you doing?
Oh man, I'm good. I'm good. It was weird seeing my name pop up in like Breitbart talking about the and on InfoWars talking about the shutdown by YouTube
Really?
yesterday.
Oh,
I'd
So-
seen that Tucker Carlson referenced you, not mentioning my name.
Well, he
And-
couldn't have
When
been
YouTube
talking
cut us
about
off?
he couldn't have been talking about our show because he said it was legal experts with hundreds of viewers. I
Yeah,
was like, hundreds?
well, it's thousands of hundreds. You know,
Yeah.
it was-
77,000 of them, but it
at
was
the
cool.
time of the shutdown, I actually had looked at our numbers like relatively right before that. At the time of the shutdown, we were not just the number one, but we had more viewers than Fox and PBS combined. And I think I
Yeah.
even made a comment about that. So
Yeah,
yes,
we
that's
were
why I sent
crushing.
the correction on that. Yeah, we were really, really crushing, and I do think that we would have broken 100 if we didn't have that ridiculous.
now I
disruption.
understand the reporting on that. I mean, do you think that this was a deliberate attack or an error?
From what I heard, it was an accident. Team YouTube has not gotten back to me yet on Twitter or or via email.
Now you have enough subscribers that you've got a person at YouTube, right? That should be getting back to you.
Yeah, I'm waiting for them. Now, I want to say my person tends to try to fully investigate things
Sure,
and
sure.
bring me a good answer. So I wasn't expecting a response from them yesterday. But Team YouTube on Twitter, despite being tweeted at by about 1,000 people and me DMing them, and I have an open DM thread with them from a prior issue, they still have not responded. And I mean, they respond with relative frequency to people.
On Twitter, yeah.
Yeah, and so I don't know that it was an accident, but I do find it pretty suspicious that the PBS stream that was trailing behind us seems to be the source of the accidental copyright match, and but I don't know that they actually asked for it. I'm
Right.
trying to get info on that. Because boy, would I love to report that PBS actually asked for all independent people to do it. But see, the crazy thing is, like, Law and Crime got shut down too.
Yeah, no, it was
And
simultaneous across the board, right?
yeah, and to have Law and Crime shut down when they're I guess maybe they're on PBS's feed. I'm not sure where. Like,
Are
I'm
those
not sure.
PBS cameras the ones? Are they owned by PBS that are doing that broadcast?
I don't know. I
Yeah.
honestly have no idea because all the camera angles appear to be they appear to be sourcing the same cameras on basically every source I've found. The one difference I saw was that during the autopsy photos, PBS was not actually switching to the autopsy feed, but some
Okay.
other places were. So I'm not sure where it came from, but to suggest that there's a strong copyright interest in the bland reporting of factual information is factual public information like this is suspicious.
That's a
I
public
mean,
government function. I that's why I asked whether they were PBS cameras, because you could at least make the colorable claim that that's our view of the public
our guy
hearing.
framed it. Yeah.
Yeah,
Framed the shot.
but no, if it's not, if it's the if it's a court system, it's not even close.
Oh, it's all from Court TV, actually, apparently.
Yeah.
So they're the only cameras allowed in the courtroom, is what I just saw from the chat from Mr. Joey Camp 2020.
See, I'm a
So-
benefit of the doubt guy. It's like, oh, that's unusual, but I stop before jumping to the full on attacks. But it certainly did. If it was an attack, that's how it would look.
The reason that I think there may have been, and again, I don't know who the party might be, but some hand in doing that
Yeah.
is the frustrating difficulty that many viewers have expressed in finding this live stream in
In
search.
searching for you, if they know your name and they know you're doing this.
There are videos out there of people typing Rekieta Rittenhouse trial and not getting any videos of the Rittenhouse coverage that I've done, and not getting the active live streams, but rather getting getting the mainstream sort of sources for it. And it's like, if you type in Rekieta Rittenhouse, that should pop. I mean, should be the top result. There's no question that should be the number one result, especially with the amount of viewership that's going on. It's not like I'm streaming to one person.
You don't have a
It's like-
common name. It's a subject
Yeah.
matter. No, I agree.
It's not
So-
just that. It should be that if you put in Rittenhouse trial live,
Right.
and you had enter while he literally has more people watching him than any other YouTube channel, and he's not on the list anywhere. You will get I scroll down 50 spots, PBS is there, Fox is there, Yahoo's
You
there.
get old videos rather than live videos.
And you'll start getting older videos, and he'll be sitting there with 66,000 people watching him, and you'll get Yahoo News with their 12,000, and then you'll get PBS obviously and Fox, but yeah, and when you scroll down, you'll just get old stuff from PBS or Good Morning America. Like, well, you just get weird things, and you won't get him, and that's just that's insanity.
And the fact that there are even other non-news source YouTubers with smaller live watchers that get ranked far above.
Non-authoritative under
right.
the YouTube vernacular.
Right. And it's like, look, I don't need to be authoritative on everything, but on this, like this particular live stream series is like the most authoritative coverage I can think of. But I know YouTube qualifies authoritative as quote unquote trusted media sources,
As in having
basically.
a network. Yeah.
Yeah. But it's just like, so when I see those things combined, and when I factor in one other aspect that I think you might appreciate, early on in my YouTube career, I might have had 10,000 subscribers at the time. I was covering the James Damore class action lawsuit against Google.
Sure.
And
Don't use the word Google. I know that.
It took about 2 years for my Google search page results to stop being artificially controlled. we'll say. And I was getting Google engineers were actually sending me screenshots of the Google internal communications about, because they have their internal version of Hangouts that they were using at the time.
Yeah. Yeah.
And so they were sending me screenshots about, you know, Google employees asking for my bar number and discussing me with and it's like, this video has like 2,000 views. Like, these are not huge
yeah,
videos.
what are you doing? Well, I know I can appreciate that. When I
yeah.
started out, especially, I do, you know, virtual legality has a lot of overlap with tech. So we talk about YouTube and Facebook and Twitter and Twitch. And honestly, they've been in the news for a number of good reasons about whether or not they're doing the right things with their algorithms and whatnot. And I learned very quickly. Well, I learned very quickly that if you use the word YouTube in the first, you know, sentence of your description or the title or Google, that one's going to get dinged. I would get demonetized to start on all of those, regardless. You know, I'm a lawyer talking about news items in that series, and I you know, there is a real kind of chilling effect towards, do I want to even talk about this particular YouTube concept because I don't know exactly what's going to happen. And as a matter of fact, you know, it was earlier, I think it was earlier this year, it's been a long year, that YouTube wound up giving me a strike, a warning strike, because it was the first one or whatever, on a video that was a year old, that was about the way algorithms were treating, in this particular case, Q and subscriptions and things. And it wasn't about anything except the legalities of it and the terms and conditions and things like that.
Yep.
I got struck because I said the phrase right in the video. And I made another video. I said, this is ridiculous, because they put up a thing that says, you know, you're in violation of our cyberbullying and harassment policies. And you could tell immediately at the time that the channel got depressed, chapters wouldn't work, all these various things. I'm not even sure if I'm not on a list just from that fake strike from a year ago.
Yeah.
And it's wild to have to deal with, because obviously, you know, the audience is here, the audience is interested. And I'm not looking to pick fights, but, you know, play fair.
No, and yeah, it's a thing. For me, one of the weird, and this is me half complaining. So let me qualify this.
You can vent a little.
No, last year was at the time my biggest year on YouTube. I mean, from revenue and everything, last year was a great year. It was bigger than the previous year, which was bigger than the previous year. So that's the good growth trajectory that you want. And so I'm not complaining about income or anything from last year, but what I will complain about is there was a specific day where my view counts from one day to the next, without me, I didn't do something stupid, right? But my view count was cut in half. My live viewers were cut in half.
Yep.
And then it was about 8 weeks later that another cut happened. And I went from a nightly viewership of 4,500 people to then like 2,400 people, and then down to about 1,200 people. And I really had to like work to build that back up. And it was just, and it happened in 2 distinct overnight incidents. It's like, what the heck happened? And from then on, I would start getting people who would report they were being unsubscribed.
Yeah,
while watching. Yeah. And so it's like, okay, that part of it was so frustrating to have to fight against. And it's like, all I want is just play, like you said, just play fair. Just play. Like, I don't need special treatment. I just want to show up like everybody else. I just want to come out here and say my thing. I didn't get any strikes until this year. My first strike was covering, or my warning strike was, I was watching Joe Biden talk about do a speech on vaccines, right? And I agreed with Joe Biden, and I got a strike
for using the content.
No, it was misinformation on vaccines, because he had said something about how they, you know, how the virus affects children, and I said, yeah, actually, they've known for a long time that this is specifically how the virus affects children. And I agree with this change. I agree with this policy change. And then they struck it, and I was like, what the hell? Like, I'm agreeing.
No, I hear
you. I'm on the side. I'm with you. But yeah,
well,
so
that's a particular hot button for YouTube.
Yeah,
I
But
got I got my notice and my strike because of just mentioning the two words, like about the M word about rules and and COVID. I put that in a sentence together, and yeah,
the
I'll be off the air for 2
You
weeks.
got to be
the
careful about the words. I mean, and that is chilling in and of itself. And you know, in my
right.
naivete, when I started this, whatever, 3 years ago, I thought, well, you know, if there are more viewers and there are more ads and they're making more money, then you know, businesses are businesses, right? And the ordinary incentives there is, oh yeah, you keep pumping the things that people like that get 95, 98% likes and are engaging with the content, and that'll grow. And it's just a little bit weirder than that. It certainly is.
Well,
Yeah.
I
Well,
would agree
the
with you. I'm sorry, you go, Nick. I had cut you up before.
no, you're on his point. I'm gonna go back to something. So you go ahead.
Okay. When you say businesses are businesses, I
Yeah, they
agree
want
with
money.
you. Yeah. But here's part of the calculus that I think you might be missing, particularly on this issue when it comes to the the disinformation, when it comes to treatments for the current for the pandemic that we've been dealing with for the last, I don't know, year and a half or so. And that is, big pharma gives tons of money to all mainstream media, to big tech, etc. So yeah, okay, fine. They like to get an extra. They like to put out your content, and you can. But the content that you're putting out there, and whatever you're putting out there, there's no way whatever revenues you can get that will be a tiny, tiny fraction of what they are literally being paid directly by big pharma.
Right.
So
And I don't think you have to limit it to any given lobbying group. I agree with you that they have a number of other financial incentives that are in play. I'm admitting, and I'm agreeing with you that you're right, that those incentives clearly come into play, whether it's cultural, whether it's financial. But that when I started this, you know, I'm a transactions guy. This is
mm,
how business works. This is, if we're rowing in the same direction, you know, you're going to be in a general okay with whatever the rules are set at. And I am still, obviously, I'm still doing YouTube videos, but I was surprised to see how much bumpiness, and you could, even at low levels of subscribership or viewership, you could see it. You could
Yep.
see, oh, the thumb has been pressed down on this right now, on how those curves worked, and you're like, huh. And that's continued to be of interest to me, not because it affects me even necessarily, but because I do find it interesting, especially in the current regulatory environment and legal environment, to look at that and say, they're playing with fire on some of this stuff. They're encouraging, you know, a lot of the stuff that's happening on a regulatory side, and I think it's interesting.
Yeah, it's wild. The main reason I was bringing up the strikes though was just to say that when all of the stuff started with the apparent shadow banning and all of that stuff, my account was completely like squeaky clean. Never gotten a
Yeah.
strike, you know, none of that. So it wasn't like now I'm like, oh well, I have an active community guideline strike on my channel. Maybe that's affecting things. And you have no idea.
I
And
don't.
the crazy,
I got the warning strike. I got it rescinded. I don't
oh,
know
you
whether
did?
that still doesn't count somewhere in some database. You know.
Yeah, you're lucky that you got that rescinded. They would not rescind mine. That stays on your account literally forever.
Yeah, you lost your
And
warning essentially.
yeah. And like you said, I have a partner manager, and I was talking to them about that strike, and I was like, this is really unfair because I'm agreeing. I'm with the authority on this point that you're saying that I'm doing misinformation on, and I don't know how to talk about this when I can't even agree with the authority. Like, so that's weird, but they would not remove it.
the most
John, oh, go
I'm
ahead.
sorry. No, the most frustrating thing, it's not and it's not how they depress the algorithms. It's the cloak and dagger element and the constantly shifting rules.
Mhm.
So I don't know if your audience here can fully appreciate. I go out and I make a live stream. Whatever rules I was governed by 2 days ago can be completely different as far as what words I can say, what words I cannot say, and the punishments are so severe. I mean, there you literally can, someone who's making their money off of creating daily content on YouTube. It's like they'll shut you down for, well, you already have that black letter on you, that warning you got 2 years ago. Well, now you're shut down for a week. And careful, because if you make another mistake anytime in the next 3 months, you'll be shut down for 2 weeks. And
Yeah,
God
and the
forbid,
borders aren't clear. The lines aren't
and
clear.
yeah, and
Yeah,
and they
absolutely.
won't tell you what the rules are. So you're totally guessing, especially when you're talking about controversial issues, which someone like us, I'm every day what I'm saying is going to be something that I know is going to be controversial to someone, and
Well, that's because you're hateful, Joe.
I'm not hateful. I'm not hateful. I just push back. But yeah, I know that I'm gonna be pushing boundaries and I have no idea what the rules are, not because I would love to see rules. And if you want to change the rules every day, at least give us notifications about the change in
Yeah,
the
let us
playbook.
know what they are. Well, and the thing that I don't like is that warning. As Nick knows here, you get that warning. It's so condescending. The communication they send you is like,
Oh.
well,
Yeah.
you might not realize that about these rules and these rules, but you're a cyberbully. Was mine. I'm like, are you freaking kidding me? So I made a video. I made a fairly passionate video about, no, you can't put public billboards up when someone looks for this video that tells them that Rick Hogue is a cyberbully and harasser. So let's talk about
Yeah.
it, YouTube.
I got one of my strikes that was mistakenly issued. They said, and it was taken. I got it taken away, but the strike email that I got was for some copyright violation. And again, I was streaming. I was streaming a congressional hearing.
Yeah.
Right. So I'm streaming a congressional hearing. Super fun to do those, and I suddenly get a copyright strike, or not a copyright strike, but the stream was taken down for copyright, and they issued a policy violation strike, which was weird. But what the stream said when you clicked on it was that this was taken down for a different policy violation. Like it was it might have been cyberbullying even, and harassment, which I don't remember. But I was like, wait a minute, the email you got says that it's a copyright thing, and then you're telling the world that I
Yeah,
violated.
You can't publicize that. No, yeah,
Right.
and that's where I got. I would love
Well,
to have a copy of the message that I sent in the little box they give you, because I'm sure it was full lawyer, where I was like, you can't declaim to the world this, YouTube. You've
Well,
got to be you're killing me.
That's what happened with, and I know this guy is very polarizing, but his polarizing people bring up interesting legal scenarios. Owen Benjamin got thrown off of Patreon, and what Patreon did allegedly, and I'm pretty sure this is true, they communicated to people, and this is a similar theory to what Project Veritas is going through with, I think, YouTube as well, or someone else, but they communicated to hundreds of his patrons that he had engaged in a community guidelines violation of some sort that was not true. And so they actually brought Patreon to arbitration. And gosh, I think they might still be in it. I'm not sure. But they brought them to binding arbitration. And
About the
I shouldn't say they did. The interesting thing is they got a bunch of patrons to bring arbitrations individually against Patreon for violation, basically for tortious interference. Because they said, you're interfering with this contract, and Patreon has specific language that says you don't have a contract with Patreon, you have a contract with the creator.
We're a platform. It's between the two of you. Yeah.
Right. And so they said you're in tortious interference, and they brought since California implemented the no class action arbitration rule, or the disclaimable class action arbitration rule, they brought 100 arbitrations, and suddenly Patreon got stuck with a bill from Jams for, I think, $2 million just at the outset. And then they tried to like consolidate all of them into one, and Jam said, no, you said you weren't going to be able to do that in your contract. We're holding you to it. And so Patreon's bill on that issue of throwing Owen Benjamin off is, I think, somewhere north of $5 million so far.
And I think I did a video in Virtual Legality on that, because people were asking me about whether Dr. Disrespect's crew could pull that off with Twitch. So we analyzed the Twitch contract, saw the same setup as Patreon. And it had the arbitration, it had the no class action, it had the we'll pay first, as is the rules for small claims in that arbitration rules. And I said, well, they appear to be in, I think, what I call the Patreon uncomfortability zone.
Yeah. And to the chat, not Carl Benjamin. He didn't bring the Owen Benjamin. the comedian. Owen Benjamin and Vox Day were working together, I believe, on a project or something like that. Carl Benjamin is Sargon of Akkad. Different Benjamins. Carl had explored the idea, and I believe it was modeled on the same concept that Owen and Vox had established. Again, very, very controversial people, I know, but controversial people tend to be interesting. So we got to talk about
that's right.
about them. But
I just found that Breitbart article. That is some genuine love they showed you. Oh my God, that is great.
yeah, it was cool.
They literally. I mean, I didn't realize that that Posobiec had put you out there to by name as far as what
famous.
YouTube had done. But did you see this article, Richard?
No, I haven't.
It's full-throated fellatio. It's really. It's really.
It's why it took me so long to wake up this morning. No, it's, it's very tired.
It's really, and you know what?
No,
and
it was.
God bless.
It's very cool. It's very cool, and the main thing is, Breitbart they've been covering topics like this forever, and we see this, right? We see certain publications once they are. If you're not inside the corporate media power structure, that's the one big advantage that Fox News has, is they're still sort of inside, and they still have one of the major news wires, right? Fox is one of the major news wires along with Reuters and Associated Press. And so mainstream media kind of needs that Fox News wire, even if they don't like the Fox News commentary that comes with it. But when you're outside, when you're a Breitbart, when you're a Project Veritas, when you're a PJ Media or something like that, you know exactly how quickly they can go after you and what kind of damage they can do to a business you've been building. So it's great to see that, and I think that's one place we as creators, and I'm not even going to get into the political divide on this because I don't think it's a left-right issue. That's where we need to be kind of united in the let's support more speech, not less.
No, I couldn't agree with you
thing.
more on that. I think that's where people get tripped up. Yeah, absolutely. Both sides get more voices, get more perspectives. Not all of them are going to be right, but you have that discussion. You're going to be able to triangulate and figure out and synthesize better than if everybody's just chirping the same thing in your ear. Absolutely.
Yeah. Let me read a couple more of these chats. John Myers says, when I was watching on my phone yesterday and I would pause the stream to do something and then open back up the app and hit play, it would be somehow now streaming from a mainstream news site. Saw a couple people with that issue. I don't know how it would happen, but yeah, some people were getting, someone reported getting switched over to, I think it was to PBS. They
Could it have been
were
when
watching
we were shut
here.
down?
I don't know, because when you were on, if you clicked on the stream, it would actually just bring up the splash page of this. This has been blocked for a copyright
That's what
issue.
I saw.
So
Okay.
I don't know that it would autoplay, but who knows? I used to have this issue with YouTube, and they fixed it, thank God. But something would happen like an hour and a half into my streams, and it would like glitch, play an ad, and then autoplay to the next thing. It happened for like a week or two, and it would just like people would get just launched off of the thing. I would go from like 1,500 viewers to literally 200.
Oh, that little graph would just be a down line.
Yeah, and it was like, and on my end it was smooth, but something would happen. Ryan Long says, I don't think it's that Ryan Long. By the way, big shout out to Ryan Long Comedy. That guy's hilarious.
Awesome.
He says, can you go over the law? It seems like 3C negates the entire law. I'm not a lawyer, but a crime scientist, but the idea of sections is weird. So 3 references something, but I can't reference itself since there are no nouns or objects in it. Okay, so
he's talking about the possession.
Yes. Do we want to pull it up and talk
Yes,
through
I think
it?
that would be useful.
Okay.
To show people what the heck we're talking about.
Yeah, let me pull up the statute.
I could certainly preface it by saying that 3C, everybody having a problem with it, makes total sense to me because it's written bizarrely.
Yes, it's terrible. It is a terribly written law.
And ordinarily, in a good written statute, you'd also probably have something like a subject to the exception put forth, so that you don't just read the early sentence that says this is prohibited, because frankly, a lot of people don't have the attention span to go and figure out that statute, especially legislatures. So it just wasn't written very well.
It was not. I'm trying to find. Oh, minor in possession of
I
dangerous.
had all
weapon.
these tabs up yesterday, Nick.
I've looked at this thing so many times. Here we go. Possession of a dangerous weapon by persons under 18, 948.60, and I will bring it up on screen here. And yeah, we can go through it real quick. I've done a whole video on this, but we'll just go through it now. I'm
right
also
back.
gonna.
You keep going.
I gotta send. I am just a second. I gotta send an invite to a good friend, Mr. Eric Hunley. He is not a lawyer, but he's a wise and sharp individual, and I would love to have his input on some of this stuff.
I was just tuning in when I heard your nice talk about lawyers are just people that bring their own views. I like to say on my channel, if you get 3 lawyers talking about this issue that I'm talking to you about right now, you'll get 3 at least marginally different answers. So have other sources.
It's one of the things that bothers me most about the law. Law Twitter is an unfair term because there's a bunch of people who are
I'm
affiliated with right, and they have. I have a particular group, subset of Law Twitter people that really, really hate me, and that's fine. I agree with them on hating me. It's good, but
I got a few DMs for being on your stream, Nick.
But that's the thing about it is there's a subset of Law Twitter that pretends that and I don't understand this, that lawyers have uniform thought and that a consensus of lawyers is somehow like authoritative in some way. And it's like, wait, but a ton of law has been changed over the years because one small group of lawyers or even one lawyer said, no, I read it this way, and then argued about it and convinced, all the way up to the Supreme Court to actually say things are different. And so lawyers should be used to disagreement. And I think projecting the image that there's a consensus on something and that is a valid claim is dangerous in our profession.
Yeah, there's a need for some, I think, to really feel authoritative. And to me, it's just my personality type, though. I think I always feel very cautious about people looking to me and thinking that I have some kind of voice of God on X, Y, or Z. So I always try to bring those sources in. I always try to talk about what the words say. And then I try to mention, hey, you could interpret it this way. I mean, I think even with the problems that folks are having with 3C, I don't think the state is crazy to say, well, that blows up the whole sentence. It's like, yeah, that's right. And then there's different legal philosophies about, okay, should we save that from the legislature's idiocy or should we not? And I agree with what the judge did here. I agree with what the ultimate ruling was, but you do look at this and say, they couldn't have meant that, could they?
Yeah, the way I think they meant what the judge came to the conclusion of. I think they worded it very poorly.
Okay.
Because and my basis of this is this law was changed most recently, I think in like 1992. This section was changed and added. And my understanding of this is that they were attempting to control handgun issues in the major cities. Basically,
and they want to be very careful to not affect hunting. I mean, I think that's clear.
Yeah. So let's take a look at it. So we've got in this section, dangerous weapon means any firearm, loaded or unloaded. So I think we can skip the rest of paragraph 1 because if we're contextualizing in this case, yep, firearm's a dangerous weapon. So then we go to section 2. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor.
And that's where people stop.
Right. It's a very straightforward statute. It's basically strict liability. If you are in possession of this or goes armed, so either one, if you have it, possession doesn't necessarily mean you're holding it. It means you have ready primary access to it is the best way to describe it. If you're in your house and there's drugs on the kitchen table, you're in possession of the drugs. Long story short, under the eyes of the law. Now, if the drugs are in your roommate's locked safe, you're probably not in possession of those drugs, even if you're in the same house. So that's why they have possession or going armed. So if you're out carrying it around, they want to have that clear language in there. So then the next section is just different classes of felony. We don't B, C, and D. So we don't really need to go into that. Kyle's not under 17 for D, so we can move straight on to 3A. So the section does not apply to a person under 18 years of age who possesses or is armed with a dangerous weapon when the dangerous weapon is being used in target practice under the supervision of an adult, or in a course of instruction in the traditional and proper use of the dangerous weapon under the supervision of an adult. This is why
the range.
Right. And this is why Dominic Black and Kyle were able to go out and shoot on the range. Dominic Black is 18. We can infer, at least because he was the one who purchased the gun. So they could go out to the range, and he is an adult and can technically supervise his best friend, even though he's just several months younger than him. The section does not apply to an adult who transfers a dangerous weapon to a person under 18 for use only in target practice. So the same thing. Here, you can use this gun so we can target shoot. So next, 3B. The section does not apply to a person under 18 years of age who is a member of the armed forces or National Guard and who possesses or is armed with a dangerous weapon in the line of duty. Same thing with an adult transferring it to someone in the armed forces. Right. So long as you're in the line of duty. So military exemption, because some people can join at 17.
Neither of which apply to Kyle in Kenosha on the night in question.
Correct. So we can go ahead and ignore that section for this one. And then we get to the critical one, 3C. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28.
That's the short barrel.
Right. And this is the big, Corey Shurafisi made a big deal over that is not in compliance with sections 29304 and 29593.
It's funny. I think the big deal lives in that and.
Right.
Yes.
Yeah. And for some people, it does. So so 241 or 941.28 is a section about short barrels. 29304 is under 16 is an under 16 hunting statute.
Yeah, these are both hunting regulations.
Right. So 29304 basically says if you're under 16, here's a list of things that you have to do. And then 29593 is a general list for all minors related to hunting. And that's where the big confusion comes in with that and. So Corey Shurafisi says that the or is a full stop after 941.28. So if you're under 18, short barrel rifle, short barrel shotgun is a hard stop. The next section, he then argues, only applies if you're under 16 because it requires compliance with both of those statutes, which would then say that even though the second statute is not age specific, that it relegates that second statute subject to the first statute, which is age specific.
And Kyle can't be out of compliance with a statute that doesn't apply to him by age.
Right. So the argument or the basic conclusion is that this law does not apply to a 16 or 17-year-old who is not hunting. Or no, actually it does not apply to a 16 or 17-year-old, full stop. So long as their rifle,
you'll never collect the other statute.
Right. So long as they are not in violation by having a short barrel rifle or a short barreled shotgun.
Which philosophically, and I agree with that interpretation, but philosophically you can understand how the state or anyone else looks at this and says, nobody on earth would write this that way if they intended for this to not apply to 16 and 17-year-olds.
They would just write this doesn't apply to 16 or 17-year-olds, right?
Yeah, I mean, there's a certain amount of programming language in legislation. I mean, that's how I talk about it on my channel, which is that, yeah, you can get certain savings clauses from courts, especially if they want to be more active or not. But for the most part, you write this, you pass it, and then you figure out what it does, what the command line actually winds up doing. And you read through all this and I say, yeah, you have to be out of compliance with both of those statutes. The first one doesn't apply to you at all. You can't be out of compliance with it. And so you're good.
Yeah, and so the idea of why you write a statute in this way, if we're being deferential in saying that the
Yeah.
legislature planned it this way, the main reason is to talk about what I was discussing earlier. If you've got in particular, if you're trying to address in the early 90s gang violence in metro areas of Wisconsin, Eau Claire, Green Bay, what's the other one? Milwaukee. If you're trying to address that type of violence and you don't see a lot of long barrel rifles in the 90s, probably in part because I believe at that time we were either flirting with or we had the assault weapons ban of the Clinton era, right? And so you actually have less access to those types of weapons in the early 90s than you do today. And so maybe they didn't think it was as big of a deal to address those. But you do have a handgun problem in the 90s. Going up, I think 1996 was one of the peak crime years in U.S. history, and especially for gun violence. So we're leading up to that. So that if they're trying to address handguns, and then if you look at the other dangerous weapons, you're talking about brass knuckles, you're talking about nunchucks, you've got
Two sticks of wood.
cestus. Yeah, you've got a cestus, which would be some sort of knuckle blade, or similar material weighted with metal or other substance borne on the hand.
A shuriken.
Shurikens. You got throwing stars.
This is what your legislatures are writing, by the way. Just so we're clear, this is not a unique set of things to randomly find.
This is my favorite word in a Wisconsin statute. A Manriki Gasari, which is, I think, in English, a meteor hammer, basically. You've got a chain with a weight on the end of it, and you're Jackie Chan. You're like, spinning this thing around like a monster.
I want the background. I want the behind the scenes of how this particular list was arrived at. And whether
Yeah,
they were fighting over this, whether they watched ninja movies. I don't know what was happening.
You can imagine the legislative aide who's helping write the dangerous weapons statute cracking his knuckles and saying, "Yes, sir, I am somewhat of a weapons expert."
I want you to watch The Warriors and just name everything they use, please.
But oh my goodness. But I'm surprised that a dangerous weapon is not what they don't have in here is actually kind of shocking, right? They don't have like a knife with a blade length over 7 inches, for example. They don't
really have any knife references, do they?
No. They don't have a switchblade, which the switchblade may be illegal in some other section of the statute.
That's right.
But I'm actually surprised that a knife with a blade length or a double-sided knife is not listed in this statute specifically. Because that could, in a lot of states, those would be classified as dangerous weapons. And I think in Minnesota, there's a certain knife length that you need a permit to carry above that knife length, in public. So, but yeah, so if you're trying to deal with violence that is more likely a result of a gang type scenario, you can write a statute in this way that deals with mainly handguns and some sort of melee weapons that are out there, concealable melee weapons like brass knuckles, awesome melee weapons like nunchucks, and really address that problem without infringing on hunting, without infringing on a kid on his own property, with a gun. Because mere possession is enough. So a kid's got, his rifle on a rack, in his room. Kid's got a rifle in the rifle or a shotgun sitting in the gun rack of his truck. Very common in the Midwest. In fact, it's taken them a long time to get around people bringing rifles to school because they would go hunting after school. Now you basically have to keep those in your trunk and not tell anybody. But not all that long ago, a rifle in Texas, still a rifle on the back window of your truck would be a common thing.
Well, and I think that might be something that's lost culturally, depending on where you live or not. I've been in Michigan for roughly my whole life, and throughout my youth, you would absolutely have hunting season day starts as almost a holiday. A lot of the kids would go out with their dad or their parents, and that's exactly what the parking lot would look like. And so, you do have different approaches. I am I got to be honest with you. I think I always ever read this statute and just stopped at firearm because I was done. That is an amusing set of weapons listed in that first paragraph.
I would have never read 3C except for this specific, like when I was diving into this issue going, okay, because I wanted to know, right? Did this kid illegally bring a gun? Did he,
Yeah.
did he grab a firearm that he shouldn't have? So I did a deep dive into the statute right away. And I was like, no, I don't think so. That's amazing. and, I'll be deferential to the state here. I can almost guarantee that, if Kyle and Dominic Black had sat down and had a conversation about whether or not, like, if they had been thinking rather than responding to riots and fires, they'd said, can you bring a gun around? They would have said, no way, this is legal, right? They would have said, because they, and this is a point the state was trying to make. You knew you couldn't buy it. And then they tried to get him to say, you knew you couldn't possess it. And he smartly did not ever, he said, no, I did not know that. And that was a very good answer. But I think if everybody's honest and there's nothing on the line, you go,
Right.
If you're not in a riot and you're sitting down, you say, Kyle, you're 17. Can you walk around the streets of Kenosha with an AR-15 strapped to you? He'd say, as long as no one knows I'm 17. I think that would be the rational answer there. But it turns out, and that's the problem with this law, and that's what the judge was getting to as well. It's like, if it's taking us all this time to figure this out, we've had months and months and months, and we still can't figure it out. How's an ordinary citizen supposed to comply with this law?
Yeah, that's where he wound up, right? Is that you need to have clarity in the law.
Yeah. So there you go, Ryan Long. It does not blow up the whole statute, though. That is one thing that was I don't want to say it was dishonest, but it was an overreach by Krause when he says it blows blows up the whole law. It's like, no, if he's 15, he's liable. Guaranteed he's liable. If he's 14, 11, 12, 13, anything under 16, it
Right.
just
No, it just
seems-
creates the window.
Yeah, it just seems like the Wisconsin legislature had an idea, whether conscious or subconscious, to preserve the this rifle ownership and use for kids who are 16 and 17 years old.
Well, that's the
Welcome,
kind of
Legal
stuff that's
Bites.
fascinating. Hey,
I hope my sound is all okay. This is like new stuff that Mr. Bites bought me. So
Oh, is that an Shure SM7B microphone?
it's a sure something. I don't
It-
know what.
It looks like an SM7B, except it's got this little green thing on it that I don't understand. So
you got
nice.
lights. You're fancy
These are
over there.
some kind of boppity boopity lights. I'm not really
I
sure.
literally have a
I'm still
USB mic
figuring it out.
resting on law books. So
You sound great though, and
Okay.
it probably won't pick up as much background noise. That's
That's-
the
this
Yeah,
is
that's the
good.
hope.
No, I think I have to bounce in like 15, so it's perfect.
I get it.
So,
You don't want to be on with me. That's
Hey, I stayed.
fine.
I'm going to stay for 15 minutes. When I popped on, Nick will vouch for me. Two other people left immediately.
yeah, Kurt and Runkle just are like, oh, Hogla.
Yep.
I got
Video
laundry to
games.
do.
That's how it happened.
Well, welcome to the stream, Legal Bites. We were just discussing the minor in possession charge in response to a super chat, and just going through the whole statute and breaking it down, which I think is it can sometimes be very boring. In this case, I don't think it is, but really getting into statutory construction and interpretation can be boring, right? But I wish there needs to be. I like opportunities to do it because
Yeah.
it's what we have to do, especially when you're a criminal defense attorney and you have to say the state is bound by the words that are on the page. How can I make those words fit my fact pattern as the best way for my client? And then you go after it.
Well, and it's the
Um,
corollary, right? I mean, I talk about end user license agreements all the time,
Yes.
right? Figuring out what the hell those things say is important because no matter how many people on Twitter tell you, no, those will never be enforceable. A lot of the time they're going to be enforceable. I try to break this to people gently, but it's important to be able to at least read those if somebody tells you there's something crazy in there, or watch my channel. It's all good either way.
And
But-
everybody should. Oh, I got to add you guys to the description. I got to do that. Let's see. We got Uncivil, who was first. Then we've got
Yeah, I should
Joe.
probably let people know that I'm in here.
I mean, if you want to.
I mean, yeah,
Uh,
probably, right?
It's
Yeah.
a super secret thing. Just popping in.
Wait, we got so on that topic, what do you think about because I see this a lot because venues are license agreements or terms of service as we're seeing with websites. And
Sure.
I think we're getting some conflation because of the broad aspects of Section 230, we're not actually seeing a lot of testing of terms of service. But in the hypothetical that you get around the 230 issue, either legislatively, judicially, or 230 simply doesn't apply to the issue you're dealing with.
Yeah.
What do you think about this idea that people have that lawsuits can include or exclude whomever they want for any reason?
Lawsuits go in which direction here?
Or
The
not
users?
lawsuits, sorry, websites.
Oh, right, right. Well, I mean, so we're in an interesting era, right? Because your private property folks are going to tell you the right thing in terms of the way the law works, which is let's pretend that YouTube or Facebook or Twitter or Twitch or whoever isn't enormous and one of the only places you can go for these things.
Just a
If
mom
they
and
were just a
pop
mom
shop on the internet.
just a mom and pop video provider, you ordinarily would look at that and say, yeah, you can host the sign that says no shirt, no shoes, no service. I don't have to have you on my platform. I don't have to put forth your video content, your user generated tweets, whatever it might be. And I think we're getting into a situation, which is why you see this regulatory issue, you see the judicial issue and everything else that says these things are getting really big. Like when we talk about YouTube taking us down for 5 minutes and 30,000 viewers go like that, that's real.
Yeah.
And whether or not YouTube should be capable of doing that, if we get outside of 230, their terms of service are very clear here. I mean, YouTube has a provision in its terms of service that effectively says, if we ever decide that you're harming us in some way, then we don't have to host whatever it is you're doing. Which from a business perspective, and again, I'm a commercial contracts guy, right? When people want to get mad at me, they call me a dirty, corporate lawyer on these kinds of things. And I look at it and say, in general, a lot of my book of business is smaller businesses. I want them to be able to control their platform, their app, whatever it is that they built, whatever storefront they have. And so I think when you talk about these issues now, you're getting into a situation where if you want to have it regulated, you want to have it legally covered, you're going to have to slice that onion more thinly than I really think either side is discussing. You can't just kill 230. You can't just say YouTube and Facebook and Twitter and Twitch can do anything they want. I think you're looking at a new kind of legal zeitgeist that's going to have to be arrived at with, what I would hope would be some kind of actual discussion at a legislative and regulatory level. The polarization of the country is harmful, not just because of media and Twitter and how you feel every day, but because you aren't necessarily getting those conversations that are necessary to cover new things. And that's where I think that there's a big problem, because I think both sides are basically right to say, hey, it's a private company. Absolutely. And wow, that really harms discourse or the zeitgeist or people. Yeah, both are correct. Something probably should be done.
But I'll take it a step in a slightly different direction.
Sure.
I agree with everything you said, but as someone who represents businesses, that while it would be nice that your business could exclude anyone for any reason, that's not actually true, though. I mean, we can write it into terms of service or whatever, but if you've got a public accommodation, for example, you're suddenly bound by you're bound by what? Title 7, right? Under federal law.
So then you get into different conversations, right? So your really hardcore libertarian commenters would say all that's ridiculous. But let's assume that a law on the books for a half century is pretty legitimate. One of the reforms that I think
it's a reality, even if people don't like it.
Well, that's lawyers, right? I got clients sitting across my desk saying, well, why is that? It's like, no, that's the wrong question. Let's try to deal with it, because we're not in the halls of Congress here. But if it is reality, public accommodations, and especially the precedent there, excuse me, sorry about that.
No worries.
Are not read to really deal with the digital realm. And certainly it wasn't contemplated when that law was written. So it is one of those reforms that you could absolutely have to make it more clear what is expected about exclusion and not. But I will tell folks that when they're having these conversations about the political side of things, that's never been something really that folks haven't been allowed to exclude on. We're mostly talking about immutable characteristics. That was what those acts were designed for. And you've always been able to tell folks, are you a Democrat? You can't eat at my diner, give or take.
Yeah, and but I think it's interesting in the conversation because it gets to this idea when people talk about saying, well, we actually in some spaces may want to protect political discourse in the public. If we say, for example, that Facebook, YouTube, Twitter, whatever, is the public square, as a lot of people seem to think that they are, then maybe there's a point where we include some qualification. We say, okay, if this is it, if you're a public accommodation that works in this way, well, maybe we call it an internet public accommodation and create a category, then we absolutely have some sound basis for controlling a business. And it gets weird when people say, well, and like you're saying, the I don't know if you said libertarian or
real hardcore libertarian. I get commenters of all stripes, which I love. I think that's fantastic.
Yeah.
But you've definitely got people that said, oh, well, the Civil Rights Act is unconstitutional. It's like, okay, well, we'll bring that up on a later video, I suppose.
And it you know what, if you have that perspective, like I'm all for the idea that we could open everything up completely and go full libertarian mode on stuff, but we don't live in that reality right now. So if we're going to talk about this competing principle, do we want to protect public discourse in a free speech society, even though we're not talking about First Amendment constitutional protections?
Right.
Then we could say, hey, political viewpoints are protectable. And if you fall into this subcategory of businesses, we can do this. And we have actual precedent for this. In fact, California is a pioneering example of this, right? Because California actually has a political viewpoint protection built into their Civil Rights Act. Now, it's only been applied in a specific way. It's only been applied to people who are it was pro-gay rights politics in, basically between 1960 and 1998 or something like that is where the real application of the law is, but that's not the language of the law. That's just how courts did it. And the reason was because when people were advocating for gay rights in California, they were being shut out of basically everything. So they said, no. We want people to be able to speak on this topic, and they wrote the language more broadly than that. But that's what their goal was, and that's how the courts basically looked at legislative history and then narrowed the application because of First Amendment issues in general. But we have like this idea that especially all these businesses located in California would be somehow immune from this political viewpoint protection, when if Twitter started banning everybody who advocated gay rights, right? Like they would actually lose that lawsuit, and they would lose it quickly. Like no matter how much 230 protection they wanted to have, they would have real issues banning if you could show through like an employment law sort of perspective that this is only affecting people advocating in this way in violation of California law. They'd have real issues. Well, I guess we get into supremacy issues, but they'd have a potential
conversation. Definitely. I mean,
well, and that's why I've talked about Section 230 quite a bit also. And I think that where I've kind of landed on it is that if there is going to be some sort of a modification of it, which there probably does need to be, I think everyone on both sides kind of agrees that it's not good the way it's settled right now, right? Like it's everybody sees problems. It just depends on which side of the political spectrum you're on to see what exactly those problems are. But I think that at least from the right of center position, a way to change things in a way that would be beneficial would probably be to maybe focus on some due process controls. That's something that isn't written into Section 230. And I understand why, because at the time that they passed it, like the internet was nothing. Like they were trying to boost the internet. They were trying to let it take off. And now
regulating
it's so huge.
angel fire, right? Like that's what they're doing. They're regulating angel fire and GeoCities at the time this law is passed. It's amazing to think about.
Well,
Yeah.
we as attorneys, we tend to try and analogize to other things. And one of the things I've heard from the left a lot is the whole comparison of, well, you guys are all into capitalism and they're private business and they can do whatever they want. And they try and use the conservative perspectives as a basis to justify the censorship of big tech. When I came back from my little breakfast break there, so I heard you talking about the right to keep someone out of a restaurant or whatever. And I do think that Nick's point about this is not the same thing as being served in a restaurant. It's not even the same thing as the right to go on a bus, because those rights are not fundamental rights. There is no right more fundamental than the First Amendment right to free speech. And in that realm of free speech, the one area that is supposed to be protected the most is frank conversations engaged in political discourse.
But I
So
would say, but I mean, like the First Amendment is also held by YouTube, right? I mean, like that's the discussion that you have to have, right?
Yep.
So YouTube goes out there and says, we find this position abhorrent, and you have to talk about what that regulation or law looks like that says YouTube has to carry it because it's not so off the rails that they should be allowed to get rid of it. And that's why I think you get this tension, because again, it's easy to say these things about YouTube and Facebook and Twitter or whatever, but when I'm working with a client that's putting together their own forum on their website and it's a mom and pop and it's 10 employees, I need to think about, okay, if they do have an issue, what are they allowed to do? What are they not allowed to do? And right now, I agree with everybody that's spoken. The jurisprudence and the regulations and the laws aren't right, but I'm a little bit more reluctant to start hitting big levers on these kinds of things that force people to have to allow content on their service.
well, I think I have a very strong counter argument to your whole point, and to those
Ooh,
people out there.
Fight.
Yeah, we're gonna go.
Do
All right, I'm going to give you the
Do it.
5-minute warning. I do have to bounce in 5. So
Okay, so I'll
Hogue,
keep
if
it
you
short.
spit, it'll land on him.
I'll keep it quick. My argument quick. You just made a claim here, essentially saying that YouTube has a right, just like we're talking about a right to free speech. So too, YouTube has a right when it comes to free speech. So, and that free speech could be the right to censor whatever is being said on that platform, because you're sort of speaking for them. You're using their platform for
right,
free
compelled,
speech.
yeah.
Right. But here's the thing, though. The whole point behind 230 is that we are not treating YouTube as a publisher, but as a distributor, right? So what we are essentially saying in that argument is it's not YouTube speaking, because the difference between a publisher and a distributor is that a publisher is the one who's speaking. A distributor is more of like a train station for speech to pass through, just like a telephone line is.
But you're
is
talking about a
train
legal
station.
distinction, right?
So it's not their. So what I'm saying is it's not
I don't
their
disagree.
speech.
I don't disagree that it's actually not their speech. And I don't disagree that 230 says it's not their speech. But the actual on the ground real politic of it is you get articles about Gab or Rumble or Odyssey and what they allow on their platforms and how the media treats them. And you can see that there's an interest in YouTube or whomever to say, whether it's right or not, whether you completely disagree with their position or not, we are going to be castigated for what appears on our service. We don't want it to be on that service. And under the First Amendment principles, they generally have the right to do that, regardless of what 230 says. 230 is a legal liability shield. They still have the authority to say, we don't want that on our service. And 230 can't prevent them from losing goodwill, losing value, losing reputation, because our laws don't control the way society works.
Okay, but the perspective that YouTube, if you're sitting there advocating for YouTube's position, which essentially, I know you're unwillingly
said,
doing that. I know you don't
I'm a
agree with it,
corporate
but you're playing devil's advocate on their behalf, and that's what a good lawyer should do.
No, he is the devil, Joe.
Yeah, don't you see
So-
the red behind him?
What I'm saying is YouTube's position is inherently playing both sides of the fence.
Yes.
On the one hand, they're saying they're a distributor and now they should be exonerated from any liability in case anyone defames anyone on their platform. On the other hand, they're saying we're a publisher, you can't compel us to speak. And that playing both sides of the fence doesn't cut mustard. It doesn't make any sense, and that's why I think there's an inherent incongruity with the position
I think
that
230
YouTube
is
is
written
taking.
wrongly. I think 230 having a provision that allows them to, what is the language that says you can moderate with no problem with it if you otherwise find it offensive, which
Yeah,
captures
that's-
everything in human
That's the part.
experience.
Yeah.
So I agree with you. I don't think they work together well. I don't. I think going the First Amendment direction is the wrong way for everybody that's not big tech. And I want to be careful about the shotgun approach for those kinds of things because and I think the first half hour I spent with Nick here was me grousing about YouTube. I have a complicated relationship with them, but
We
that
are
when
we are the domestic abused.
yeah,
Yes.
well, yeah, it's
Yes.
Stockholm syndrome.
We have
get
battered
all
wife
this stuff.
syndrome. We keep coming back here.
Yeah, so
I know you
but
won't do it again. I know you love me.
Please.
exactly. So I understand where you're coming from, and I agree that it's not working right. And in fact, the recitals to 230 are hilarious. If anybody hasn't read them, they talk about how this law is going to help political discourse and
Yes.
keep freewheeling ideas in America and all this stuff. And it's like, oh, that's not really the direction it went. So
But
in
don't
any
those
event,
recitals? I will ask you this: don't those recitals now give just cause to question 230 for the court to actually say that the way it's been applied is not
they give nothing to
consistent?
the court. The recitals
I mean,
are non-operative.
It's
It
like
reflects the intent of 230, though. The recitals reflect the intent of 230. So
Yeah,
if
but
a
the
court's
words
trying
are
to
clear
understand
enough.
how
Like if
230
there were an
should be
ambiguity
applied.
that kicked in, if you could get them to ambiguity, you could start looking at congressional history. You could look
Right.
at those
Yeah.
recitals, but it's pretty clear.
Otherwise, the text on the page. Yeah.
Yeah,
But the text on the page says that the basis is if it's or otherwise objection. What was or otherwise? What are those
But they've
three
got-
words?
otherwise
got it all.
objectionable.
Objectionable.
yeah.
Yeah.
So as far as
It's a catch-all, and they're but people have used successfully catch-all phrases in legislation to their advantage forever, right?
Or
That
anything else. You can modify
Yeah.
it for these specific reasons or anything you want.
I mean,
Yeah.
so I can understand why they probably put that language in there in the first place, because they were like, I mean, we can't anticipate every kind of
we can't anticipate a
transgression that's
deepfake.
going to happen.
Yeah.
We
Right.
can't anticipate the reality of deepfakes. Right now, you could take an underage face of Emma Watson, right, or Dakota Fanning or something, and you could plaster it on a pornographic video. Like you
Which
can
is
do that
terrifying.
with face swap. And so the idea that you could take that, and in 1996, when they're passing this bill and they're making these recitations, they don't have any concept of this happening. In fact, I would argue they had no concept of Facebook. They had no
Right.
concept of MySpace. None of these things existed in 96. The closest we got were forums that and I mean, I think that internet forums, that require membership and all of this stuff might be a little bit of a different category. But yeah, I mean, if the legislature wants to address those issues, they have to do it. I don't think
Yeah.
we're going to get there
The
through the
other-
courts.
Well, the
unfortunately.
one thing that I
Can
can see the
bou-
courts
can I
doing
just
though.
pop in just 1 second? I got to bounce.
Yes.
Sure.
So I might come back. This was enjoyable, but I gotta do some billing. So I will
Right.
talk to you all later.
Later,
Joe's got a
buddy.
bill. So yeah. No, I was going to say that. So the one thing that I can see the courts doing though is maybe honing in on the good faith moderation aspect.
what?
Sorry, the
What's so
chat
funny?
says show us the deep fake so we can avoid it.
Oh no.
You have the best audience ever.
No, so but what I'm saying is that the courts, I think, maybe could there's some potential room for the courts in the good faith moderation aspect. And I don't know, I mean, I've looked at case law in section 230 to like really understand it, but I haven't looked at the actual arguments, on that level of detail of like whether or not that those arguments were put before the courts in various cases up to now. But it seems like an argument could be made that yesterday's live stream being taken down was probably not good faith moderation, right? So I think putting some sort of emphasis on these social media platforms having to make some kind of a showing that what their moderation was done in good faith in order for them to get that liability in the first place. Like that is all written into the statute. It's just a matter of judicial interpretation, I think. I don't know what you guys think.
Yeah, I think there's, Thomas, Thomas has commented extensively on this section in a beautiful dissenting opinion that I covered in a video. If y'all care about those things, you can go read how much I love Clarence Thomas's dissent in that case. But he's commented on this, and it was basically, we have a regulatory structure that we have imposed on several industries. And again, this is what gets me annoyed about having this, where like, I'm a libertarian. I believe me, like, and again, I would prefer zero regulation to what we have, my libertarian roots, but we don't have zero regulation. We don't live in that environment. And so I confront us with the reality of the environment that we're in. And so you have hardcore libertarians agreeing with currently radical, and I'm going to categorize it this way, it may be unfair, but radical left-wing political thinkers. Can you mute your phone while we're in court? I mean, oh my God.
I didn't know.
Mr. Neerman.
So you have this weird convergence of two different groups arguing for the same thing for wildly different purposes. But Clarence Thomas points out, we have common carrier laws. A phone company cannot refuse you service based on your political beliefs or what you say on their platform, right? You get on Verizon and you send a text message that says, I love Hitler and I love David Duke and I want to have a threesome with both of them. Like you say
Somebody's
that,
going to clip that out of context.
and Verizon cannot say, oh my God, I don't want this text communicated because ew, right? They can't say that and kick you off of Verizon services. They can't do it. They're a common carrier and they can't do it. A telegram company who is asked to deliver a message from one person to another based on the contents of the message cannot, unless they've been given prior notice, refuse to deliver the message. They just can't do that. And so since that exists, we have this structure that could be applied to mainstream media. Now, Thomas did also go on to say very specifically that he's not so sure the courts can apply that, right? The courts are going to have to go ahead and probably defer to the legislature. But he's saying there is a structure that does exist and applies to everything that we do. And to pretend otherwise is nonsensical because we've given Verizon the airwaves, right? They lease out a section of frequency, of radio transmission frequency from the government, which somehow claimed ownership of radio frequency. For some reason, we can't actually express how they did that. They just did. We have laid lines down for telephone companies, the Rural Telephone Act, right, of the 60s, which basically said, we're going to put a telephone line to every house so there's no longer party line. We're going to do this thing. It took a while, but we did it. And now anywhere you go, you're going to get a telephone line to your house, and you're not going to necessarily have to pay the full brunt of that. And that's because the government said that. And as an exchange, look, we're delivering, at the time, we're delivering Bell Telephone to every American citizen. And if we're going to deliver Bell Telephone to every American citizen, then they're damn well going to provide service to every American citizen. And then now we go and we just extrapolate that out. Eminent domain is used to send internet. We have broadband internet initiatives, and we have companies on the internet that benefit greatly from those services. And the biggest benefactors of it are Twitter, YouTube, Facebook, Google, Amazon, and Netflix. They're benefactors in a way that no one else can even come close to, like what the traffic Netflix does. And we're going to say that we use the law to get your service available to every American. Not necessarily given to every American, but available to purchase. Netflix has a distribution rate of literally 100% if people want to buy it. Walmart doesn't get that. No one else on earth gets that. You don't have to leave your house. All you have to do is have internet, and they made sure that there's a line to your house, and they're trying to make sure that there's a broadband line to every house in America right now through the government. And we're going to say, wait, that is not worth a minor amount of regulation. That is not worth a minor amount of saying, you know what, just because you don't agree with the political speech doesn't mean you can't transport it, you can't transfer it from one party to another. That's silly, because we do it with everybody else. Everybody else is under that same umbrella.
So I'm curious about this because I agree with Thomas' reasoning that this is certainly more appropriately handled by legislature than by the court, because I can't sanction judicial legislation, and that's essentially how this would come across. My question is this: I mean, we've seen states like Florida try to pass laws as to what policies Facebook must abide by within the confines of their state. And my question is, when we talk about legislature making change, I question. I thought it was a bold move by DeSantis, and I applauded him for it. I question the legal authority for a state to create its own unique laws as they relate to something that is clearly interstate, international, like a carrier, such like any internet company. Ultimately, I mean, you and I are operating interstate technically. I think that they should be able to do it, especially because when you're talking about these companies, they have a capacity to control what happens in various jurisdictions. So I think that when Florida passes a bill saying you can't limit this person, you can't, if you can't treat people unfairly, I'm curious about your perspective based on the fact that it is interstate as to how that would withstand scrutiny from the court as to the authority of the state, of one individual state, to pass legislation about this topic.
It loses to the federal government immediately, because
If the federal government supersedes. But what if they tack on a rule?
That means that 230 should, through supremacy, trump any private state-based litigation, right? Like it, I mean, based on how it works, that should happen, because Congress has the sole power to regulate interstate commerce, and I cannot imagine that Section 230 is passed under any authority other than the Commerce Clause.
Right.
Like that is and
that's
to the
classic
chat,
interstate. It's classic interstate.
to the
Well,
chat,
and
if you-
also the statute itself said that any other laws that intersect with it, basically that would go against it, are not to be applied to that kind of a case. So state law, federal law, constitutional law.
Well, the supremacy clause doesn't. I mean, wait. Does it? Is there any specific comment in 230 or thereabouts saying that this will supersede an individual state law? Because I do know that there's situations where it does. It says it expressly.
Yeah, from what I remember, I remember that. Yeah, it's a pretty powerful statute.
Because while clearly the federal law trumps state law, at the same time.
Well, depending on the issue
there are times where there are times I've looked at laws where I would think that there was a conflict, and the court has said otherwise, and saying that this is not something we don't apply federal statute here to say that they're in conflict. But if it's clear, if it's expressed in the statute, then obviously, yeah, I hadn't noticed that ever in Section 230. Now you're going to make me read it.
230 has an express statute basically granting blanket immunity from all civil litigation related to the moderation of content. So then that would presumably encompass, and I think the state would competently argue that would or the federal state would competently argue that would include state law tort claims as well. But
I don't think the federal government would be involved in that suit. It'd be Facebook versus the state of Florida, but you're saying Facebook could rely on the supremacy clause that
230 would apply.
Yeah,
and the feds may actually implead into that, right? Like the federal government may implead on behalf of Facebook if they disagreed with the state law.
Yeah, Legal Bites was saying earlier that on both sides of the aisle we're not happy with Section 230. That's true, but the reason
for
that
different reasons.
yeah, and those reasons could not be more opposite. I mean, the left literally wants much more censorship. They want their they want cancel culture to be codified as law. And whereas our position is no, let everyone speak, and I don't care how offensive they are, or this if they're spouting, leftist gibberish. I don't care. Just let everyone speak, and let the public decide where their tastes lie and who's correct based on by voting with the power of their attention span. So
Let me read this super chat. David Stern says, Kyle better believe in the heart of the cards. Kyle, I use Pot of Greed, which allows me to draw 2 more jurors from my deck. Binger, I attack with false evidence for 100 credibility damage. Judge, you activated my trap card. Mistrial with prejudice. Yes, there you go. That was very confusing to me. Is that Yu-Gi-Oh? I think. David S says, please keep us posted on future coverage. You guys are the perfect example of fair, unbiased coverage while offering a unique perspective. There you go. Well, I mean, all of us stream all the time. Probably too much.
Yeah.
Probably way too much. But we do. And that's why I've included everybody's link in the description who has joined the stream so far. Let me find the next one here. Catherine H says, what do you think Backdoor Binger and Big Boy's reaction will be if Kyle is found not guilty of all charges? Will they have a public meltdown and argue with the jurors and judge?
No, I think Binger's going to have like a dramatic close up. It's going to be in black and white, and then you're just going to hear this, "Hello, darkness, my old friend." That's going to be it. He's just going to sit there stunned.
He's gonna.
That's it.
I think Kraus might go destroy an entire Jimmy John's. And I don't mean go eat everything in Jimmy John's. That would be the obvious joke. No, I think he will go to Jimmy John's, flipping tables over, ripping the booths off the wall. He is going to be, he looks so mad every time anything doesn't go their way. But, this is for you guys. The big panel does not get this. Someone sent me something yesterday, and we all missed this. And it's, hold on. I've got to do this very carefully because I don't want to give their, I don't want to dox their name. Perfect. Let me share this. The chat. This is for you. We all missed this. And so you guys are here for jury deliberations. Again, what's wrong with you, chat? I love you, but what's wrong with you?
There's a lot of people here too.
Okay.
What are we looking at?
This is from yesterday. This is a clip. Richards is going to say something, and my man who did this video is going to pinch to zoom on Krause's face. Krause is what matters in this clip, okay? I don't want to spoil it beyond that. Here we go, guys. Watch Krause. He walked right by them, and then they ran ahead. They were lighting a fire when Kyle walked up.
The only thing I can say about James Armstrong is, okay, that's interesting. What I'd like to say about his photographs, his knowledge of what he did, and some of the statements that the state has made regarding it is, what he did for those 20 hours is hocus pocus, and he makes an exhibit that is out of focus. And that's
an agreement.
I don't know if
Oh my God.
agreement. I don't know if that's agreement or his face is more like.
No, that's
that is
actually.
Respect for
that is
the
respect
game.
for the lie. That is
All right,
yes.
Respect for the game.
Yeah, that's how I took it. I don't think he's agreeing. He's agreeing that it's hocus pocus, but I think he's like, "Wow, well played. I got to tip my cap to that
At
one."
the very least, yeah.
And I thought that was his glove don't fit, you must have quit moment, and that he should have come back. He did sort of play off of that theme later on, but that was his glove don't fit moment.
Well, he kind of did though. I mean, he referred to magic. He referred to Fantasyland. Like he did it in different ways. That he was
too
just
subtle.
like, look,
It's
they're
too
just
subtle.
trying to. No,
I
that's
disagree.
Perfect. I think that's perfect.
Krause on rebuttal said hocus pocus.
Hocus pocus.
Yeah.
Yes.
Done. He did it.
That was
Yeah,
that
I
showed
that.
how much he was in his head, how deep that was ingrained in his head, and how
Just how
cut
much
he
rent
was.
he's paying.
Yes, Yes, that was it.
Yeah.
Was
No,
exceptional.
I
And
completely agree. And I think the point he was trying to make was like, look, he's trying to make us look kind of ridiculous. He's trying to, paint us to be these, oddballs that are, trying to make things up. But it's like by actually using the phrase, the jury, for all we know, forgot the hocus pocus phrase. But then as soon as he said hocus pocus, then
No,
the
they
jury's
didn't.
gonna be like, oh yeah, hocus pocus
No,
out of focus.
nope, no, they
That
didn't
that
forget
photo was out of focus,
that.
huh?
They didn't forget that. But it's sort of, to me, he came across as like, I am not out of control. I am tired of being told I'm out of control. I'm not out of control at all here. That's
You're out
what
of
his whole.
control.
It was just insanity. It was. I don't know what. I think strategically, it's crazy that they put him up there because we saw the meltdown he had on the stand when Nathan DeBruin, who recently opened a Twitter account,
Oh
which is
yes.
called Photos by Nate.
He liked one of my tweets. That's how I found that out.
Yeah, Photos by Nate D. By what is it? I think it's Photos by Nate D. or something to that effect. If you look up Nathan DeBruin, I'm sure you'll be able to find him there, and who we call here Photo Chad. But we saw how Krause melted down when his integrity was attacked, and he lost it. He just lost control, and he couldn't think straight. And that's why, coming off of that response, the closing arguments from Mark Richards, I thought he was the worst possible personality to put up there because he just sat there and just belting out his anger and doing his stupid little checklist of just annoyance. I am turning this off now, by the way. I'm sorry. And
yeah,
just
it's really embarrassing.
it's
actually
so
very
unprofessional.
frustrated.
It's so. Do you know I actually leave this thing on while I'm doing my own streams? I stream 5 times a week, 10 p.m. to midnight. I lead into Nick's show, and this has happened on my show 0 times. So that's why I'm kind of no one
Conspiracy.
even knows this number. But
Stuff like conspiracy.
yeah, I thought Krause. I thought strategically, you have to put your team as a lawyer. You have to put your team in its best position to win, like a coach trying to win, and you set your team up to make it most likely to succeed. And I just thought he was the wrong pitcher to go send out there in that moment in time, because he had displayed that he cannot handle that emotional, the emotions that he feels when his integrity is intact. So
I wonder if their line of thinking was something along the lines of like, okay, so the defense closing argument just kind of destroyed our credibility, and or maybe not, maybe they weren't thinking that it destroyed, but they were like, they really took a lot of swings at our credibility and they really focused on Binger. So can we really put Binger up there now? Which I still think it would have been a better choice, because that would have been the stronger, like putting the stronger foot forward and be like, yeah, he just said a bunch of shit about me, but I'm going to come out here and tell you why he's wrong, or or tell you why that's all a mischaracterization, and I'm continuing on because I'm on my way to get justice here. Like that would have been a better look. But it seems like they maybe thought, at least I this is what I'm imagining anyway, is that maybe they thought, if we throw Krause up there and he kind of defends like Binger and Binger's character or something by like going out there and like kind of taking swings at the defense and getting angry, like maybe that'll look better, maybe that'll play better. But I don't see how that would play well for anyone, because that just, I mean, he was yelling at the jury, he was getting in their space while yelling at them and yelling into a handheld microphone. Like none of that looked good.
I don't know why you take Binger, who, if any of us are honest, we got to go, Binger is very good to the jury. Like, he's very good in front of the jury. He's very comfortable. His cadence is solid. He just has a great presence. Like, I don't mean to fluff the guy. I don't really like him, but
Hey, Eric.
Hey.
He's got this all around good presence. And then you go to Krause. It's like, why would you quit Binger? Right? It should be Brokeback. I can't quit you. Binger should have been back up there. And he should, maybe they did it on the fly too. Who knows? Like, maybe they said, whoa, your entire credibility was just thrown into shambles. If you get up there and start trying to defend it,
I had read
they
scheduled it that way from before the day started. That Krause is supposed to. It is
stupid plan. That's an ego play for Krause. Like,
I
oh
still
yeah,
don't
buddy,
know.
you helped out.
I still don't know that Binger looks good in front of the jury anyway with his style, because like like it would be fine if he was just talking down to maybe Kyle, or talking down in response to the defense, the other attorneys. Like that's, I think, fine. But when it was he had the same sort of persona, the same sort of vibe on the other witnesses that are much more credible and much more like sincere, likable by the jury, like Nathan DeBruin, for example. Well, he wasn't cross-examining him, but you had the same vibe throughout the entire trial coming from him, that I don't know that he was smooth. Sure, he was very smooth, but he still was very condescending, and especially the combination of the two of them together, very condescending, very much on like, in this like in this like white tower or whatever, what have you, like just kind of calling down to everybody else, like, you don't know what you're talking about. I know what I'm talking about. I'm the prosecutor in the white hat, and I'm going to tell you how it is. Everybody else is wrong.
Didn't
I-
Binger
Yeah,
come
maybe.
across as the high dollar defense lawyer that got flown in from New York? I mean, if you're going to look at the comparison, like he's the guy that had the slicker suits. He was the one that had the pens. He was the one who had the smooth demeanor and attitude. And I don't know if that plays well in that area or not. I can't speak to the jury, but what I can say is Richards, at least at the end, felt like he was a member of the community.
Yes.
And that was
Totally.
I think a great element. We look, we were attacking Richards for the last 2 weeks, and justifiably so. He earned our scorn and our wrath because of his passivity in defending or sleeping
And his
through this
opening
entire
statement.
trial. Yeah, his opening statement was okay though. I mean, I think he
No,
I mean,
I don't agree.
That's it was. We all remember. We'll never forget the hard R. We will never forget the hard R. And if
Yeah,
you're
but if that's
memorable,
all you take from it,
Yeah,
that's
is
not
that
a
what you
good
want
thing.
to remember? I mean, that's sort of like Nick's tweet that I just shared that got pulled already out of context. Rekieta.
Oh no.
It took a guy, what, 5 minutes?
Yeah.
what was pulled out of context?
Me saying about the threesome with Hitler
Oh.
and David Duke.
It's already
Nice.
out there.
Nice.
Oh boy.
Oh, God.
That's beautiful. And my face
Wow.
I
is
knew
right
it was
next
gonna
to this,
happen.
smiling, like, yeah, there's no.
Oh, no, they cropped them. It's
Oh,
all
thank
in there.
you.
But your
That's
ringtone
awesome.
slipped in
Thanks,
at the
chat.
end.
You don't put someone else in there with me. You don't ruin someone else's life. That's not even fair.
Yeah.
But your
So.
ringtone made it in.
Yeah. Yeah.
Nice, very nice.
Oh my gosh. Welcome to the show, Eric. Man, glad to
Thank
have
you.
you on.
I feel good. The non-lawyers here, I guess it goes to a jury, so I'm the jury.
You can be the jury. What do you think, man? You've been following along, I assume.
Yeah. I mean, I agree with you guys the most part. I was blown away yesterday. I was like, who is this guy? And where did they put Richards? I mean, seriously, that was a shocking replacement. And my only theory is, Barnes keeps talking about how he's got a very short temper. He was pissed. And I feel like he came across as righteous indignation.
Yep.
And that was good. That was the first time in the entire trial I felt like he was actually fighting for Kyle, like he cared. And I hope the jury sees it that way. But I mean, it was like, I love that he was like, Binger, 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 Binger. The same way that Binger went after Kyle, he was going after Binger in every way. And I still worry about it, though, because of that debate that Nate had. I don't know if you saw that on Matt Orfala's channel. He was with Bess, like millennial splaining Bess or something like that. It was a very, very woke seeming individual.
Sure.
And her ultimate thing is, in the end, that morally, I think it's wrong. He should just be, it doesn't matter. He showed up, he had a gun, he's bad. And I fear that there are people in there. And as Barnes pointed out, the whole behavior panel got shut down, left out. So all it takes is a couple of those in there to screw everything up.
Yeah, well, we'll see. The jury
that's
panel
why there
is...
would be a mistrial or a hung jury, though. Mistrial because of a
I
hung
want to
jury.
confirm with you guys because I had Runko of the Bailey on my live stream last night, and we were pretty sure about this, but I'm not a criminal defense attorney. He is a criminal defense attorney, but from Canada.
Yeah,
The
so it's
jury right
basically
now,
not even real.
yeah. So, so the jury right now, I assume that if they were to reach conclusions on, let's say, 3 out of 5 charges and get hung on the other 2, so those conclusions would be binding, and
Yes.
if it's an acquittal, he would be acquitted, and if it was, conviction, he would be convicted. Because I could see something like that happen. I don't think they'll be hung on all these charges. I think that on some of these charges they might end up hung and others not. And so that is the ramifications, though. In theory, they would leave over 2 charges as a mistrial, and then the state can go after him for the other 2 charges and start all over again with only those charges pending, right?
Yeah.
I guess, or maybe the judge will step in and just say, "Okay, get rid of this. We're done."
No, I mean that if it's a hung jury, they're not going to get dismissed with prejudice. So they would be able to bring them again. The state would have to decide whether they want to bring them in again, because, well, if they're losing or if it's close, then that's not the best look to go ahead and try another bite at the apple. Plus, it would give the defense a different approach to the case, right? Like they would get to look at the things that they did wrong and clarify those. They wouldn't have the benefit of having the curfew charge and the gun charge, like tainting the whole jury.
Mhm.
So the state has to make a lot of consideration whether they want to bring that case back. Now they may do it for political points, but in theory, they have just as much reason not to. State resources, the embarrassment of the state for losing the case in the first place. Like if they lost it the first time, they should expect that they're going to lose it again. And the other problem with the state's case in general is that it's such a technicality based case. We want to fool the jurors that the facts are not what the facts actually are. And that is maybe the most offensive part of this. They know
I don't think that's true.
provocation.
I think you're mistaken. I think that you and I see it that way. I think that's real. I think your perspective is reality. But in the mindset of Binger, in the mindset of Krauss, we saw from their emotion. They showed passion and emotion in this trial that we didn't see from Richards at all until closing arguments. Because I believe that, like many lawyers do, when you get deeply invested in your case, you fall in love with it and you genuinely believe the crap that you're saying. No attorney stands up and makes such an idiotic argument to a jury along the lines of, he has no right to fire when the guy is lunging at him within 4 feet, and because everyone gets beat up sometimes, so you can't use lethal force. What a moronic, stupid thing to say, that anyone who just walks in and hears someone make a statement like that would think to themselves, you're an idiot. Like, that doesn't make any sense at all. There's no logic. There's no justification. It sounds so stupid. But when you're a lawyer who's fallen in love with your case and you really believe in your positions you're coming from, all that kind of stupidity makes sense to you. And don't tell me that you as a lawyer, as an advocate for someone, haven't fallen for that yourself, or sometimes arguments that in the abstract you wouldn't really believe in so strongly, but you sort of at least go through the process of thinking to yourself, yeah, that might work. I think that'll work. And then afterwards you step back and you're like, wow, that wasn't the smartest move to throw
It's
out there.
cognitive dissonance, Joe.
Yeah,
Cognitive
and
dissonance is the word you're looking for.
But that's why every time that you get deeply involved in any kind of litigation, you want to have other lawyers outside of your immediate circle that you can call up and say, hey, I need a gut check right here. Am I seeing this right, or is this just like me liking the smell of my own cologne? So that kind of thing is very important.
I don't know that I fully agree. I know that lawyers can get wrapped up in that, but I'm not sold that their indignation is because they're so invested in this case personally, that they ignore like obvious flaws in their case. I mean, this is not them making a novel argument that they really passionately want to be the truth about some issue. This is about them reframing the entire case against common sense. And to me, it looks more like a lawyer who's been given a bad case, They've got a client that they're gonna service the client, whatever they need to do. Maybe it's an existing client and this is a minor issue or something, and they're gonna make a grade A effort because the client says, I want to pursue this, and that's the state, right? Saying you're going after Kyle. I cannot believe that Kraus and Binger are bad enough attorneys to genuinely believe the nonsense they're saying about self-defense. Like
that's fair.
I just can't get there. I think maybe they're making a passionate argument about provocation, maybe, but
I mean,
I don't know.
Binger's statement that so Binger argued that Kyle, by bringing a gun that night, gave up his right to a self-defense. That statement was retweeted by Bad Legal Takes. Like, that's how you know that it's bad, when part of your closing argument is retweeted by Bad Legal Takes.
Here's the thing,
Like,
though.
because
Is that for lawyers or is that for people?
it's so that's it.
I keep going back to Bess and Nate. That's what she wants. I mean, she's hanging on that whole thing. He brought a gun. Bad things happen. If he didn't bring a gun, those bad things wouldn't have happened. And I'm not saying it's logical or anything else, but you're like, it's a bad legal thing.
If she hadn't worn that skirt,
well, I love that.
Happened.
I love that analogy. But then getting back, as I said, is cognitive dissonance, right?
Mm-hmm.
They have their argument. This is their theory of the case. Bad, Kyle. And have you ever argued with somebody who's just dug in on a subject?
Of course.
And no matter what you do, well, except for Nick. He's the arbiter of reason. Whatever you do, they get just crazier and crazier and crazier. Like, you're a doctor and you're telling people not to smoke, but you're smoking. And it's like, my grandfather lived to be 102 and he smoked cigars and drank whiskey every day. And it just goes on and on and on. And it becomes more and more ludicrous. And I kind of feel like that's what you saw happening in real time, because there is no time to actually step back and react. It's like, oh no, I'm just going to throw at it. I'm going to throw at it, and not necessarily respond with reason or sanity.
Okay, to the chat who's freaking out, here's the feed from court. There's nothing happening. It's not muted. Nothing's going on. Yes, the judge briefly appeared in frame. Someone is saying Court TV reported that after 90 minutes, the jury asked for 11 more copies of the jury instructions. That's all fine and dandy. None of that's actually coming through the feed, though. I do have it up, even though you can't see it. There's just literally zero is occurring on the screen. If something happens, you'd actually hear it, because the audio will come through the computer, and you'll hear it before I switch it over. But there's nothing going on. I am monitoring it.
11 copies.
Well, there are 12 jurors.
That means they're completely confused. They've got to be completely confused, and they're all like, "Wait, what? What does that mean?" And that doesn't.
Maybe in the alternative, they decided they each want to take a few minutes and go through all of the counts themselves. And so each one is going to go through the jury instructions and go count one, check, count two. And then they're going to come together and say, what did we come up with? Maybe that is, maybe it's not just confusion. That could be a possibility too.
Or they're having a group reading together and they're trying to understand it.
Yeah. You are Horatio. You are Yorick. Sorry.
I was going to say, like a play, they're doing a table reading of jury instructions. That'd be fun.
But yeah, don't worry. I am monitoring this. Look, if there's an announcement, if anything happens at all, I'm on it, because I
would expect
really
an announcement before they come out. They're not just to come out. Also, the jury's there. I think the public at large would know that they're going to announce the jury. The jury reaching its conclusion, and they'll come at 1 p.m. or whatever.
Yeah, because they got to get the parties back there. Oh, excuse me. They got to get Kyle in there. They got to get all the attorneys back in there. The attorneys are all right now, calculating their billable hours. Or if they work for the state, they're sitting there, eating the souls of children. One of those two things is occurring.
CNN right now with his agent.
Well, I just really think that this is a case where self-defense has gone awry, and our interpretation of self-defense is probably not the correct interpretation anymore. Wouldn't you agree that he shouldn't have been there with an AK-47 R15? Wouldn't you agree that his 75 clip magazine bullets were way too much, and that he shot so many people. It was just, it was. I hate
But he
his
should have. But he
patronizing
should have.
tone.
He should have made. He should have made more shots by making some warning shots, perhaps. I
Yeah,
love
what
that
was
suggestion.
he
And
could
why
have
do you only
fired
shoot
warning
black
shots?
people? I don't understand that.
If he would have fired warning shots, what's he? One, he's going to shoot him into the air like the Arab Spring or something. Like what is
Or
happening
into the ground.
here?
Either way, you have another charge for reckless endangerment.
He did fire
Yeah.
2 in the air. Jump kick guy.
Yeah,
Well, he fired them at him, but not
I'm
just
joking.
he
indiscriminately.
should have
Oh.
fired him. He should have fired near the victims. That's the way you actually do this.
Just like
ignoring
someone around the feet, just make them dance.
ignoring the legal reality that would be attempted homicide, because that is also deadly force and would carry the same punishment as the actual homicide. So, oh my gosh.
Now, you guys talked about them never playing it in real time. Did they ever play the incident in real time?
At
No.
some point in the trial, maybe.
yeah, testimony, but that's
A long time
not during
ago.
closing, which was frustrating.
Yeah, a long time ago, perhaps.
Like I definitely I appreciate what he was trying to do by breaking down all of the tiny little decisions that he had to make within such a short time frame, and it was great to highlight that. But I really wish that he would have just taken that last step to say, okay, so now you saw all of those decisions. Let's take a look at how much time he actually had to make them. Let's play it
Yeah.
from the top.
You've heard a lot about 4 shots, and don't even play the video, right? Just grab the audio from it. You've heard a lot about 4 shots. I want you to hear how fast those shots were. This is not sped up or altered in any way. Like, and then that's it. That's the
Yeah.
time that the defense is saying he could have stopped shooting, that he should have determined that he was on the way down and should have known that he was at that point. At that point, they should have known that. The problem is, of course, if that first shot doesn't take them down, hesitating even for a moment ends up with Kyle dead.
Yep.
Right?
yeah.
Like that's where you go with that. And I like you, Legal Bites. I just wanted him to hammer the point home. You've seen all this.
Just
We've
tie it
gone
with a
for
bow.
We've gone frame by frame. I want you to realize how fast my expert, Dr. John Black, testified. This is 30 frames per second video. So each one of those pictures where the defense or the prosecution is trying to show you that he's doing all this stuff. He's checking his gun. They're showing you one picture at a time and trying to extrapolate all that. I want you to understand that each one of those is 1/30th of a second. It's 1/30th of a second. And let's look at how it looks in real time. And then you see Kyle get kicked in the face, spin around, bang, bang, grabbed his gun, bang, and then waits just a second and bang. Like it's so fast.
It is so. It is.
And I would have played it
lightning
over
fast.
and over and over. I would be like, okay, so this happened. Wait, I didn't see that quite right. Let me replay that. You see how? Wait, oh no, it's too
And
fast.
that's another good point, is that another possible way of doing it would be showing it in real time every single time, and then each
Mhm.
time showing a new detail. I mean, like, okay, this was super fast, but did you miss this? Did you miss this? Did you miss this? Like,
Yeah,
and then just
I like
to
that
show, like,
approach.
oh my God, there's
To
so much
drill
information.
in that the only way you can really break down what happened here is if you slow it down far slower than Kyle had to react. By the way, and I think when you're doing that, I like the fact that he did touch on this. It's not just where he shot and when he shot, but also who he did not shoot. That anyone, that people who had been rushing him, but then step back to show that they're not a threat, that he was able to make that calculated assessment in tiny fractions of a second to say, okay, we're not, look, I don't want to shoot anyone I don't have to. And you show that,
Yep.
he was not some crazy active shooter. He's not someone who was hoping to be in that situation. Quite the contrary. He was trying to get away from that situation any way humanly possible. By the way,
Also,
that
the-
whole argument Binger kept making, speaking of which, that whole argument Binger kept making, saying like, did it look at the callousness that he lets Rosenbaum bleed out there rather than helping save his life after he just shot him down. What kind of ridiculous stupidity is that? That does he think anyone in the jury would be like, yeah, that's what he should have done there. That's what he should have done. He should have gone down to his knees and tried doing chest compressions on Rosenbaum while everyone's screaming, he shot him, get him. That's what he should have been doing. It's like,
Speaking of Binger, he said in Kyle's shoes, right? I also would have made the point of saying here's the slow motion. This is what we see as we're looking at later. Then real time. This is what Kyle saw. This is what we see. This is what Kyle saw. What was
Yeah.
Kyle supposed to do? Kyle sees it this fast. We're sitting here parsing it. This is what Kyle saw. This is what we see. This is what Kyle saw. And just over and over. And then say, Mr. Binger said, put yourself in Kyle's shoes. Put yourself in Kyle's shoes. Look at this. What would you do?
And that's what John Black was supposed to do. That whole thing got left off. John Black was an expert on not only video in general, but he was an expert on, and he testified to this, was qualified for this at his Delbert hearing. He was an expert on the perceptions of the people in the video and their decision making based on information that was available to them rather than the video itself. And
Right.
I think they really bungled John Black's testimony. I think they really did. He was his whole qualification. They pay him a bunch of money. They fly him out there. They do all this stuff to have him ready to go. And then the questions were all just like, this is, you're just going to play some slow-mo clips. Like that's what we're going to do here. You lightened it up and you're playing it. Like, put him down and say, have him say, no, here you go. Of course, what Kyle was doing based on the information in the video is at issue. So if the state objects to this, they're going to look absolutely ludicrous. And they're just going to say, how is this not relevant to his state of mind? This man, we talked to him. He's qualified as an expert in what people actually see versus what we see from the perspective of a camera. That's his whole role for being here. And you agreed to that. And then you let him talk about those things, but they so like accepted the limitations of his testimony. They should have asked the court to expand upon it and said, Your Honor, this guy is who we brought in for this purpose. The defense wants him limited to just timing shots, like he's a more accurate stopwatch or whatever, which is great. But they have raised all of these issues. Of course we get to go ahead and impeach them with an expert. Of course we get to do this. And let the state feebly argue in front of the judge that, no, we want less evidence on this thing, in my opinion.
Yeah. I think that he seemed like a very competent expert witness. I mean, especially the way that he was explaining things at the beginning. And I was really disappointed by the way that they set up that line of questioning, because if I remember correctly, now I don't even remember that much from his testimony, which tells you just how well that went. But from what I do remember is that the middle portion, which is the worst part to have your zingers, the middle portion is like where he started to get into good stuff. So yeah. And by that point, I think that the jury was long gone. No one was paying any attention, but he was actually very good at explaining a lot of this technical information. He just wasn't being asked it in a way that really was helpful for the jury to be able to pay attention. And that's the thing about an expert witness is, I mean, that the two keys for a good expert witness is, first, yeah, they obviously have to have a good understanding of the material. So like, you know, the pinch and zoom expert was not very good for that purpose. He really knew nothing about the pixels that get, you know, sort of populated when you pinch and zoom, and what color are they? Well, I don't know what happens there.
I could have told him this stuff. What's mind blowing
Yeah.
is, you know, that the company's software, the company itself, the software they are using in their blog stated you cannot use this as evidence. In their blog. I'm not. I shared it with Barnes the other day. I can text or DM it to you, Nick, but it's mind blowing because they themselves put it out. They said this could be a good investigative tool, but not as evidence. And they talked about the shortcomings in it themselves. It is staggeringly poor form.
But the other part of sorry, I was going to finish my thought that the other part of of a good expert witness is being able to translate what you do know into regular English for people that are not from your field. This is obviously the biggest issue for lawyers is trying to be able to explain things to clients so that they understand them, et cetera, et cetera. But yeah, I mean, and that's, but anyway, but I think that the bigger problems with his testimony were more having to do with the way that the questions were framed for him to explain what he needed to explain.
I
So,
DM'd it to you, Nick.
3 quick things. 1, the quartering can check his DMs. 2, yes, the chat is correctly pointing out that the judge barred through his order the discussion of those things pre-trial, and the proper way to address it, as I said, is to bring the request to the judge, not to try and introduce it out of anywhere. Bring the request to the judge. Says, Judge, and if anybody remembers his in-court order, which is what he went over rather than the proposed order that he ended up signing, he did say, I'm going to leave the door open for the behavioral testimony. He did say that if it becomes relevant, because this judge has not been a fan of an a priori exclusion of evidence throughout the trial. We've seen that, and specifically of testimony. So you bring it to the judge, not what Binger did, right? You bring it and you say, Judge, we believe that they have made Kyle's decision-making an issue in this case at several points leading up to this, not only throughout the whole night. What we want to do is introduce limited testimony of our expert around the events in which self-defense is occurring and the decision-making process under stress, so we can show his perception rather than the camera's perception. That's what our expert's here to do. That's what we discussed. You did say at the pretrial motion in limine hearing that you would allow this type of testimony if the door is open. We think the door is open, Your Honor. Can we do it? And then again, let the state argue that the door is not open to what Kyle was doing at the time he's making the shots. Of course that's relevant. And they're going to try and argue that it's not. And then they were, I believe firmly that they would have easily won on that request. But I think they misused that expert for the reasons stated, and by me and by Legal Bites here, that I don't remember his testimony at all. I don't remember any of it. And the third, people are now asking, would this be grounds for a mistrial on appeal? And the question is always, was the objection preserved? And on this one, it's muddy, right? Because they did preserve an objection to the expert and the introduction of the expert's use of this software. They didn't do it on the same grounds. So that would be the argument on appeal. We preserved an objection. Here this is. Well, then the appeals court has to determine if this new information constitutes new evidence that they can or cannot consider. And so then the state would obviously argue against it.
What is that law the judge was talking about that was, bad science led to people losing their jobs and everything else, and you can't just go with bad, because could you not, like with what I sent you in the DM, but use something like that, like the own company said this should not be used to overturn that piece of evidence if that proves to be pivotal?
Yeah, what he was referring to is the Daubert standard, which is case law Daubert. I pronounce it Daubert because it looks French.
I pronounce it Daubert. I don't know, but so many legal terms depend on like what geographic area you're in. I've talked about this before. Like even within Texas, which is where I went to law school, they taught us in our advocacy classes.
So how do you say voir dire then? How do you say voir dire?
So if you're in federal court, they said if you're in federal court, it's voir dire, but if you're in state court, it's voir dire.
Voir dire.
Voir dire.
It's voir dire. Yeah. You can't. There's no. Texas does not own pronunciation of anything legally related. They can't.
But that's just that was the recommendation.
That's a Daubert hearing.
That was
don't get me wrong. I love it.
I think in California, I don't know. I've got. I think I have at least one of my California lawyer friends watching. They can text me and correct me, because I've been wrong on other pronunciations before. California has a word for a motion to dismiss. It's called a demur. But for the longest time, I only saw it written, and I didn't actually use it in conversation. And especially not having gone to law school in California, so my boss roasted me when I in conversation like several times referred to it as a demur, and he's like, "Oh, is this a pinkies out demur?"
Well, are they related? I mean, it sounds similar.
To the
to demur is to pass over or to choose to not acknowledge, right?
There's
I
an
mean,
extra ER on demur in
Yeah.
California.
Oh,
Yeah.
But
okay.
to the
Hey,
chat,
Kurt.
Texas
Hello again?
should own the legal pronunciations of everything. They just don't. I mean, that's look, I believe me, if everything were said in a Texas accent in the courtroom, things would be better.
I believe that's the new MV7 microphone, if memory serves
Yeah, it is.
correctly.
Sure, MV7. I have one too.
Yeah. So I
Yeah,
Oh,
yeah.
I have
Eric-
one
is it plugged in
too.
through
Eric
USB?
DM'd me earlier about that.
Is it plugged in
Are-
through USB?
Probably.
Yes.
Yeah, I was just curious because the sound quality was really good. So interesting. It's cool.
They sound better on
Um,
USB than they do on audio interface.
Okay. Now
Because
But
they have a
that's-
built-in app for near and far. That's the advantage of it. I have it as a travel.
But that's how a lot of legal terms go, is because you're in law school and you're reading through them and you get Latin, you're like, pro hac vice. What the hell is this? Like, you never hear it said unless it
Yeah.
comes up specifically in a class, and then you're still relying on some dummy's interpretation of how it sounds. And yes, I did refer to all law school professors as some dummy, because at the end of the day, that's what we all are, and everybody needs to get off of their horses, in my humble opinion. And I think law professors who
Texas
realize
law
that,
professors are actually on horses. Fun fact.
yes,
No?
true,
I'm kidding.
on a horse with a big iron on the hip. No, it's so I always say, I qualify it as, I read it as French. My mom is from Louisiana, and so, you know, like I read French words as French words, mainly because of that. But that's just how it goes. I don't know the correct pronunciation, but yeah, it's that standard that they wanted a way to qualify experts to make sure they were actually experts. And in this case, you got a guy who clearly is not an expert. Like, his expertise is literally, I put in program, I click the button.
And then
Yes,
asked, and you know,
yes.
as soon as they scratched the surface on like, well, what do you really know about this? He's like, I don't know.
And then also, I wish they pushed back a little bit more on the peer review. It was peer reviewed. So is this peer as informed as you are? Because if so, we have way more trouble.
I love the judge. Peer reviewed. What does that tell me? Right?
What
Like,
does
that
that
was a
mean? Who's the
beautiful line.
peer?
What does that tell me now? What, that doesn't help me at all.
I mean, Nick's stream is peer reviewed by us, and look at the quality of that. So, you know, damn.
Hey, wait a minute.
Yeah, they just let anybody on.
Yeah, we even have non-lawyers on this
I
panel.
know.
Oh my
Occasionally,
God,
yes.
just
Disgusting.
disgusting.
No,
Well,
but
it is
I
nice
always-
to have a non-lawyer on because they can talk from their perspective, and I think it's interesting, particularly at this point, like see what other people are seeing and how they're reacting to things.
Yeah.
Because we're
I was
all
gonna
over
say,
in
I
the
always-
legal niceties. It's like because we're doing the flow charts. You know, well, if we go to this part of the flow chart at 3AC sub I, and the third word therein, we know, well, we got that element. And
Oh, so,
yeah,
oh, sorry,
that's not
Kurt, go
just not the non-lawyer reaction. Where self-defense good.
Well, it's also like one of the other reasons why I love when we go on Eric Hunley's channel on like every other Friday is like, because we'll go off and we'll start like rambling off about something, and he's like, actually, I don't understand what that term is. And then we're like, oh wait, okay, other people probably don't also. And it kind of is a nice reminder to like kind of slow down and like define a few things for people.
Here, Eric sent me this, and let's do this real quick. So, Kurt, I don't know how much you've been following along, but this is from the amped software that was
Ooh.
used to make the video edits. This is from their blog on can AI be used for forensics and investigations. So this is from their forensic image and video processing. So here we go. Investigative versus evidentiary use. Image and video forensic software is normally used for two very closely related applications as a tool to get investigative leads, tool to analyze data to be presented as evidence in court. I already expressed the concept in a previous article. When you're doing image enhancement in the investigative context, you're just trying to get a clue to the footage, blah, 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 blah. When you're working in a judicial context, your work must be ready to eventually become evidence to be used in court. Hence, your process must be more rigorous and formalized. Many of our customers use our tools mainly for the investigation phase, but we obviously design them for the most stringent and demanding evidentiary use. The pitfall from the division above is that often the lines between investigative and evidentiary contexts are blurred. What was initially used as a quick investigation hint may become the strongest evidence, and if the work was not done properly since the beginning, can turn things into a huge mess. Furthermore, even at a purely investigative level, getting on the wrong track can be worse than having no information at all. So there's some doubt.
Scroll down. There's a highlighted sentence, a bold sentence that is very important, where they say flat out, should not be used. Hold on. This is the enhancement part where they're talking about it. And I believe they go into
Here we go.
introducing.
According to the above. Oh, hey, we've got real quick. Let me add guys, I'm very sorry. I'm going to bring a bunch of Wisconsin into this stream. So let me,
order, I'm sure.
Let me do that. And I would like to welcome to the stream, Mr. The Quartering.
Come on.
Yeah.
I'm just
How's
here
it going, buddy?
it's going well. I mean, I'm just here to wreak a little havoc. And
that was my favorite part.
Yeah,
Your Honor, I want to throw this man off the panel. He's coming in here with a fake accent, Your Honor, trying to cozy up to us good Wisconsinites.
It's so sad because closer to you, that's a correct accent. But we don't like, I'm in southeastern Wisconsin, so we don't go behind the snack shack and look at a tallywhacker.
But you're closer to Kenosha then.
Yeah, 15 minutes out. Yeah.
Oh, okay.
Which is a
a
foreign
foreign
land.
country from where you
Yes,
live.
you're in a
apparently.
foreign land.
Yeah, I do.
So you're farther than Antioch.
I'm close. Yeah, right. I'm closer than the foreign land of racing.
So can we get, I mean, this may be a hard admission for you. This is we asked the tough questions here, but are you actually who shot 2.5 people in Kenosha that night? And was it actually you in the video?
Look, I was just out walking my dog, and you know,
they all say that. They all
Pinch and
say
Zoom
that.
says otherwise.
I fought like a man, and I didn't use my weapon.
Yeah. Look, everybody takes a beating sometimes, I guess.
Don't we all? Lord knows I have.
Yeah.
You know what? My thought was
I didn't even think of it.
I was like, my thought is that's not really true because some people have guns. So no, not everyone takes a beating sometimes.
Right. Yeah, some people just pull out the gun and shoot the armed assailant. Okay, so about what we were talking about, this is the software that they used. And so this is, according to the above, image enhancement with AI shouldn't be acceptable in general for evidentiary use. So
that would have been helpful for them to bring up. That's all I'm saying. That'd be very helpful. Oh, here's their own site. Read this line, Your Honor.
I think with the combination of having an expert who disqualifies himself, this would have been beautiful to bring up. It's like, wait, so Your Honor, we have on their own blog them saying this shouldn't generally be acceptable for evidentiary use. And here we have this guy who's operating the software who can't tell us how any of it works. I think when we combine these two, Your Honor, this has to go. This has to go.
The least expert experts ever admitted to a jury. I mean,
there was that cop earlier who pulled up everything off Twitter and YouTube.
This guy
was a pretty good expert.
No, that guy, he might not have been expert in like that particular area, in that particular element that he was testifying about. This guy who's supposed to be the expert, he's literally like, well, I bought Photoshop and I just finished paying. I got my subscription to it and I put in the product key number and then they say, okay, click here. And that's what I did. So,
I just pushed the magic autocorrect button and it worked.
And in his testimony, I mean, somebody can just go back to that footage and then pick out all the times when he said, I don't know. And it's going to be at least a handful of times.
I think it was close to 15 times that he said, I don't know. It was a lot. It was a lot.
On basic things about how it operates. That's what makes him so inexpert. It's like, okay, when the pixels get separated like this, is it gonna change? And you have blue here and red here. Is the middle one gonna be blue? I don't know. Is it gonna be red? I don't know. Is it gonna be purple? I don't know. That's insanity.
Well, what
that
do you know?
I don't think that resonates with the jury anyway. I think all the nitpicking about AI, and I think most people understand zooming in on their phone. Like you guys, as an invoice of lawyers, you're really interested in that. But I think most people in the jury, they probably didn't care about that.
Well, that's what we're arguing, is that they shouldn't have allowed his testimony at all, because the
Yeah,
first
yeah, yeah.
argument about it happened in front of the judge. The jury's not in the room. When they have their objection, they say, hey, this guy, he can't tell us how many pixels are being added. And this is exactly why, because of what you're saying, right? The jury
Mhm.
goes, I pinch on my phone, I look at my kid, and I get their face bigger, and everything works great. And so they're saying, Your Honor, we can't allow this evidence in. It's prejudicial. Because it's going to show something, or they're going to be able to say it shows something that might not actually be there, and the jury's going to trust it because they trust zooming in. So, yeah, I think I agree. I think it doesn't matter to a jury, and they were probably zoned out during that questioning because they're bored, right?
That was
Oh, no.
brutally technical. And it was like 3 people who didn't know what they were talking about very specific things. And you can just smell that. And there's no way anyone on that jury was dialed into that. No way.
Jeremy, I did see your videos on the defense and the prosecution's closing. I didn't know if you did a video on the rebuttal, so I wanted to ask you about your impressions of it, because to me it just sounded like angry man angry at jury. So
real quick before that, sorry, I have to, there's an ad that needs to run for CVS Pharmacy on the stream. Welcome, Mr. Ron Coleman.
Hello, Ron.
How are you doing?
Is he in a full body cast?
No, it's just ice.
He had a wisdom tooth removed.
It's just unbelievable what my jaw looks like, what my chin looks like. The only reason I'm checking in is not because I have anything to add at all. I just want a better seat.
Jumping to the front of the line. I'm sorry, Jeremy, I didn't mean to cut you off.
Oh, no, you're fine. You're fine. Hey, by the way, congrats on all the success of your stream and suckering all these people into subscribing to you. Wait till they see where your real content's like. I thought the rebuttal was, for a guy that only worked 20 hours as a lifeguard, and by the way, only 20 hours. I thought it came across as, if I had to define it in one word, it would probably be sweaty. I don't think he seemed irritated and seemed to talk down to the jury, in my opinion. Frustratingly, they let some mistruths just slide by. There are no left-handed and right-handed weapons, which is absurd. And they could have just made him look bad if they just had said something, but maybe they were using the whole don't interrupt your opponent while they're making a mistake. I have to hope that they're playing 40 chess, because I thought they had a couple opportunities to dunk on that guy and didn't do it.
No,
yeah, I can't imagine that the
that.
jury saw that no, the comment about no, the guns don't have a handedness. Sorry, if I can spit it out. I think that comment, I can't imagine that comment played well with the jury when they actually just saw for themselves an example of why that particular gun would not work well in the opposite hand.
Mm-hmm.
Well, if you're going to inject the casing into your face, it's probably a relevant thing.
Right.
Yeah,
right.
Well, maybe. I mean,
cause
only if you don't want casings in your face.
I knew that. I knew that was coming. I knew it, literally.
Well, at least he didn't point it at the jury.
It's not just a matter.
I know
though,
that's the other thing is when Binger frigging pointed the gun at the jury. That was the first time.
Baldwin.
Yeah, right. Well, when I was my 1L summer, I interned at the public defender's office. And I remember the very first trial that I got to observe, that was like one of the biggest benefits there was getting to observe trial. First one I did, I saw in closing argument, the defense counsel, he pretended to have like a bow and arrow in his hand. And he was trying to illustrate, I think, some kind of attempted homicide or something. And so he's like pretending to draw back the bow and arrow, but he's pointing it directly at the jury as he's doing it. And all of us were just kind of sitting there like, why are you threatening the jury? And then I think he ended up just completely bombing and totally lost that case. But I don't know. I mean, I wonder if maybe like in the moment, Binger was just like, yeah, this is a fantastic idea. I want them to feel threatened the way that they thought maybe Groskowitz felt threatened or Rosenbaum felt threatened or something.
That's the ultimate Hail Mary. If that was the strategy, that is the ultimate Hail Mary. Like, let me scare the bejesus out of the jury to get them to go along with me. That's a real risky venture there.
So we have some conflicting reporting going on earlier. It was mentioned that the jury had requested 11 additional copies of the jury instructions, which are 36, 37 pages, right? There's some conflicting reporting coming from a Fox News multimedia reporter named Giovanni Leggi, Lieggi. I don't know how to pronounce it. Sorry, I'm not that Italian. But he says they only asked for the 11 additional copies of only pages 1 to 6 of the jury instructions, which he asserts are the pages that lay out the self-defense privilege. Now, Mr. Ken Jennings, Kiwi Farms Ken Jennings, has suggested that he has the PDF copies of it. And so I've asked him to send them to me so we can take a look at the pages 1 to 6. But if that's the case, that would be, I don't know if that's the reason stated, but if that's the case, that they're only looking at self-defense, that makes a pretty interesting sort of
honestly,
twist to that.
I think that could go either way, because that ultimately is the heart of the case, right? Or, well, I mean, maybe that is a good thing, because maybe they did hear what Richards was saying in his closing argument, that he said, at the end of the day, this is about self-defense. That's what you need to be deciding. And if there is self-defense, then you need to acquit on all of these charges in each instance if there's self-defense. But I don't know. But then again, they could be deciding that there wasn't.
Hey, I'm gonna. I don't want to take the spotlight away from all these brilliant minds. So I don't want to hang out too long, but I wanted to, maybe not now, but down the road, I thought there are two things I wanted to get your guys' opinions on, and then I'll dip. But one was I felt like in their closing, in the defense's closing, I felt like they didn't do a great job being very clear that they wanted a acquittal or not guilty verdict. I think they kept using, I thought the words they were using, I forget what the exact word they were using. It was kind of like when they were talking about red herrings on the prosecution side. Is there a reason that they didn't just say, look, hey, if you believe, they didn't come right out and say, if you believe that this was self-defense, then you must acquit. Is there a reason they didn't say that? And two, do you guys think I actually don't think jury will come back today. Do you guys think that that'll happen?
No.
I want them to desperately, but I don't know if it will.
I think it'll be by tomorrow, or they're going to be hung. That's my thought.
You're Jeremy, you're right on that. I question the privilege. They kept using the word the privilege of self-defense, which kind of bothered me in a way, because a privilege means something is given to you or bestowed upon you. And I would almost think that you'd want to push it as a right. Like I have a right to defend my life versus a privilege.
I think the reason why they did that, though, was because they were speaking to specific terms that are in the jury instructions. Because you're able to then get the jury to connect what they're saying in their closing to the actual jury instructions, because privilege is a word that comes up there.
Right. I understand. Yeah. I'm just trying to think as just a person who doesn't think legally, going, privilege.
So I mean, they maybe should have explained what a legal privilege, what privilege means in this case. Privilege does not mean that they have the opportunity to it. They probably should have said on their close. Privilege means that when they are acting in self-defense in good faith, then they are protected from prosecution by that privilege. That is what the privilege means. It is, in a sense, enacting a right to self-defense so long as they meet the required criteria. Maybe, but I don't know that getting into the weeds too much on it would be super helpful. But I think they are mirroring the jury instruction. I mean, I think that's the language that they use, and that's probably why they're doing it.
Yeah, because at the end of the day, those are the words that they're going to take with them into the jury deliberation, and they need to be able to apply that to something.
Yeah, so and it's a real shame that the social media has co-opted the use of the word privilege from us brilliant legal scholars.
Yeah, well, they would ascribe it to Kyle right now. Of course, he has that privilege.
Yeah, they want to use that word privilege quite a lot. See, he is privileged. We said so the whole time.
Okay, so let me pull this up, because this, I think, is instructive on what they asked for. If it's correct that they're only asking for the first 6 pages, and of course they could be asking for the first 6 pages now and then asking for other pages later. But here we go. So this is the jury instructions, the final copy that was filed just yesterday.
Cool.
And it starts off with the opening instructions. Information is not evidence. Here's the charges. And then the first thing, privilege of self-defense, is right here on page 2 and goes to 3, no duty to retreat, provocation. And then here's the intent, 4, 5, and it goes into part 1, 6.
Didn't the judge, or wasn't the instruction though that you find on the first one before you go any further? If you find
before you go,
agree?
kind of on the lesser includeds is what he was saying. The first, but the first count doesn't have any lesser includeds. But this, and I'll puff myself here. This speaks to my theory that of the case entirely is that everything hinges on the shooting of Joseph Rosenbaum. I think if that is justified, then every other action that Kyle does is justified at that point, because at that point he is under threat and he is trying to then get away. And I think the jury is going to be in that mindset. If he's not justified in shooting Rosenbaum, I think he loses everywhere. But I think the jury might have to have questions about the remaining counts. Like, did he become justified? I think they come to no as the answer if they come to no on the first one. But I think that first one is just the most critical aspect of the case.
I think Richards covered that too, because he said scene 1, scene 2. He tied it in like this is the one film, the one incident, the one movie, or one show. So it's all this show. So whatever happened there initiated the rest.
I think you're making a good point, Eric, and I think that he actually made a mistake on that element in that he said if Kyle sticks around there, in that case he's gonna scene 2 happens at the car lot there. And I wouldn't have phrased it that way. I said, if Kyle sticks around there to treat Rosenbaum, he's dead. He would not have survived that. In order to just remind the jury as to the extent of the grave threat that he was facing in that given moment, rather than just saying, well, okay, he would have ended up killing Huber at the station. No, I don't think that happens. I think if he stays there, he's dead, or either he's dead or a lot more people are dead. So
yeah,
or both.
And they got to that a little bit with if he would have taken his gun, he would have shot someone else. And again, I think this is a fair criticism, is he kept saying that he would have shot someone else, more people would be dead that night, et cetera, et cetera, et cetera. Instead of he would have shot Kyle Rittenhouse and then shot other people. He would have gone on. This is a man who was trying to enact violence the entire time. And remember that this was part of the theory of their case. And I think was even brought up on opening, that he was trying to steal the gun because he couldn't get one. Joseph Rosenbaum was prevented from owning a gun, so he had to steal a gun. And Binger took big exception to that, saying there was, no evidence of it. But
other than the lying in wait and the ambush and the trying to grab the one guy, he didn't do it with others. He had an incident, and Richards kind of went over a little at the other place. There were more than one. There were more than one individual with an AR-15. And he couldn't do it. But Kyle was by himself, so he was separated from the herd. Rosenbaum ambushed him. And that does fit that theory of the case, but I don't think he really drew it out well.
One of the things going around on Twitter to my lawyer people, not to exclude you, Eric. Oh my gosh, that was rude. But to the lawyer people, people are asking if Binger committed 18 different criminal acts yesterday in trial when he pointed a gun with his finger on the trigger at 18 members of the jury.
Misdemeanor.
I mean, that could be argued as provocation, can it not?
I'd be pissed if you pointed at a weapon.
Not just provocation. It's specifically a criminal act to unsafely handle a firearm in a way that puts others in danger. Now, we'd have to analyze it.
I don't remember if it was Runkle who pulled it up or someone pulled it up and said that actually in Wisconsin, that is a crime. And and you need to rely on self-defense. So it technically was a crime. And like all the crimes that were being committed before Kyle was engaged in, you can expect it's just as likely that crime will be prosecuted. So
I just wish somebody jumped out of the jury box onto Binger and took him down. That would have been funny.
That would have been grounds for a mistrial.
but it would be justified.
Yeah.
And it would be self-defense.
Yeah. Oh, jeez.
Oh, excuse me. Yeah, but I mean, I think, I think one of the state qualification. First of all, you got to realize that it'd be his office prosecuting him, which they're never going to do. Second of all, the qualification of the defense argument for that would be this gun was checked. It was completely unloaded. It was not only was it unloaded, there's no ammo sufficient for that weapon in the courtroom at all. That would be the arguments that they would make. We saw how well that worked for Alec Baldwin in not shooting someone, but
Exactly.
you know, that would be the thing. I do think that the law in Wisconsin requires endangerment as an element. And if that's the case, the jury didn't seem to be in any danger other than apprehension. But they
Did
may
anyone duck? I'm curious.
I don't know. They may have
I didn't
civil.
see the jury.
We can't
Like,
see
it
the
could be a
jury.
civil
Yeah.
court.
I don't know. If I'd be kind of a little like
That's a
That
that's a
would be-
civil. It's a civil.
That would be kind
assault.
of funny. That would be
It's
kind
a-
of funny if afterwards if they acquitted Kyle and then afterwards there's a lawsuit filed against Binger.
18 counts of civil assault, common law assault. That'd be beautiful. That would make my day. The state's attorney's office would basically have to settle that out. I mean, they'd argue a litigation privilege, I guess, but I don't think litigation privilege would ever extend to a physical threat against a juror by the state. That doesn't seem fair. You get tort immunity from it. Or would he have qualified immunity?
I don't see
do you
why.
really think he's qualified? I don't think he's qualified to handle the weapon.
If you saw the way he handled it, yeah. It should be a strict liability. It really should be strict liability. But
That'd be funny. Catherine H says, did we cover this? What do you think Backdoor Binger and Big Boy's reaction will be if Kyle's found not guilty of all charges? Will they have a public meltdown and argue with the jurors and the
Yeah,
judge?
we went over that.
Probably.
Yes, we did. And I think the consensus is yes. I think he would go on a media
Krause
tour.
would.
I think, well, I don't think they'd put Krause on TV, but I think they'd put Binger on TV. And
Yeah, and he would just have his shoulder right over Groskowitz and say like, "Yeah, we did everything properly.
we're co-writing a book.
Exactly.
How two lovers found themselves through the court system would be the book.
I wasn't implying that.
I was. I think that's the best title they could come up with. That book would sell millions.
I dropped a Babylon B story in the private chat if you want to take a look.
Oh, you can you? I've
Or
got
actually-
the court feed. I've got the court feed shared. So if you
Oh, no, I get it.
yeah, if you share it, then I don't have to redo it every time. Kylos Rex says he doesn't have a motive. Know why? He's not lying. Members of the jury, the prosecution's not going to get Kyle today. No, because I'm going to get the prosecutor. Your Honor, my opposing counsel, Mr. Binger, should go right to F-word jail. The son of a bitch is guilty. Here we go. How is the Babylon Bee the funniest publication that's out there right now that does any of this type of content? Like The Onion used to be funny, and they stopped.
They're not woke. They just do humor, and it's funny. They just put it up there. I mean, good lord.
Oh, that
is a pretty
beautiful.
inspired article there.
It's pretty good.
Oh goodness. Richard Sparks says as Tucker Carlson, which I can't do a Tucker voice, but he says what the Rittenhouse trial taught us. Tucker's video from last night talks about the stream takedowns yesterday. Yes, he did. He didn't mention the stream by name.
Except he
but
definitely got his facts wrong because he said only hundreds of people were watching.
I was trying to decide if 77,000 people qualifies as hundreds or if it necessitates.
I mean, it's hundreds
thousands.
and hundreds and hundreds.
Maybe you thought it was my Friday streams with you guys.
Yeah, I corrected him when I tweeted it out there, but I think that those of you who joined late here, I think that Nick got a makeup from media at large with the I'm going to read an article to you here that I stumbled on.
Oh, come on.
Let's do it. Let's do it. Are we gonna embarrass Nick? Let's do it.
You stumbled on it? You mean you found it when I mentioned it on stream?
Google owned YouTube censored, then reinstated independent streams of the public trial of Kyle Rittenhouse, including the popular Rekieta Law Channel stream over what Rekieta Media says was a, quote, BS copyright claim. Live footage of the trial is publicly available and cannot be copyrighted. It appears that YouTube quickly reinstated Rekieta's law stream, but not before it interrupted the experience of roughly 40,000 viewers who had been viewing it. Quote, we're back up.
More
I
than
wonder
that.
if they interviewed you. Did they?
It was 70,000 then. We
Well,
lost
we lost
40,000.
That's what they're saying. We
No,
lost.
we're back
okay.
up. YouTube dropped us by 40,000 viewers over a BS copyright claim because they're literally paid for by the media, said the official Twitter account of Rekieta Media in a statement. Quote, there is no copyright issue here. YouTube is just shutting down independent creators. And then they include a quote from Jeff that you were quote tweeting Jack Posobiec. Rekieta Law is one of the most popular legal channels on YouTube. I guess you are. You are one of the most popular legal channels on YouTube with over 260,000 subscribers. You got to be at 300 now, right?
Last I
checked,
you're
you were close.
275.
Yeah.
But here, look at this. Here's the thing with view counts in general. So
Yeah.
we have 63,000 live viewers, which is amazing.
Oh,
the
sweet.
poll I put up at the beginning of the stream has 108,551 votes. So
People coming in and out.
yeah, unique viewers is way vastly different than what happens. So
I'm not finished. Rekieta
trying to
has
cut you
called
off.
out the media for lying about the Rittenhouse case and anticipated that the prosecution's attempt to charge the teenager with unlawful possession of a firearm would fail, as it did when the judge dismissed the charge earlier today. In a video ahead of the trial, Rekieta slammed the media for referring to the rioters who attempted to assault Rittenhouse as, quote, protesters and, quote, marchers. Quote, these were not protesters and marchers. These were assailants. All three of the people that Kyle Rittenhouse shot were in the process of assaulting him, said Rekieta in the video. Quote, the question isn't even about whether or not they were assaulting him. The question is whether the assaults and the response were justified under Wisconsin law. Breitbart News has reached out to Google for comment. They don't say if they reached out to you for comments. That's what I wanted to know. Did they talk to you directly?
They did not. They may have called me. I don't know.
You were just too busy with the chat.
Where's Breitbart located?
It's Andrew Breitbart's organization, so California, right? Because LA, Ben Shapiro was editor at
Well, he moved to
large.
Tennessee.
Well,
The
no,
reason
that's
I
Daily
asked-
Wire. But
Yeah.
I'm
I was-
talking about Breitbart.
I was watching TV with my wife last night before bed. It was about midnight, and my phone rang, and there was a phone call from Washington State, I think it was. And so I didn't answer because I was like, oh, midnight, I'm not answering a damn phone call. but like, so they could have potentially reached out then.
They
but,
didn't leave a message. I feel
No,
like,
no one
I feel
left
like
a message.
that would warrant leaving a message.
Yeah, that usually helps. Or text first and say, hey, this is blah, 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 blah. Can I call? That's always a handy thing. Folks, I got to go back to my day job. I'm
Oh,
not a
don't
slack
leave.
lawyer.
Give me just a second. Guys,
Yes, sir.
this man, Eric Hunley, operates a fantastic YouTube channel. An absolutely fantastic YouTube channel. He brings in
two, right?
Like two,
Yeah.
but I'm talking about the main one for now. He brings in a diversity of opinions and personalities to host excellent panels. He talks about subjects that you can't find anywhere else, and he does so either intelligently or with intelligent company, whichever one seems to fit the operation. Guys, it's content. We all talk about legal stuff. Eric talks about legal stuff. He brings on lawyers. He talks about media stuff. He brings on media people. He covers all sorts of subjects that are fascinating.
Carol Baskin. This guy interviewed Carol Baskin. You
Not
need to
only
go back
that-
and watch that interview because
the
Nick
best
sent out
super
some
chats
super
ever
chats
given
that
during
will
the interview.
make you cry laughing. That for Eric to read out asking Carol Baskin certain questions that were pressing and that were that
Questions
Nick
that we're all thinking maybe.
Look.
Nick wanted answers for. And
Look.
yeah.
Maybe we needed to know if the bones came out in the tiger's poop or whatever. I can't even remember. But go
No,
check
she
out
said,
Eric Hunley.
When my
He's
husband
linked-
went missing, I think what happened was she said when my husband went missing, and Nick super chatted went missing. Where'd you? Are you still looking for him? Maybe check inside the tiger.
Oh yeah, that's what it was. But
since I lost my husband, did you check inside the tiger?
I might have been cursing at Nick a little bit under my breath as I was trying to keep her on the episode and keep her talking about Don Lewis all the time, and miraculously she did.
Well,
But,
my
yeah.
favorite part was I know she read that chat. Like you could see her see it, micro react for a second, and then go back, and it was
And
like
her phone kept ringing. Nick, didn't you
Got her.
notice her phone kept ringing?
got her.
That was somebody saying, "Shut up."
Anyways,
Anyway,
guys, Eric
thank
and all of the panelists. Well, except I don't have the quartering in here yet. I guess I have to link that little tiny channel.
Little baby channel.
I forgot to shill at Jeremy that he needs to add me on Twitter, and that's never going to happen. It's never going to happen.
Eric's channel, quartering, everybody's down in the description now. Just click on their name. It'll take you to their YouTube page and check it out. Eric, thanks so much for coming on, man.
sir.
Ciao, Eric.
See you, Eric.
All right, now it's only lawyers here again. Okay. We're
now
not
let's
tainted.
stop.
Let's get back into
We're not
real
tainted
talk.
by natural, real, wholesome people, and it's just us slobs.
Now that there's no one for us to make feel awkward, let's stop talking about the law. Right? Let's do that. With that, I've got 2% right. Says, just wanted to pimp while we wait. The upcoming Sci-Fi Con in Lebanon, Tennessee, Confinement 3.0, weekend of February 25th, small, chill, casual convention with authors like Michael Z. Williamson and Stephanie Osborne. Confinementcon.org. No mask, no vax, no problem. So there you go. If you're into sci-fi and want to go to Lebanon, Tennessee, which is better than the actual Lebanon, from what I hear.
Infinitely.
That is Confinement Con. The Dragon's Treasure says, speaking of small businesses, I'm closing in on making $10,000 in a month, a major milestone for me. I couldn't even make that in my first 2 years. Help me break this barrier. Coupon code is 4 doors more whores.
Nice.
If you like loose leaf tea, which I very much do, and he has great ones, like a ton of variety, legitimately. The dragonstreasure.com, which is a haven for tea and anime lovers. But don't hold that against him.
I was so excited to buy it last week, or I think it was last week. I don't know. I can't tell time anymore after this case. But recently on one of these streams, I was like so excited to buy it. I totally forgot to put in the promo code. Oh well. But no, he had a really good selection on there. It was like I think what did I get? I got some kind of like Christmas flavored one, because that's typical me. And then the one that was like on the front page, the everything changed when the Fire Nation attacked.
Oh, okay. I don't know which one that is. All I will say is Elixir of the Gods is really, really good. It's really good. So that's my personal endorsement of the week on that on Dragon's Treasure Tea is Elixir of the Gods. I could drink that stuff like water. But next we've got John Wells says, I'd have a phone call, go back to the YouTube app, and it would completely reset everything, then had to find you in history. Yeah, we showed up on KidsTube actually at some point yesterday.
How did we show up on KidsTube?
Or YouTube Kids, I should say. But yeah, I don't know, because all of my streams have the same thing. No, it's not made for children, but no, do not restrict it to people under 18. Because if you do that, I mean, you kill everything. But if it's not made for children, it's not supposed to go to YouTube Kids. So that I don't know why that happened. I have no idea.
What were they sharing on? They weren't mirroring your stream. What were they doing with it?
No, it was the stream showed up in the YouTube Kids thing, and then the recommendations that followed were kids shows. It was very odd. It was very odd. So I hope some kid got a legal education yesterday. That would be good.
Speaking of kids content, I was a little bit surprised that they didn't put up more graphic imagery in the closing.
I was
The
too.
prosecution.
Yeah,
I thought they
we
were going to go over all of those autopsy photos. I was ready for it, and it didn't happen.
Yeah, this is a good opportunity for us to talk about strategy and different moments, like legal strategy, which is not even about. I'm not even talking about the whole thing about the flaws of objection, but just as far as like approach to handling different elements of the case, or things like you just brought up, like the strategy of throwing things out there. I think is really interesting. Yesterday we actually saw a debate on our panel here that I noticed, and it's sort of it never got called attention to, where when they were talking about referring to whether it was better to attack Binger individually, whereas, which I think is what Viva was saying, that it's good to go after Binger directly, whereas Emily
was
Baker
saying it should be the state.
Yeah, Emily Baker said make it about the state and the government. And I actually was rolling that around in my brain, which is better, to go after Binger directly or reference the state, the dark state. And I wanted to get your thoughts on that before I tell you which of you were right and which you were wrong. So
I will happily do so, but let me first say people are asking if it's good or bad that this is taking so long. I say it's completely neutral at this point. This is a complicated case with 5 different counts, and several of those have sub counts. So we're not talking about an easy 20-minute decision unless everybody walked into that jury room and just said not guilty to everything. You're going to have some debate. And welcome to the show, Mr. Matt Wilson.
Hey, Matt.
How are you doing today?
It's at Lawyer Matt on Twitter.
That's correct. I'm having a little bit of an issue with my earbuds right now. For whatever reason, it is not picking up.
That happened to me the other day.
Don't you hate it when that happens?
Yeah.
Are they communist earbuds? I mean, is that possibly the problem?
It could be. I hope y'all aren't hearing any reverb. If they are, I'll jump off.
They all come from China, don't they?
You sound good, actually. So on our end, I think we're okay.
Okay, good.
I mean, you're echoey, but that I think is the room you're in more than anything. You're not echoing us. You sound echoey. You should get a whole bunch of foam and put it around everything you own just for when you show
ignore
up
him.
here.
You sound
or
very,
just a blanket,
very alluring.
put it over
you sound very,
Thank
very
you very
alluring. Okay.
To Joe's question, Matt, did you get a chance to watch the closing arguments?
I watched some of it yesterday, not an awful lot. And the reason I didn't was because I was working on a big case that if I told you about it, you might get demonetized by Google. So
Yes, it's a fascinating case, and I wish you a ton of luck. We've seen some good results from some courts on those types of cases in the past couple days.
Oh, gosh, yes.
This is about various medicines, I assume?
Yes, it is, in various orders.
And maybe the forced application of them.
I wish upon you God's blessing in doing the Lord's work.
But the question that Joe is proposing is in closing arguments, they went after Binger, the state's attorney Binger, on credibility issues and stuff like that. But the question is, was it wise to go after Binger personally, or should that have been an approach of going after the state itself rather than Binger as an individual?
Well, my thought on that is when you are fighting for the life of a 17-year-old boy, I mean, you don't want to leave anything on the table. And let's face it, the defense left an awful lot on the table when they didn't object to stuff. I mean, if you're going to keep the attention of the jury, sometimes saying stuff like that works. Now, I think a lot of it was to try to rile Binger up, because the gang knows that if he gets riled up, he's going to take it personally. And then when he takes it personally, he's going to say something really stupid like, you shouldn't. Well, of course, it wasn't Binger who said this, but was it Krause? Is that the name of the other DA?
Mm-hmm. Mm-hmm.
I mean, when he said that stupid line about he was a coward for not putting up his fists and fighting, I'm thinking, I'm sorry. Look, I'm not the lightest fella in the world. I have a little bit of a weight problem. I'm not in good shape, but Krause probably has never gotten in a fist fight in his life, so he probably don't need to be talking.
He might have been in fist fights, but they probably were one-sided.
Well, probably
So.
one-sided. That's usually how it was with me. But the point is, that just shows the level of naivety. If a raging mob is coming after you, you're going to defend yourself, and you're going to use the best methods that you have to defend yourself. And apparently, the district attorney is not mindful of that. But I think riling them up they had nothing to lose.
But no, the real question here is, I think we're all on the same page as far as the strategy of going after them, after the tactics of being so dark and shady, nefarious, and constantly shifting to whatever they can try and fit a claim against them. But the question really is it strategic? Do you think it's strategically better for them to attack Binger as a person for the way he conducted this case, or to attack the state at large, the government at large, and make that your focus in order to say, yeah, this is your classic evil government doing what evil governments do, and make it less about Binger on an individual basis? That's
in general, I would defer to trying to just go after the state. But I think in this case, Binger's behavior was so out of line. I think it needed to be called out, because, and this is the thing that I would have been reluctant to do that down here, because I know my judges would have put me in my place. I was very surprised that the judge says, "Oh, it's just argument. Let him go on." And I mean, just let the boys fight. And so he got away with it, and since he got away with it, I think it was a.
You think strategically it's better to
I think it was strategically better in this case since he got away with it. Now, I'm speaking with hindsight, because, like I said, if the judge had slapped him on that objection or slapped him for that behavior, it would have certainly backfired. It's kind of like, when it's 4th and 10 in football and you decide to go for it and you actually making a 12-yard run, you look at it and think, hey, that's a great job. But then, if you had missed it, well, you'd be firing the coach. So, but in retrospect, I think it was a good idea.
I need to step away for just a few minutes. I'll be right back, though.
All right. So, Legal Bites, what are your thoughts on this?
I think I'm thinking that part of it might also have to do with the demographics that we're talking to, because if you have jurors on the jury panel that are they tend to be, government friendly. They have no real reason to dislike the government. That they might be like, really, the whole state, the whole government, everybody's doing that, but I see this guy right here that's a total slime ball, but I don't know that looks like it's everybody in the government is playing this narrative. But on the other hand, there are plenty of other people that are very distrustful of big government, very distrustful of the state in general, and so maybe that would play well for them, better than turning it into what could look like a personal attack. That, like, this is now turning into, these two lawyers hate each other and are going out for each other, when that's not what this case is about. Like, there's always a risk of that. So I don't know. I mean, I do agree. I think that in this particular case, I think Binger and Krause ran this really too dirty, to really let them slip by. And I think that this was probably a proper case where, like, they ran it dirty enough that I think it probably warranted calling them out as individual attorneys.
So I agree with both of you, and I'll explain to you. I want to give you my perspective as to why calling out Binger individually was uniquely important here. And it touches on what you were just saying now. You need to put yourself in the mindset, or the responsibility of Richards is to put himself in the mindset of the last couple of jurors who have not been sold by all the video evidence and all the forensic evidence, which shows that it was justifiable self-defense under the law. You're trying to approach the mindset of someone who came in here with a pretty strong leaning against Kyle, thinking he didn't belong on the streets there. This is not someone who's going to be a based conservative. It's going to be someone who's at least leaning left. And someone today, in today's culture, who's leaning left, they have very strong worship of big state government. That's what they're hearing on the left, is how government is protecting us. They're saving us from the pandemic. They're, everything. There's a very strong mentality that's pro-government from the left today. So if you're trying to appeal to someone who is on the left and you just start implying like, oh yeah, it's like there's another case of big government trying to trample over the little guy, that is not an argument that's going to fall on deaf ears to someone who's anywhere left of center. And that's why if you make it personal, you don't make it like, oh, you're not going to be viewed as a conspiracy theorist that government is bad, which is what the left will look at you, but you just say, no, this particular DA's office, they're really corrupt in the way they handled this particular situation with Kyle Rittenhouse. And here's how, and here's where you see it, and here's the different steps that they took. And this way, I think attacking the government in that scenario, you're not hitting your target audience. Your target audience is the people who are not yet convinced, as opposed to people who are already convinced. And your target audience is likely to favor government, and that's why I think making it personal on Binger is a more powerful way to approach it.
You know, another thought, just I'm sorry.
Go ahead. No, go ahead.
Well, the thought
I had a
crossed
thought
my
too.
mind-
So
well, I had a thought that just crossed my mind even as we were talking, and that is, imagine for just a moment that you are on this jury, regardless of your political persuasions, regardless of this, that, or the other. Okay, most people don't want to be on a jury, and they sure don't want to be on the jury of the one case that is being viewed all over the world right now. And because they don't want that pressure, they don't want that stress. And it's a lot easier psychologically to blame the kid for even just showing up in the first place with his gun, because if the kid had just stayed home that night, they wouldn't be there. Okay. Mm-hmm. So from their standpoint, they probably, from Rittenhouse's standpoint, even though he is presumed innocent, even though he is, under the law and the jury is supposed to have this clean slate, they're bound to have a bias against him, just because of the fact that if it weren't for what he did, they wouldn't be wasting, 12 days in trial and not being able to watch anything they want on television and having to deal with this stress and having to deal with their mouths being shut and all that kind of stuff. And so they go in there with this bias against Rittenhouse. And so if you're going to counter that bias against Rittenhouse, you got to create another bad guy. And the other bad guy is Binger.
And it's not just, I think those stresses you mentioned are important, but even further stress is the stress that they themselves and their families can be put under public pressure and be doxxed, be punished, be canceled, that if they come out with a decision here, they're put into this box now where they either throw this kid in jail. And it's a tough spot for someone, that you either put this kid in jail or that, hey, my name might come out there as being one of the people who acquitted Kyle Rittenhouse. And that's something that there could be some crazies out there who are going to be really angry about that. And that's a stress. Who needs that stress in their life? That's a stress that none of us have ever dealt with.
I do.
Well, Kyle can tell you the best places to buy
AR
for self-protection. He's got it down. He can take you to the store. He can help you out with your purchasing needs. He is 18 now.
Actually, no, he does not know. He only knows one place to buy ARs. They specifically asked him if he knew any other place possible, and he's like, "No, I don't."
I also don't understand the point of that question. If he did know other places to buy ARs, why does it matter either way?
Right. How
they're
does
trying
that
to
prove or disprove anything?
Some weird theory on he selected this evil gun, which is
I went to the gun show and I saw row of ARs, and I picked out this one because I thought it was the best for hunting commies.
I was expecting him to go, did you know that this is the same model of rifle used by the San Bernardino murderers? You knew that,
That's
didn't you?
the reason why you got it?
Didn't you? I've got a purported criminal history of Jump Kick Man.
Ooh. Well, that would
we have a name. We have a name on Jump Kick Man.
According to the Dan O'Donnell show, they have, let's see. Jump Kick Man has never been identified until now. And this is today. This is today. The Dan O'Donnell show can now report exclusively that Jump Kick Man is a 40-year-old black male from Kenosha with an extensive criminal record who was at the time of the Rittenhouse shootings on probation following a conviction for domestic violence battery.
So all the investigations in the world couldn't figure out who this is, but this guy, they figured it out.
They have not.
What a corrupt state. What a corrupt DA's office. They definitely knew who Jump Kick Man was, and they didn't want him on the stand. What a corrupt, evil government we have, or at least they have there locally in Wisconsin.
That raises an interesting point. What about? I mean, I wonder what Brady evidence is not being disclosed or hasn't been disclosed. I mean,
Oh, tons. I mean, how many conversations has Binger's office had with witnesses that are not disclosed, right? Like, because they're in the course of like their criminal charges. Like what conversations did Binger's office have with Zeminski's, for example? Were those disclosed to the defense? You know, Kelly Zeminski's case was pled out or whatever, but do we have any record of those conversations regarding plea deals? Like, did any of those occur outside of her presence, so that they're not, you know, I don't know. I'm just curious what is not being shared. Yes, the Brady evidence. Thank you.
I'm so angry about this. There is no way that this information wasn't in the hands of the DA's office months ago, probably within days after the incident actually happened.
So they don't name him in the article, but they do say that according to online court records, Jump Kick Man has a criminal record that dates back more than 2 decades with multiple felony convictions for car theft, ID theft, drug possession, escaping custody. His earliest conviction listed in the Wisconsin Circuit Court Access online database is for felony escape, meaning that he had already been in custody or convicted of a crime in the penal system. Blah 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 blah. So I don't know.
I bet they know who Yellow Pants Man is. Also, I'll bet they know all of these people.
Of course they of course they have access, unless they're a chaos tourist, right? But we all know that the only chaos tourists there that night were packing AR-15s.
Of course.
Right? Like that's the only people who are there chaos tourisming. All of the testimony about any of the rioters being from out of state came
friendly
from
couple fires just tipping over a porta potty or two,
which no one was in. It's like, how do you
burning down car dealerships?
Because to the panel, I'll throw this out there. If you were in a porta potty that got tipped over in the middle of the riot, would you jump out of it and tell everybody that you were in there, or would you hide?
I was assaulted by Joseph Rosenbaum. Putting in my head. Can we block Nick from his own stream? Jesus Christ.
That's an image I just didn't want to imagine there.
Well, neither did the person who was in the porta potty when he got tipped over.
That's true.
So
that would be pretty embarrassing.
I was assaulted by Joseph Rosenbaum. Yeah, I had drunk a lot that day, and I was having issues with my stomach, and there was that porta potty there, and I got in there, and the next thing I know, it's rocking back and forth.
Okay, no.
The long crime stream is blowing up.
I need a mute button for other participants in the channel.
People are saying the jury is back, but I'm trying to confirm.
If so, that's amazing.
All right, what's the over/under?
Well, then you would be right on the over/under, and I'd be off. But okay.
I don't see that the jury's back. I've got the court TV feed and the law and crime feed up, and there's nothing happening currently. So if they're bringing the jury into the courtroom to review video evidence, which is a possibility, then we may not be able to see that. Because it would unnecessarily risk exposing the jurors by camera. But no, I'm monitoring the feeds, and we do not see it. Court TV tweet has them back. Let's see. We'll have to follow. How many things do we have to follow? The law and crime feed is going just garbage. Checking court TVs.
McDonald's is going to offer the Egg McMuffin for 63 cents on Thursday. Can I order 100 of them and freeze them? They have breakfast forever.
The most recent court TV tweet was 20 minutes ago. Lunch break for the jury. Okay, yeah. Why do you get a lunch break in the deliberation room? Don't they just bring the food in? That's what they used to do. You just bring the food in there. So anyway, well,
in my day, they brought the food into the jury deliberation.
In any day,
where are you from? What century are you from? They got
the last one. Literally, the last century is what century I'm from.
Yeah, so
Same one you are.
Oh yeah, the same potbelly stove ovens they would cook up their lunch on, and then they would bring it in. I don't know where you're coming from.
What? But honestly, wait. So you're trying to tell me that the jury deliberation room, they're gonna have them leave the deliberation room to eat lunch?
I think they have a lunchroom.
Are you
that they
allowed
all
to
have
deliberate during lunch in the
No,
lunchroom, or is that just
there's
a
no
deliberation
talk
room
of,
thing?
of Rittenhouse during lunch.
Oh my gosh. Absolutely insane.
I got to get my
okay.
245 over. So, for my bet here with Nick. So yeah, sorry.
No way. Oh no, I actually fully accept that they're in the lunchroom and not able to deliberate. So we get to
Well,
take
that
an
sucks for
hour
you.
off of the time.
Sucks for you, brother.
No, we get to take an hour off because that
Hypothetical
245
question.
can't include lunch. What's up, Matt?
Hypothetical question. Is the judge going to send them home? Let's say they deliberate for multiple days. I mean, will the judge have to send them home, or will he sequester them and put them in a hotel room or
They'll go
whatnot?
home.
Or how late will they be staying in the courthouse before the judge says, okay, that's enough for the day, we're going to send you back? And does Wisconsin have a law on those in that regard? I know Tennessee had something a few years ago where, a case got set aside because the jury was stuck, in deliberations after 7 or 8 o'clock at night. And I'm just wondering if there's anything comparable in Wisconsin.
I have no idea. The judge has been reluctant to sequester them in general, but it's possible that he would. He didn't sequester them last night after everything was done, and he could have done that. So who knows? Who knows if they will sequester them or not?
I seriously doubt it. They're all going to be able to go home and surely not talk about it with anyone overnight. Yeah.
Of course not.
Yeah.
Never.
How's it going, honey? Yeah.
Right. Oh, let me tell you about work today at the courthouse. Noah Hastings says the jury already decided they just wanted that last free Asian food lunch.
Oh.
Rhonda Ernst. Oh, this is a great chat. Says, you just told a Midwest mom me to have your son take a beating like a man. If he dies, he dies. That is what he said. You lost any trust I may have given the prosecutors. That threw me over the edge yesterday. It was essentially over at that point.
Yeah.
Yeah, and that's a real risky gambit to any of the parents, moms or dads, I think, on that panel who go, because like me, my oldest is 14, and so it's a little bit different, but I cannot fathom myself in 3 years going, you know what, son, go be an activist, please. Like, I don't want my kid at any political rally like this or whatever, riot, let's call it what it is. I certainly don't want my kid at a riot at 17 years old. However, if my kid happens to be at a riot, maybe a riot comes to my town, I don't know, I certainly want him to be able to defend himself and not, quote unquote, take a beating in the street from a. I've watched enough video of people taking beatings at these riots from 7 or 8 people soccer kicking someone in the face while they're down on the ground, and I go, that's death potential in every hit. No, you can't just take a beating. This isn't a fight that a teacher's going to come break up in the high school, over someone stealing lunch money. I
love having all of our man cards checked. You're not a real man. You won't get out there and fight him hand to hand and take it like a man. I'm like, well, Jesus Christ. I mean, what happened to toxic masculinity as a concept? Lord.
Here's the thing. This was such a massive screw up, and that chat really drilled it into my brain there that you just read off. And that is, before yesterday, there was never any implication from the state that there was an admission on their part that Kyle would have faced any physical harm at all if he didn't fire. They waited because in theory, you could argue for all of us know, maybe he's lunging just for the gun, to get the gun away, which is what they were implying the entire time. He's just trying to get the gun away from this dangerous guy who's waving it around or trying to take his gun, but not that he's going to physically harm Kyle at all. And they wait until closing arguments to basically admit that Kyle should have stood there and gotten the crap kicked out of him. And that's the first time the jury heard that. They never said that before. When Binger did in his opening, where he's like, when he admits that he brought a gun to a fist fight, I wouldn't have framed it as a fist fight if I was the state. I would have said that he's just going for the gun. That's all he wants. He doesn't want to beat up Kyle. We have no evidence according to the state. I think the state's out of their mind, but he's like, they don't believe the threat to kill him, or they're trying to get the jury to disbelieve that. Why would they admit that there would have been a fist fight at all? It was such a stupid error by the state. Thank God. But I think it was moronic for them to admit that if Kyle did not shoot, a fist fight would have ensued.
Yeah, I mean, the interesting thing about all of that is is this admission that there was a need for Kyle to defend himself, but he just went too far with the self-defense.
Yep.
Which I think that's a bridge that they should not have built, personally, because a jury may have said, you know, he could have just kept running. He didn't need to do anything in that scenario. He could have gotten away, or he shouldn't have been there. But once you say, well, there comes the point when he should have put the gun down, put up lefty and righty, and gone to town throwing bones on these people, it's a pointless admission, and I hope they get hung on that. Actually, that would be great if the jury comes out. Not only do we find him not guilty, we find him not guilty because Krause is a moron. That's what we've determined.
We, the jury, we find not guilty, and Krause is an idiot.
Let me ask y'all this
Additional
question.
findings we were asked to find, but yeah.
we branched in our own direction here.
Let me ask y'all this question,
This
because this just crossed my mind.
Sorry, go ahead.
All right, you're a juror who may be genuinely afraid that one day you're going to be doxxed, or that your children are going to be retaliated against because of what you're going to vote on today. So you have an emotional vested interest in your own personal safety to do something to throw this kid under the bus just to protect yourself. Okay. So, you know, I'm sure there may be some jurors in there who may be looking for anything to peg a conviction on so they can go home and sleep at night knowing that they don't have to worry about the angry mob with the pitchforks and the torches coming after them. But at the same time, when you do hear stupid things like the DA saying that he should have gone there and took it on the chin, my goodness, if a DA down here in Mississippi said that, he wouldn't get reelected. Because
he might be out there taking it on the chin right after, right? Like,
yeah. I mean,
the judge might have word. I love those courtroom videos where the judge picks a fight with one of the lawyers. That's my favorite. We need more of that happening.
Like last week.
So this is a question for the panel. All right. This is from 2A Self-Defense Law. It says, question, case out of Alaska 4 years ago. There was reversible error in a self-defense murder case. In the closing argument, they kept saying he didn't deserve to die. And it says each state lawyer said once, I cannot find that case. Are any of you familiar by chance with a case out of Alaska in general? And then more specifically, one where they had reversible error? Because
to Westlaw.
Yeah. Because that's pretty interesting because, both I think Binger and Krause did say that basically Rosenbaum didn't deserve to die. Do you have to preserve that objection?
Oh, yeah. I mean, he said as much before. He says, like, if you didn't say it, you lose it. So, but I'll find the case for edification. Why not?
How good is your Westlaw subscription?
And we're going to find out.
Yeah.
I do have the state law, like all 50 states. So if you can't find it, let me know. But I'm not familiar offhand with that case. But it sounds, I mean, that's a phenomenal case. Because
why would you have all 50 states? I don't understand why you would pay for a subscription like that.
YouTube, that's why.
I cover all 50 states.
We need to get a sponsorship from Westlaw. I'm not even kidding. Westlaw or Lexus, one of you guys needs to sponsor us. I don't care. I will happily shill either one of you forever. You guys spend so much on marketing to law students anyway. Just either one. Please sponsor me. I'll shill you forever about how great you are and how the other one sucks.
Just give us the law student package.
Yeah.
Right?
Law
like
student
what's
package, which is all the things
that would be great.
package.
Yeah, that'd be
because
pretty solid.
I pay I think $6.50 a month for Westlaw.
It's insanity.
Someone from
That's why
Westlaw,
I don't.
someone from
yeah.
Westlaw or LexisNexis is watching this stream. I guarantee you. Please contact us about sponsorship opportunities. We'd love to show your products and anything else that you have. It'd be great.
Yeah.
I mean, I've been able to get by with using case text instead because I looked at the
case
cost.
text is garbage unless they want to sponsor me, but even still.
You're
Our bar
spending
association.
for my purposes,
$7,000 a year
it's been
on
useful enough. But yeah, I mean, hey, if Westlaw,
Wow.
I love Westlaw. I that's what I used before I had to pay for it myself.
I myself use Lexis, but I only do the regional subscription for the districts that I'm licensed in or have any bearing to, and it's a little bit cheaper for me. But for the other states, I have because I'm a member of the Mississippi Bar, they have a program or sponsorship with some agents from group, I can't remember the name of it, where you can go on and you get 50 state, free from them. So if I'm in a pinch, I go that way. But
yeah, to the chat, $650, not $6.50. Yeah, people are asking. It's very expensive.
It's insanely expensive. I remember when I was just looking to get in New York, and as a solar practitioner, I was like, that's pricey. That's really pricey. And especially in New York, at least, we charge a billable rate, which is, for you guys out in Minnesota to bring in $650, you guys are charging, I don't know, you're $200 an hour out there.
Mm-hmm.
That is what you guys are charging, right? I mean, that's a normal rate there.
In my town, the highest rate I know of in my town is $250 an hour. So
yeah, and if you charge $250 an hour in New York City, no one will hire you because they'll assume you're incompetent.
Right.
That's how so that's what I'm saying is if the pricing that Westlaw is attaching to Minnesota, that's so prohibitive based on the billable hour rate that you guys are charging in the Midwest. That's
Joe,
that's crazy. Yeah.
Will you sponsor my admission into New York? Because I would love to bill $600 an hour for my time.
Sure.
So T sent a chat, says, "Hey Nick, I was trying to look up Rosenbaum on the Wisconsin sex offender registry and he's not showing up. Would they have removed him for being deceased? Was he never there? Or did they binger it up?" One, I think they would remove him for being deceased. I don't know if he was ever on the Wisconsin one. He probably should have been, but I don't know how long he was in Wisconsin or if he ever registered. But he's on either the federal or the Arizona one. His criminal acts against minors were in Arizona. So that's you may have to check down there. But I know there's a bunch of people who have like the screenshots of his criminal history. It's all been found. But yeah, but if he didn't register in Wisconsin, that's just one more thing they could have gone after. Yeah, he should have asked his girlfriend. By the way, when you moved into that new place and Joseph Rosenbaum was with you, did you have to go door to door and inform your neighbors?
We were members of the Welcome Wagon. Yes.
Oh man. What else do we have? Here's the Janto says it's Rossiter versus State, 404P 3rd, 223. It's a Court of Appeals case. Law student subscription for the win. Thank you.
Nice. What's the last citation of that? 128.
It was 404P 3rd, 223.
23. Okay. Yep.
Is the case. But yes. So I am trying. I have. You guys, the audience has been amazing. I have so many super chats to read also. I do have a bunch of them backlogged. And if I don't get to them on a stream, I will get to them in a recorded video, like ASAP. Because that's one thing I've always tried to do on the channel is read every chat that comes in, even if I can't do it live. And so that's
called the personal touch, Nick.
That volume has changed dramatically over the course of this case as we have something like 60 times the viewers on some of these streams. But I will still be doing it. Okay, so to the panel.
What do you do when more chats come on the follow up stream? Like, how do you?
That's why I'm probably just going to record it, because I've tried to do a couple of the makeup streams, and I end up, getting more. Yeah, and it's like
a never-ending cycle.
Right. And I love that, but I'm also not trying to accomplish that on doing a let's read a super chat thing. So live is just an easier format for me. That's why I was doing it. But now I'm just going to have to record it. Let's see. Yes, and AJ Cook points out that Rosenbaum served every day of his 10-year prison sentence, which is nowhere near long enough for that crime, in my opinion. Dozens of disciplinary infractions in prison, then another 2 to 3 years, if I recall, for cutting his ankle monitor after he got out.
Nice.
Yeah, he was an upstanding citizen of Arizona, only upstanding because he didn't want to lay down on the concrete bed in his cell.
Yeah.
Was the thing.
Yeah, that's one I'll have to remember. That's a good joke. That's a good line.
Yeah.
So
I'm writing it down.
But do we have any? Okay, what is the most likely charge if Kyle is convicted of anything that you guys think?
It's got to be the recklessness, just because the instruction is so confusing, right?
I think so. Oh, wait. So you're saying against McInnes?
Yeah.
That
Take your
reckless
pick.
one?
Yeah.
Well, because I think the recklessness against Jump Kick Man is more likely, mainly because the judge did clarify if you find self-defense on Rosenbaum, it transfers to McInnes. But he said it in a very confusing way.
No, he tried to clarify it, but the instruction is so confusing that it's impossible to follow. It's like, yeah, it doesn't follow, but it does follow, but it doesn't, but it does.
They should not have an additional jury instruction when self-defense applies. They should have an alternate jury instruction, flat out, because the whole jury instruction says no self-defense on recklessness, and then it adds in a paragraph about self-defense on recklessness. It was like, why?
The concept of applying reckless endangerment to a homicide that's defended by self-defense is an attack on our basic Second Amendment rights and our ability to defend ourselves. And it's so obvious, it's staring us in the face. So let me explain to the jury. If you use bullets that are full metal jacket and more likely to pierce and come out the backside, they say you are recklessly endangering the public. If instead you choose hollow points, which are much more likely to balloon and stay inside the body, they will say, why would you use a bullet which is likely to balloon by ballooning the person you shoot at is much more likely to die and suffer a far more serious injury. So no matter what bullet you use, the state, once you allow them to say there's reckless endangerment, if you use a bullet that's piercing, the state is basically cutting off your ability to use a gun to defend yourself on your basic Second Amendment rights. Because no matter what bullet you use, you're wrong. And that's what they want. They want to strip us of our Second Amendment rights. And that's exactly what this is standing for. I wish that Mark Richards would have made that point when he was addressing the Second Amendment, when he was addressing the reckless endangerment claim, that the reason this is here is because they believe that Americans should have no right to own weapons and to defend themselves with weapons. That's the entire point to that charge. And I don't think the jury has any recognition of that at all.
And I think what you're saying, and maybe to clarify, is that the reckless endangerment charges against McInnes is obviously bogus, but even against Jump Kick Man is bogus. It was not a reckless act that he fired a weapon at someone and missed, right? Like that was they should have done an attempted homicide charge on him like they did with Gage Grosskreutz. There's a real reason that they didn't, and I think it boils down to that jury instruction on self-defense in regards to recklessness. Recklessness is not pointing a gun at someone and pulling a trigger with the intent to shoot them. That is not recklessness. Recklessness is being shooting, like let's say you're in the, I don't know, a city, and you just shoot that way. You don't see anybody, but you just shoot that way, or you tip the gun up at a 30-degree angle and shoot. So this bullet can traverse, 3/4 of a mile, 2 miles away.
It's
depending
like dropping
on
an anvil off a bridge, just for craps and giggles.
Yeah. Or in Minnesota, as it were, pumpkins. throwing pumpkins off of an overpass, and that pumpkin hits the windshield at the right angle, goes right through, and kills the driver because they're driving 70 miles an hour. Those are recklessness. Pointing a gun at someone, whether they're attacking you or not, and pulling a trigger is not reckless unless you think there's blanks in it, maybe, Alec, right? Like maybe that's it. But you're not going to get that if you're carrying live ammunition.
Unless you blindfold yourself and spin around in a circle while you keep pulling the trigger. That's basically.
Is this tantamount to the depraved heart charge that you sometimes see in some states? Like, that you're just,
Yeah, but with a much lighter yardstick for penalty. Like it's much easier to convict. I think it's a much shorter, it's a much simpler case for the state to convict on.
I also think that's why they have Rosenbaum as a reckless homicide charge, which is ludicrous. Rosenbaum,
it's a very strange thing. It's like reckless. How's that even work exactly?
Because if anything, if they don't think they can get intent on him, they've got to do a second-degree murder charge, right? Like second-degree intentional homicide. He points the gun at him. Their entire argument is that he points the gun at this guy and pulls the trigger 4 times. On the 4th time, specifically killing him while he's down. That should be an intentional murder charge, if nothing else. But the fact that they're unwilling to say that his shooting of Rosenbaum was intentional, whether or not it was premeditated, this should, again, and this is getting into the weeds, and I don't know that the jury needs to hear all this, but you almost want Richards to bring this up and say, hey, why, if he sat here and told you that he killed him on purpose, why didn't he charge him with intentional murder?
Yeah.
He charged him with reckless murder. What, he was just shooting randomly and happened to 4 times hit Rosenbaum? That's
one
what
way to go.
I mean, that's what bothers me. I don't know, I don't know that they motioned to dismiss that charge. I don't think they did, but they maybe should have for pleading standards on that one.
I want to point out this guy Dustin C here raised a really interesting question for the panel, where he says law Twitter is going nuts about federal charges next. Is that even possible, or does double jeopardy preclude that? They're claiming federal gun, homicide, hate crime, terrorism, etc.
What evidence is there for a hate crime?
The victims are the same race.
Yeah,
and
they're not a
outside of
protected
that.
class. Sorry, but Title VII tends to apply to protected classes more strictly. Although this isn't a Title VII claim, you would have to show the government would have to make a probable cause showing that he shot them based on their race.
Yeah.
That's why they got Chauvin, was
or based
because
on terrorism, but no.
But Chauvin also being a police officer, he would have been governed under the criminal version of 1983.
Yes.
I mean, there's the civil statute 42 USC 1983 where you can sue a state officer for depriving your civil rights, but there's also a companion criminal statute that allows the feds to go after a person for depriving you of their civil rights if they're acting under color of law.
It's 242, right? It's like 18 USC 242.
Yeah, 242, 243, I think, something like that. Yeah. As to the other question about the double jeopardy question, there was a case at the U.S. Supreme Court a couple of years ago called Gamble versus United States. So there is no double jeopardy problem if the feds want to charge him because they're separate sovereigns. So yes, the federal government can charge him for the same crime without it being a double jeopardy problem. That being the case, however, there's no crime to charge him with.
And if they did create a crime, it would be an ex post facto provision. It'd be ex post facto because it would be, you're criminalizing an action after it happened. You're doing punishment for something that, that wasn't on the books when the crime happened. And so unless there's an existing federal law that he violated, the U.S. district attorney, the U.S. attorney would be very hard pressed to try to find anything to that effect.
I want to throw this down real quick to everybody in the YouTube chat who is a proponent of alt tech. You don't have to leave the YouTube chat or anything like that. But yesterday, when the stream went down, a bunch of people flooded to Odyssey, and it kind of broke everything. But they have assured me that they can handle a heavy load of people. So if a whole bunch of people want to follow the link right now that I'm going to throw in here, on Odyssey and stress test their system. Again, just right click and open it in a new window and see if we can break the Odyssey stream. I think that would be
I'm happy to
that'd be
help.
funny.
This is like jumping on a bed to test it out. This is
They have
like
the Odyssey guys. They said we can take it. We can take
You
it
guys-
today. So
for those of
they
you who are
actually
really
challenged
old,
20,000 people to show up. But I
you
don't
guys
know.
are the gorilla, and this is that's the Samsonite luggage. It's a really old commercial that really, really old. I don't even think that Kurt's old enough to remember that one.
And
I don't
also,
think that
if
I've seen
you-
it.
If you don't like YouTube censoring
you.
your chats, Odyssey, from what I understand, does not do that. So, you know, if you want to say something spicy about
They're saying
Bicep
broken.
Boy, or
They're saying it's broken.
oh no, I'm watching it right now. It's live. It's all good.
Well, then your chat is working in mass to like basically troll you because I keep seeing error, broken, and yeah.
Oh yeah, no, I got all kinds of errors.
I see the numbers climbing up.
I love your chat. That is
They didn't make
great.
it very far.
There's literally like 4,000 people screaming error broken, and they're totally all effing with you.
No, I don't know. I don't know. We've got 4,300 over on Odyssey right now. So 4,500.
Let's make Odyssey cry.
going up.
I'm all about that. Let's make Odyssey cry.
I think they're happy to have this happen. That's my
someone in tech
thought on it.
support right now isn't that happy. I'm telling you what. Someone's like,
Look.
"What did you say, boss? What?"
They said, bring 20,000 people over here. We can handle it. That was the exact line from, I believe, like the developer. So
Okay, I'm really getting black screen, no joke, like comments here in the chat. Like out of black screen and HTML error. That's what I'm
I got
seeing
all
here.
kinds of errors when I tried to join. That's just a big wall of errors in red.
I'm gonna try it
It was
myself
great.
and see if this
I
screen with
tried
you.
to comment. I tried to comment and I got a
GitHub
bunch
something
of
library
GitHub
reflect view call server H. Oh my god.
Sorry, Odyssey. I love you guys. I want
Is it
to.
broken? It broke?
I mean, the video is still playing for me, but I can't comment. I get. Oh wait, there a comment went through. A comment went through. No, this is important though, right? Because alt tech and the guys at Odyssey are great. Make no mistake. I love the platform. I want it to grow and grow and grow. And I'm so glad that they started mirroring my streams over there. Because for a while they wouldn't, because of how long they get. And now they mirror the streams over there, and I'm able to now mirror live streams directly over there. And it is functioning. And I want to mirror all of them going forward. So I love these tests.
This was like Kraus testing out a brand new chair made out of matchsticks. It's just
It's like Kraus testing out a brand new chair made of titanium. Oh man. Well, thank you guys for pillaging the fertile land that is Odyssey. That made me really happy. I do want, like I said, I want alt tech to succeed. I am on YouTube because it's the best place to get my voice out to the most people. I wish that were not the case. Like I want anything other than that to be true. And Odyssey is there. Rumble is apparently there, and I need to make a Rumble now, I guess. But
we all YouTube right leaning YouTube content providers. We're basically like interns working for Governor Cuomo. Like we're newly hired people, and it's like okay, so like I know that this is great for my career, my advancement, and whatever groping happens along the way, I gotta put up with that. I gotta shut my mouth. I gotta take it, and yeah, you know it's gonna happen. You know it's gonna come, and you just sort of smile. Yeah, okay.
Oh, I'm gonna come.
And then when we become big enough that we can go on Rumble and transfer our audience over there, then we can complain about how we were assaulted on Google. So
yeah,
well,
I'm gonna get a meme of someone sending me like show me a picture and saying like show us on the doll where YouTube touched you. So
everywhere.
The problem is if we go over on Rumble, Amazon Web Services will shut them down or something, right? Like That's the thing. We get to kick it one more notch or one more rung up the ladder of internet service provision, and see what happens with that. Oh God, I hate the system so much. Need a Way Out says, "Hello from Minnesota. Love the channel, don't you know?" Oh, thank you, thank you. That was very
don't you
Minnesotan.
know?
Now there's a thing saying, please enable cookies if nothing appears. Oh, okay. This is on me now to fix this problem.
Yeah, it's your fault. It's your fault. I still
And then
have
there's a
video.
warning. Odyssey performance may be degraded. You can try to use your waste 5 minutes and refresh. Please no crush us. It literally says that. Wow. Wow. I'm tweeting that one out too.
I love them. They're phenomenal. They're phenomenal. And to Thomas, I hope you have a long day of coding ahead of you. I still have video that's live on Odyssey. I can see it. It's great. It's phenomenal. But whew, what a disaster. I did hear some reporting that pizza is what was delivered today for dinner at the jury room. So, well, I shouldn't say jury room. They got pizza to eat today.
Well, that's enough reason to continue deliberations just a little bit longer now.
Yeah.
Pizza?
I'd do it for pizza.
Oh yeah.
Guys, you okay. Look, I have to
What
help
kind
you
of
guys.
pizza now? That's the other question.
You guys,
Is it deep dish? Is it thin?
Yeah.
I can
have to
tell
vote on the
y'all
pizza?
don't live anywhere near Minnesota or Wisconsin. Like pizza is everywhere. Like there's so much pizza. It's embarrassing levels of pizza. There's just
I mean,
pizza.
there's a lot of pizza everywhere. It's like
But
one of
it's-
the easiest things to market.
But the problem is this isn't good pizza. It's just every chain of pizza. The Midwest is this weird place, and maybe we can briefly digress into this. I know it has nothing to do with Kyle Rittenhouse, but if you go to Texas and you're driving around like Houston or Dallas, you see a billion different restaurants that you'll never see anywhere else, especially in Houston, my favorite city in the world because of this. Every strip mall has
Austin's
like
pretty
three,
good for food.
eh,
I'm
it's
partial.
It's not the same, is what I mean.
Okay.
Because Austin has a bunch of commie nonsense going on, and they have zoning rules. Houston does not. Houston's like, zoning? What even is this? It's like, no, we want the strip club and the liquor store next to the daycare. that was my
That was
daycare.
intentional.
That was my daycare. Okay.
Well,
And
how
so-
how are all the ladies supposed to get childcare then? I mean, they
Exact-
have needs too.
I 100% agree with you. But what I'm saying is when you drive around Houston and you're like, there's all these restaurants. It's like the most beautiful small business capitalism in the world. When you go to the Midwest, that's gone. It's gone. It's chains. It's only chains everywhere. And it's like, oh, I like this one. Oh, that's a chain. Like, oh, I like this. Oh yeah. They 27 locations. Okay. I got it. No, we're not talking about like, I mean, you can find them, of course, but I'm saying down south, you have them everywhere. Up here, it's not so much. Not so much.
That's
And
fair.
it's
But
embarrassing.
even
So
when
the
it comes to-
pizza they're getting is Domino's. Let's be honest. This is court.
Better than Little Caesars.
Oh,
I
that
don't
might
know.
be
I have a soft
slanderous.
place in my heart for Little Caesars.
I
I
don't-
like their deep dish
Ooh.
though.
No.
Not
I
the
used to
regular kind.
walk.
I don't think I've ever had a fresh Little Caesars and buying
Maybe
it
that's the
right
problem.
from Little Caesars.
Yeah, that's the
Oh
problem.
yeah, that's every pizza. Okay. Anyway, I used to walk with my grandma about 1.5 miles through Houston, down Antoine. We would walk down Antoine to the Little Caesars and go get a pizza. So I love Little Caesars because of that. It's a good memory
Aw.
for me. And we also used to walk to the Subway that was not too far from there as well, and the Baskin Robbins.
I'm old enough to remember when you went to Little Caesars, their whole shtick was the 2 square pizzas that you got every time you ordered something. And it was in that huge plastic bag. And it was, of course, when you're 14 years old, any large pizza is enough to,
Like Amazon is
back
there, yeah,
then,
you're
large
right.
was large, you know. It's amazing how times change even with restaurants.
Now their thing is hot and ready. The pizzas certain pizzas are always ready, and so you
Yes,
can
that's
during
why they're
business
not
hours.
fresh because they made them 2 days ago and they've just kept them on their hot lights.
No. Look, you
She's
go to
saying it's like 7-Eleven hot dogs. They're just
you
like,
go to the
Yeah,
Little
exactly.
Caesars in my town, you're getting a
Yes.
fresh pepperoni pizza because they cycle through those things like crazy. I've actually gotten there when they've run out of them and I've had to wait. And I was like, thought this thing was hot and ready, you liar. Sorry. I have a sore spot for promises unkept. All right. So let's see. Carbonis for the win. You are from Minnesota, aren't you? Let's see. Wait, Fox News Milwaukee had something. Oh, I scrolled down too far. What did we have? What did it say?
Got a friend of mine who's used to be on a pizza place in where I used to live, and he's now doing odd and sundry other things in another part of the country. And he just texted me and said that pizza is a nice barter economy or a barter currency.
Just hand pizza over in exchange for
Yeah.
things. Just a Dude says Fox News 6 Milwaukee has the closing arguments segmented. Why not replay it to kill time with the ability to pause and comment? Because I don't know if I want to sit through them again. Do you guys want to sit through the closing arguments again? Do we want to do that? I mean, we could. I'd rather talk about other things personally.
Yeah.
While we wait. Like what about this the big people are asking what the next trial is going to be. And there's been some speculation. I mean, Arbery is a big trial.
It is happening. That's happening right now.
The chat says no, please no. No.
But I don't know. Maybe they're trolling you. Maybe they're saying no when really they mean yes. Yeah,
I saw
that
one
could be
yes,
trolling you
so
again.
we should do that. One yes means yes, we should do it. Dude, how many phone calls am I going to get today? From the UK. Okay. I don't know what's going on. No, I don't. I really don't want to rehash the closing arguments. And the jury's not going to rehash the closing arguments, so I don't know that it's beneficial for us to do it either.
Right.
Someone
But
just said to me, Joe, no means no.
The Arbery case is big. It's going on right now. How long is this case supposed to go? Do we have any idea? Like the Arbery case?
Well, I think yesterday the prosecution was still putting their case in chief on, weren't they?
And the defense can go for a while. And I will tell you that I think the testimony of Travis McMichael, and I can't imagine that he can get around testifying. I think that he's going to have to waive his Fifth Amendment rights. That will probably be riveting television. But I did want to ask you about Fifth Amendment rights. Now I remember this. If there's a mistrial, I assume that Kyle's Fifth Amendment rights are not waived for the next trial. Am I correct in that?
Wait, what?
Let's say there's a mistrial here on some charges. Some get dismissed, and let's say there's 2 or 3 charges left over. But they're the same charges. They're the same charges that were exact same charges as from this trial. Has he waived his Fifth Amendment rights with respect to the charge, or is it with respect to the jury? That's my question for you. Can the state come to the stand because he testified the first time?
Yes, I think so.
Because I can understand arguments saying that, look, before that jury, we felt as if his testimony was appropriate. But now there's a brand new jury, it's a brand new case. He has a Fifth Amendment right. You can play video because that's an admission under oath. It's not hearsay. It's an admission. There's a million reasons why it's not a hearsay problem. You could play video. The state wants to, but to make him come up and answer new questions would be a violation of his Fifth Amendment rights. And that's my question to you: can they do that? And a further argument is, let's say they would add on one more charge. If they add on one more charge, he clearly has a Fifth Amendment rights.
I think that's a different question in my opinion. I think if they're a rehash of the existing charges because of a mistrial, then he's waived his Fifth Amendment privilege. Waiver of Fifth Amendment can happen pretty quickly if you talk about, if you talk to, even if he went in for a police interview and answered questions without an express waiver, comes close to waiving Fifth Amendment rights, depending on the questions that are asked.
You will admit to me that if there's an added new charge now, that he has not waived it. And
depending on the elements of the charge, I think so. I think he has not waived it.
guess it would also depend upon, like you said, of the elements of the charge and whether or not he has stated any facts that would dovetail with the respective elements of the new charge. I mean, wouldn't that, Joe, have a bearing on it too? Or
I don't know, because I was thinking that these lesser includeds were not there when he took the stand. And so I think that actually supports what you're saying now, that the lesser includeds are dovetailing with the same elements. So we don't say that, well, you're charging him. Let's say all of a sudden there was a brand new charge, like, distribution of cocaine thrown in there. So in that
Yeah.
case, now they couldn't make him take the stand.
It'd be a separate thing.
Because even if they're all in one case, so he would not be able to take the stand because he can't be. I don't think he can take the stand at all. I don't think you can make him take the stand. Rather than another perspective might be, well, they can make him take the stand on some of the charges, but if the state is prohibited from asking him about anything related to the drug charges, and there he could raise his Fifth Amendment rights. There's different ways to look at it, and I'm just trying to figure out how this works. I'm sure this has come up in the past, and I'm really curious.
Well, the one thing about the Fifth Amendment is that they've been pretty clear on is that you don't get to come up, assert your defenses, and then claim Fifth Amendment privilege against anything else. So once you waive them, like, you don't get the benefit of selectively enforcing your Fifth Amendment right. Is how the court has ruled on that. But I think on a different charge, I think you've got a good argument, assuming it's not like a very similar element type
Lesser
charge,
included, like the lesser included.
right? But as for the rest of it, I don't know. I don't know. It's tough.
It's a good question. I think someone asked me that on one of my streams. Which, by the way, those of you I stream every night, Sunday to Thursday, from 10 p.m. till midnight Eastern time. So, and people ask me questions like that, and I sit there trying to postulate and figure that out. So,
That's
why I asked you minds who are sharper than mine as to.
It is very easy to waive a constitutional right, be it the Fifth Amendment or the right to a speedy trial or anything along those lines, if you don't watch what you're doing. I had a case, let me think here, it was back about 13 years ago. Guy was arrested for a drug charge for something that had happened 8 years earlier. He had they'd failed to put it in the system until the year before, and it was 7 years after he'd been, the charge had happened. So I moved for speedy trial. I moved and said that his rights under the Constitution to a speedy trial were violated. Well, the DA went ahead and set it for trial on a Friday, the Monday being the day of my hearing on my motion to dismiss. Well, the problem for me personally was I was taking the Tennessee bar during the middle of the week. And I was presented with this situation where, okay, if I'm going to move for a continuance because I have a scheduling problem, I'm waiving my client's right to a speedy trial, and I can't do that. So I had to file a motion to dismiss and argue it and hope I won, just so that I could take the bar exam that week. Otherwise, I would have been preparing my first criminal trial instead of studying for the bar.
Wow.
Yeah. It's and it is weird. Like, a lot of constitutional rights, if you don't assert them or you don't assert them properly, you will lose them. For example, your right to an attorney can be lost if you don't assert it. I mean, that's one that you don't lose. You don't waive, but you don't have it until you assert it. Your right to remain silent in general is not waived necessarily, but you don't have it until you assert it. And so it's a tough question. I don't know the answer to this.
All right.
Are we serious?
Well, I feel less stupid because I was like, well, I'm not a criminal defense lawyer, so I don't know. I'm gonna have to ask one of those experts that I know. So
it's yeah, and that gets into one of those situations where you go, I think it would be an argument. I don't think there's an actual definitive answer. I think we would be the lawyers would be arguing over, did they waive their Fifth Amendment privilege in the previous trial for this one?
And you might be right, because how often does it happen that someone chooses to waive a Fifth Amendment? And in a case like that, how often would you have a mistrial And then you would need a situation where after mistrial, the state is sufficiently vested that they say, we're going to bring this case all over again. Those are three things that do not happen very often. And for all three of them any one of them is uncommon to happen. To have all three of them happen is probably highly uncommon. So I can imagine it's not a question of law that comes up too frequently.
Yeah, I agree. It's very situational. Let me.
Are we saying rest in peace to Odyssey that you destroyed the whole thing? Did you actually break Odyssey? That because
it's up.
I don't know. I'm seeing all these people complaining about Odyssey having problems.
I got a link from Adam Krigler that says Google, Spotify, Snapchat, Discord, and other platforms go down, but they don't mention Odyssey. From Down Detector. So let's see. Site Down Detector began showing a spike in reports of outages starting at 12:40 p.m. Eastern on Tuesday, affecting Google, Facebook, Instagram, Snapchat, Discord, Spotify, and TikTok, as well as Target, Etsy, Shopify, and Home Depot. Amazon Web Services and Cloudflare were also affected. So
AWS, okay, big time.
Yeah, they might all be related. In all honesty,
I'm still blaming Odyssey though.
Yes,
they're the ones that asked for this.
It's Odyssey's fault.
Yes.
Let me start reading some of these chats that have come in today because there are good questions here. Like this one from Bradley says, if you can't defend yourself from pedos and commies as they burn down your town while police stand by and do nothing, what is the point of anything at all? That's a very valid question, Bradley. That's actually one of my frustrations with the defense is that they did not get in the prior acts evidence. I thought it could be done personally. I thought they could get there, and they did not. But let's see. I'm hearing from Odyssey that the instantaneous rush, especially of new users, is tough. It didn't fully crash, but was under heavy load and erred for some percentage. But they are still working on it. So thank you guys for helping out with that Odyssey stress test. It helps them make a better product, and that's good. Dude, seriously, I'm gonna turn my phone off in about 5 seconds. Why are people calling me?
You're still getting phone calls. They're probably media requests.
They might be. They need to leave a
voicemail.
Yeah, they need to leave a voicemail for me.
I mean, yeah, that's usually my policy is like, if you don't leave a message, I'm assuming it's not important.
Yeah, that's it. Okay. Anyway, this one was from Michigan. I know people in Michigan, but I'm streaming, so we've got priorities here. Andy Lucy says Binger's booger hook on the bang switch of that AR-15 triggered flashbacks to basic training and flagging the jury. If I had done that, my drills would have had wall-to-wall counseling session with me. Yeah, you can't do that. You can't do that. Billy Witch Doctor 99 says everybody gets the brakes beaten off of them sometimes. Yellow Flash / Kraus 2021.
Oh no.
Jack Stainback says communism is a red herring.
That's a quote from Clue. The movie.
Oh, okay. The communism is a red herring.
Yeah.
I watched Clue on Twitch a couple months ago. I love that movie, but I didn't
It's
remember.
really
the quote.
good. So when you were in law school, did you have anything called like law review or anything? Any kind of like a play that the law students put on once a year?
If that would have happened, I guarantee you I would have not gone to it, and I would have laughed at everyone involved. Look,
You would have laughed at me.
Yeah. I would have laughed shamelessly at you. Like, you went to law school and you did a play.
So at UT it's called assault and flattery. And the whole premise the whole premise is making fun of the law school experience, and it's always a like they take some kind of a movie or show or something, a premise, and basically turn it into like what would happen if this were basically like law school. So the 1 year that I did my 3L year, I did it I was like a random cast member on it, and it was Clue was the theme. It was great.
Oh my goodness.
It was really fun.
That's fantastic. No, I did, full disclosure, I did some community theater, but I could not imagine like a law school version of it. It seems to me like it would get too wrapped up in like inside jokes, which that's the thing about community theater that I don't like. It's like when they change words and stuff to like shout out to their own community. I'm too serious about stuff. Matthew Dombrowski says, really appreciate the coverage during the trial. Thank you very much. Alex McCamey says, what's the best meme to put on a billboard that Binger and Krause have to drive by on their way to work every morning? It's the background of this stream. It's just Krause with his head in his hands.
Or the picture. Or the picture of Binger holding the AR-15 and aiming it at the jury.
Well, that thing has been memed so much now. Like people have all the different angles of Binger like this with his arm way out and everything. And they've been photoshopping him into everything, like into Call of Duty screenshots. And it's great. It's great. Especially with that call out to Call of Duty was such to me, that was a big misstep by the prosecution. Why would you call out video games? You thought you were in a video game.
Well, Nick, here's one thought to consider. We don't know the ages of the jurors. We don't, unless it's been reported in an independent report where they've given a range or something. But if you've got a higher median age group, if you've got your grandmothers and your folks who don't understand video games and they don't understand first person games, and they think that all of this stuff is just training you to kill people and that's what you like to do, I think that might have been just a way to bias a jury. Now on the other hand, if you were dealing with a jury that had a mean age of 30 or 35, that would be very dumb. So I think it's going to be a situational thing at the end, because a lot of it depends on what people know about video games.
Right. Yeah, that's true. That's true. I guess I have to agree, because I think I've told this story before, but my grandmother, after the Columbine incident, did ask me if I ever played Doom before. Oh, hey, I've got someone with the answer to Joe's question. This is a lawyer that I know through Twitter. Says, you're killing me. I'm sorry. He says, you can always get your Fifth Amendment back. If there's a mistrial and the defendant testified at the first trial, she cannot be called to the stand against his or her will, but the transcript of the prior testimony is fair game, so he or she will likely testify in his or her defense. So thank you for clarifying that, good sir. You know who you are. And there you go. There you go. I'm happy to learn something.
I figured that would be, I mean, I didn't know off the top of my head if you could compel the person to testify. I didn't think you could, but I didn't want to say absolutely because I didn't know with certainty. But when you've got 8 hours of video of the guy testifying, sometimes you can just bring those clips in as exhibits or just play the whole darn thing, because
very true.
In that case, the hearsay exception, the declarant would be unavailable, having asserted their Fifth Amendment right now, and so then that could be brought in because there was cross-examination available. This is, by the way, Nick, I want to thank you for letting me get on your show and introducing me to your audience. This has been fun the last couple of times I've done this, and I figured I wanted to thank you personally and publicly for that.
Oh, well, I appreciate having more and more lawyers on, as long as they're not nerds.
Well, I feel almost like Joan Rivers when she was Johnny's friend, would always thank Johnny for letting her be on the show. Now, I mean, I doubt I will ever go on Fox and run against the Tonight Show here versus you, but you know what I mean.
Well, I'm going to run against the Tonight Show. There we go. John
that
Omar.
Expression, that was a bit dated for the audience, I'm sure.
Let's see. John O'Mara says, I've given 3 $5 super chats and 1 $20 super chat. This is my second. I understand the difficulty in reading them all. I'm sending this one because you asked why so many are watching jury deliberations. And he says, you are the reason. Oh no. Well, I'm glad to have people interested in this stuff.
Aw.
I think this case is critically important, honestly. Like, again, it's a district court case in the state of Wisconsin. It doesn't have any precedental value outside of other specific self-defense cases in Kenosha. It won't be authoritative. However, I think it matters for the pulse of self-defense in this country. Like, it's nationally watched. The facts are not as muddy as they're attempting to be made, and people have a decision. How much do we want to allow people to defend themselves as a society? Where is it? Where's the line? I mean, for me, that line is you should have basically ultimate self-defense. I think Castle Doctrine and Stand Your Ground are phenomenal pieces of law that deserve a lot. I don't want to kill anybody ever. And I was a concealed carry holder for 5 years. I'm not currently, and I don't tend to carry. And I didn't carry even when I had my license, not because it's mainly because the gun was big. And I couldn't afford a smaller, easier to carry
You just
one.
needed that Glock 27, small tiny gun.
I did. But I have a 45, and so that was cumbersome to carry. But it was like, I hope to never have to use it. I'm not like one of these guys like, man, I pack all the time hoping. I don't think there's that many of those people that are out there, but there are a few. But I think the right to self-defense should be a paramount concern. If you don't have the right to keep your own life, what do you have the right to do? What does it matter?
You know, Nick, and another thought just crossed my mind. You know how yesterday it must have been Binger who got up and said that when you bring a gun somewhere, you've waived the right to self-defense. Is that kind of what he said?
That's explicitly what he said.
Okay. Well, if that's the case, then everybody who lives in an open carry state hasn't got the right to use it if they need it. I mean, that's how absurd that is. And it's an affront to the Second Amendment, and it's an affront to basic human dignity and human rights, in the sense that the first thing that you have the right to do is to protect yourself and the people you love and care about. And that's reprehensible for an officer of the court and a state official to say that.
Yeah, I think. Let's see. Anyway, I think that the other disingenuous aspect of what he said is obvious in the fact that people successfully assert self-defense with a gun constantly. Like that's a quintessential deadly force claim, is that someone uses a gun. No one's drawing out samurai swords, except for that guy who attacked the army pilots. But no one's drawing out samurai swords to defend themselves. Like, no one's walking around doing that. They're typically using a handgun in self-defense. And so to suggest that someone bringing a gun anywhere nullifies self-defense just defies common sense. And I think it was a very big mistake, because the jury's got to listen to that and go, I mean, I don't know, though.
Now, they're trying to use the essentially like the transferred intent of provocation to nullify. Is that kind of what I'm hearing? In other words, just by analogy, if I were a criminal and if I had a gun and I was trying to shoot person A and I hit person B instead, then I would still be charged with the murder of person B because of the doctrine of transferred intent. Are they trying to say that provocation can be transferred, and therefore if I am hypothetically trying to provoke one person but another person sees that, then they can use that to come after me and I don't have self-defense? Is that basically what the DA is trying to say?
Yeah, I think so. Kurt, is that your read of it?
As best as I'm able to determine, because the DA they explicitly say on the one hand, we're not contesting anyone's right of self-defense or the right to have guns, and then they're like, we're contesting the right of self-defense and the right to have guns. So I the message from the DA in terms of the underlying theory is weird, and I know it's impossible, but I wish I could just ask the the prosecutors. You keep saying that Kyle had other options. He didn't exhaust other options. I'm like, okay, I really just want you to put yourself in that moment at time and tell me, even with the benefit of hindsight, what options did he have, let alone your ability to process them at the time when your adrenaline is spiking and you're in a panic fight or flight state. And depending on your physiology response, it's not uncommon for your eyes range or ear range to narrow or even shut down. You become tunnel visioned and what you can hear and see, or they can shut down altogether. Your ability to process anything in this chaotic, loud environment. I'm like, even so, that's one thing. But even in the benefit of hindsight, with all these many fitted photos and videos from all these angles, what exactly do you think Kyle should do? Apparently, the answer to that question is he's supposed to, man up, take off his bra, and he's supposed to engage in a fist fight.
Yep.
And I'm like, really? So if you were in that situation and you had your druthers, right? If you had your wish, and you had your druthers, you only wish that you had your hands and you would be comfortable in that situation. That's what you're representing to me. And it doesn't, I have a difficult time believing in my heart of hearts that he'd be like, yeah, I really totally would feel safe in that situation, being chased by this guy, when it's chaotic and all the rest of it, and he said he's going to kill me. So I don't, the prosecution's argument seems disingenuous just from that angle as well.
And excuse me. On the provocation aspect, the prosecution was making the case, and I think that this is a solid case in general. If he points his gun at Zeminski, if Kyle does point his gun at Zeminski and effectively, not like in a pretend pixel way, but in a real way, if he unprovoked or whatever goes, and just points his gun at someone, does a third party then have a right to intervene? Is that provocation under the law?
Presumably the answer to that question is yes on a legal theory, but from their own frame of reference, the answer has to be no, because it's defense of others for Rosenbaum, right? So Rosenbaum in the best, but Rosenbaum sees Kyle point the rifle at Zeminski. Okay, so he's going to engage in defense of others. Okay, so he has self-defense in this view, defense of others. But why does Rosenbaum, from within their own framework and within their own logic, which is exactly, I suppose, the problem, there is none, but from within their own logic, why does Rosenbaum have this right of self-defense? But if you assume the facts from Kyle's point of view, where that didn't happen, he doesn't have the right of self-defense, because that's the whole. First of all, they said, first of all, we don't believe him that happened. But then they go the next step further. Even if it did happen, he still doesn't have the right of self-defense. So like, we're willing to accept his premise and still say that it's the wrong result. So how do you get to both those places at the same time?
Right, and I think that's a distinction in this case. But in the ether, right? Party A points at Party B, Party C it witnesses this. Then does party and one of the points I think Nate maybe brought up yesterday is that we have no evidence that Party C witnessed this. They never introduced that evidence, but let's say in a complete vacuum, Party A points a gun at Party B. Does Party C have provocation sufficient to intervene, where Party A loses their right of self-defense temporarily?
I think the answer has to be yes, and the prosecution even argued as much for Huber. They're saying these people are hero. They're chasing down someone they believe to be an active shooter. So they're like, yeah, Huber has this right of defense of others because Huber isn't being threatened himself. And I tend to agree with the prosecutor if you assume the best case scenario from Huber's point of view. So it should be.
So So I think that is. I think that Matt. I think that was addressing your question, right?
I think. Let me ask you this though. Zeminski, he was pointing his gun, assuming that he did, and I'm speaking hypothetically because there's not, as you pointed out, we had questions about pixels and stuff like that. But if he was pointing the gun at Zeminski, assuming arguendo that he did that because he felt threatened by Zeminski, in other words, he was trying to defend himself from a threat from Zeminski, then there wouldn't have been any provocation towards Zeminski. That would have been self-defense.
True that, because Zeminski did have a firearm, so you could then go to the next step and be like, well, maybe Rittenhouse saw it or was engaging with it or whatever. There's possible ways to get there.
Yeah, Zeminski was walking around with his firearm out throughout the night. We have pictures of him with his gun just drawn at the gas station. We don't know what he did, and that's the big problem in this is all of their talk about the Zeminskis and Kyle pointing a gun at them. There's no actual evidence that occurred because when asked, they can't point out where the Zeminskis are in the video. And the fact that the judge even got to that conclusion, but still allowed that video and those photos to be showed, to me, that's still potentially reversible error. They objected to that expert who cut all of that footage together. So I think they may have preserved for appeal all of the evidence that he brought in, but it's hard to say. I think it should have been
there's
more
definitely
specific.
grounds of appeal. I'd feel a lot better writing this appeal than most appeals, but of course, I don't think it should get that far.
Right. Mag says, hoping and praying for Kyle. Thanks to you and your guests for the great insight and honest commentary through all of this.
I'm going to try.
Next, we've got Havoc says, Fatlock's hyperbolic rage and closing rebuttal is legendary. I decided every kid I know gets an Armalite this Christmas instead of skateboards. Yes, he did suggest that everybody should buy their kids AR-15s instead of the skateboard they were going to get, because that makes sense, I suppose. Peter says it sounded like they're going to do motion practice after they send the jury away. So we may be hearing a discussion of directive verdict or dismissal with prejudice once the jury is picked.
That'd be
nice. That was earlier. It didn't appear to occur.
Nope.
Unfortunately. The other problem with that is I think motion for directive verdict is basically gone, right? Like, what are you going to direct verdict on when you have fact questions about provocation involved?
Well, I think I don't know for sure, but I would, because I think you can do it in a JNOV. I'm pretty sure you can, where the judge can say, yeah, there's a technical sufficiency to find guilt beyond a reasonable doubt, but the overwhelming weight of the evidence, the manifest weight of the evidence, is such that it does not support it. So I think you can technically have this jury question where it's like, yeah, but the overwhelming weight is the other way, so it doesn't matter in the end. So maybe, I don't know.
Welcome to the stream, Mr. Andrew Bronca,
A new
Law
friend
of Self-Defense.
Hey, this is where all the cool kids hang out, huh? This is the
Hey,
back
Andrew,
of the
it's
bus
a new
here.
friend.
Apparently.
Tell us about yourself. Who are you?
Yes, attorney Andrew Branca, Law of Self-Defense. I do self-defense law, and that is all I do, everything I do all day long, especially during these high-profile trials.
So we've got this is like the guy.
Everything we know is wrong.
This is the guy. Yes. So you've been watching the trial. You've been writing about it on your blog, lawofselfdefense.com. You've also been live tweeting the closing arguments. What's your read on what's going on?
Well, I mean, the whole thing's a travesty of justice, obviously. The evidence is overwhelmingly consistent with self-defense in a trial where the state has the burden to disprove self-defense beyond a reasonable doubt. I mean, it's not even a close call. And so that's why you see the state flailing around like this. I mean, when they go to attack self-defense, there's really two ways to do it, right? You can attack the elements of self-defense, disprove any one of those elements beyond a reasonable doubt. You've disproved self-defense, but that's really impossible on the evidence in this case for any one of these criminal counts. So if that doesn't work, you can try the backdoor approach, which is provocation. If you can prove provocation beyond a reasonable doubt, then self-defense is off the table. You don't have to worry about the elements anymore. But their evidence in support of provocation is laughable. It's this hocus pocus focus picture. And the one witness who might be able to testify as to provocation at that moment by the cars at the ambush site is Joshua Zeminski. And of course, the state was very careful to put him on ice with a pending arson case that gets delayed endlessly so he can assert his Fifth Amendment rights whenever he might want to be called, or the defense might want to call him as a witness in this trial. So it takes him out of play. And if that's all the evidence you have on provocation is this ridiculous photograph and this drone video that even the judge looks at again and again and again and again and can't see what poor Assistant DA Krause claims is so obvious and apparent, that's not proof beyond a reasonable doubt by any measure. So then you get to the third avenue of attack, which is just the rhetoric, which is just poor judgment, basically the poor judgment. We can't have 17-year-olds with rifles going to riots, and he just made a poor decision. He lied about being in the EMT. I mean, none of these things are criminal charges. I mean, he's not charged with lying about being in the EMT, or he's not. Thank God we can't be criminally charged for poor judgment. I mean, as a guy with an ex-wife, trust me, that would be bad. So there's nothing here, and I don't think even the prosecution has any reasonable expectation of convincing 12 jurors of guilt, at least if we have anything resembling a fair and impartial jury. But what he might get is one juror who is not willing to vote for acquittal. And
Yeah, I think
if he gets that, he gets a hung jury. Normally, I would say a hung jury is a win for the defense. I mean, most of our, criminal defense, you're doing criminal defense. Most of your clients are criminals. And, if you get a hung jury, at least they didn't get convicted that time around. So that's a win for them. But this is not the typical criminal defense case. I mean, a hung jury here is a theft of a just acquittal from Kyle Rittenhouse. And Prosecutor Binger will be happy to prosecute this kid again and again and again until the end of time, until this kid is ground into dust. So they need an acquittal.
Let me ask, I have a couple of questions. And first of all, I am Joe Neerman. I don't know if you put the name to the face, but I'm actually scheduled to have Andrew Branca on my live stream tomorrow evening at 10 p.m. I look forward to that. But
crap, that's not on my calendar.
What?
Okay. Did we do this by email? I do remember. I do remember
Twitter, by DM.
By DM. Okay. I'll dig it up. I'm sorry. It's crazy. It's crazy time right now. I'm glad you mentioned
He's also
it.
supposed to be on my stream tomorrow night. What's this double booking thing?
Is it really?
No, he's kidding.
So my question.
Yeah, I've got it right here. I've got it here.
Questions.
We're good.
All right, good. So I'll be sending you the link to the show before the show tomorrow evening. So I have two questions. One is I threw at the panel here, and I don't know if you maybe have more familiarity. Assuming there is a hung jury and a mistrial here, where the state comes back, do you believe that his Fifth Amendment rights have now been waived, and the state can call him to the stand against his will?
No.
Yeah,
No,
Joe,
you
you
can
were
always
gone when
reassert
I got
your-
corrected on that.
Yeah, you can
Oh,
always
did you?
reassert your Fifth Amendment rights. I mean, anything he said in his testimony here is fair game.
It's
that's-
admissible.
Yeah, of course, sure. That's all part of the record of the first trial. But if he wants, you can reassert your Fifth Amendment right anytime you want.
Okay, so the next question is a legal strategy question, and this is something you all probably heard of Darth Crypto. I had him on a couple nights
In
ago.
fact, I just connected with him on Twitter. For
Yeah,
the last couple days.
So he's done a lot of video work. Those of you who in the audience who may not be familiar, he's done a lot of video work trying to break down the Magic Focus picture and disproving the state's claims. And in the course of his video work, so he actually found video which shows right before the gun waving that Zeminski was walking toward Kyle with his gun out. And it's hard to see, it's a little bit blurry, but he's making the point that the defense could have gotten up and made the claim saying, even if you buy this argument that he waved his gun, it was not in defense of property, it was his own self-defense from Zeminski. And therefore that's not provocation, that's self-defense, and he doesn't lose his right to self-defense for provoking Rosenbaum.
But didn't Kyle testify that he didn't point his rifle?
That's correct.
Well, that's
correct.
a problem then, right?
And right, so and that's what I was thinking. Even if he hadn't testified that, as strategically, I think that's a tight line to walk before a jury. I think you're walking a tightrope, and I want to get your thoughts as far as giving the alternate arguments before a jury. Would it be wise to say, look, there's no provocation here, but even if you because he didn't wave the gun, but even if you thought he waved his gun, it was the self-defense that he was waving his gun.
I'm not a fan of these alternative hypotheses for the defense when you're arguing a self-defense case, because the jury, they want to know what the F happened, and if they believe your story, they'll acquit you. But if you start giving them, well, if you don't buy this story, we'll give you a different story, you're done.
No, that's
that was my thought also. To a judge, yes, you can parse out different arguments.
If it was a bench trial, that would be completely different, but you can't do that with a jury.
That was my thought as well. But I told him I was going to throw it out at the panel, and Yeah, you showed up, so that you're the perfect person to throw that at. Thank you.
And listen, I haven't seen Darth. I forget crypto. Is that what it is?
Yeah.
Yes.
So I saw really just one of his videos. He was doing kind of walking outside and doing like what the prosecution closing might look like, and I thought it was pretty good. I thought he did a great job. I don't know if he's an attorney or not.
He's not.
But I thought he was pretty much dead on. I haven't seen any of his if he's done like technical analysis of the whole image enhancement nonsense. I haven't seen any of that, and I don't know anything about imaging, right? I'm just a small town lawyer, but I do know whatever you put in front of the jury is supposed to be a fair and accurate representation of the original item, and that's clearly not the case here. I mean, it's simply obviously not the case.
It would have been nice if someone brought that up.
This evidence should never have been put before the jury. It's ridiculous.
Yeah.
And I think Giraffacy had a great illustrative example when he had the little squares and then you expand them and then you put stuff in here and you don't know what the hell you're putting in. That's a different image. That's not enhanced.
Especially
That's
when
doctored.
the expert
That's
themselves are
fabricated.
just saying, I have no clue. Various versions. How does it work? I don't know. What colors would you get? Don't know. What
Red,
colors would these
blue,
be?
Right.
But it was peer reviewed by someone who's my peer, who presumably knows as little as me. So
Well, again,
all
that's
good.
that's very misleading, and the defense really should have addressed that. The peer review just means you followed the standard operating procedures of your office. It doesn't mean the end product is a fair and accurate representation of the original. The peer didn't say that. If the peer was prepared to say that, they would have had the peer come in and testify.
Well, the best
Right.
part is the expert himself couldn't say it because they asked him, "Did you compare the final product with the original picture?" And he said, "No, I didn't." And so
he couldn't even swear that it fairly and accurately depicted what it was purportedly portraying, which is evidence 101 for foundation to get it admitted, is that you have to be able to swear that under oath. And the judge seemed to just ignore the fact that there was no testimony to that effect. And I think the real damage is the pareidolos effect, which is if you tell people, if you show a picture of a cloud and you say that's a picture of an Indian, in that case, people will see an Indian. If you show them the same cloud and you say that's a picture of a baseball field, everyone will see the baseball field. And that's what happens with this image when they throw in these different pictures here. And the jury is having a seed planted in their mind as to what they're supposed to be seeing. And so they're like, hey, yeah, wow, I'm positive that's what I'm seeing now.
Right. I mean, we've all seen these drawings that you look at it one moment, it looks like a woman. You look at it the other moment, it looks like a horse. And, your brain goes back and forth with the image. And one thing that really struck me about this trial is how often the prosecution argued and how successful they were arguing that, we have all these thresholds in the law for evidence to be admitted, right? There are certain qualities, certain fair and accurate, certain not hearsay. And the prosecution kept arguing, well, all right, maybe we don't meet the threshold, but let it in anyway. Let the jury decide. I mean, the whole reason we have the threshold is because we're not going to let the jury decide unless the evidence meets some fundamental level of quality. And that's certainly applied here. And later the judge goes, well, if it turns out afterwards this imaging stuff is not reliable, this conviction, if it happens, is going to collapse. I'm like, your job is to make that decision before the jury sees the evidence, not afterwards. It's too late afterwards.
I wanted to ask you about the judgments as a matter of law, judgments notwithstanding a verdict, the directed verdicts,
I think that's all
dismissal.
fantasy.
It's all fantasy.
Yeah. I mean, technically it exists, but this judge is not going to do this. This judge has places enormous trust and respect in the institution of the jury, and if they return a guilty verdict, he's not going to touch that.
So how do you feel about those appellate chances?
Appellate chances are appellate chances are zero. Always assume they're zero.
Yeah, which is fair.
It's almost impossible. Remember, right now we're in the trial phase, and in the trial phase, every presumption is in Kyle Rittenhouse's favor,
straight.
right? He's presumed innocent until proven guilty beyond a reasonable doubt. Once he's found guilty, all the presumptions are that he's guilty. And the burden now is on him on appeal. And if he didn't win when the terms were in your favor, the prospects of winning when they're not is very low. I read thousands of appellate decisions every year. And the number, by the way, first of all, the number that get reversed, very low. When you get reversed, it's not like the charges disappear. You just go back for another trial. Right. And that's the same consequence as having a hung jury here. They'll just, Binger will be happy to try him again.
Unless, it wouldn't go back again if there was sufficient misconduct that there should have been mistrial with prejudice based on that Fifth Amendment violation.
I don't see it.
I agree
The
with you.
appellate
I
court
agree
is
with you.
going to
It's
defer
terrible.
to the trial judge on,
Right.
on whether it met that threshold. And the trial judge clearly doesn't believe it met the threshold because he didn't grant the mistrial with prejudice.
Yeah, yeah.
But he hasn't. That was just filed on the 15th. They haven't actually. I don't think he's actually ruled on it yet.
No, but I think if he was going to, I
Yeah,
mean,
he would have just
he
done
said
it.
he would have done it. He would have had the hearings. He would have had the parties come in and argue it out. And he didn't bother doing that. He's not going to do that. If he was inclined to seriously consider that, he'd do it before this went into deliberations. I mean, it's an hour conversation.
Right. I agree. They should have. I thought they should have disposed of the. Well, I shouldn't say I agree. I thought they should have disposed of the case when the Fifth Amendment violation was brought up, along with the whatchamacallit. I don't want to say
rules of the court. The
propensity.
Right,
With the propensity question, and when the judge is up there snapping about it, I think that's the time that it should be dealt with, and that he didn't was frustrating to me. But he clearly wants this to go to the jury. He wants to make because he'll get pilloried if he dismisses the case, especially with prejudice. But hey, we have another guest on the stream here. But Andrew, I wanted to get your read on the performance of the defense, and if you saw any particular issues that you really liked that the defense has done, or particularly disliked in either their cross-examination or their closing arguments.
Sure, happy to do that. First, I'd like to say hi to Robert. Robert, first opportunity for us to communicate directly. I appreciate all the kind things you've been saying. Very, very gracious of you. And yeah, I mean, I wrote about the defense closing I guess yesterday. Everything tends to blur when you cover these trials for weeks at a time. But I don't want to say it was bad. It wasn't bad. It was fine. It was good. I mean, he hit the facts well, the important facts. He made a lot of good points. And this may just be a reflection of my own kind of personal and professional preferences. I would have liked to have seen a different tone. I don't think the tone helps win over jurors that are not already on your side. I think it's very well accepted by jurors who are on your side already. They feel the same way. They're angry about this unjust trial taking place. But those aren't the ones you have to worry about. You have to worry about the ones that aren't quite on your side yet, who may have some sympathy for the people who were killed or their families or whatever the case. There's some reason they're not on your side yet. And those are the people that you need to attract over. And I don't think you do that with anger, because they're not angry. If they were angry about it, they'd be on your side already. I think you need to take a more, and you have to fake it, right? Because this is obviously a terrible injustice. There's damn good reason to be angry about this prosecution. I understand why Richards is angry. I'm angry too. But the point of the closing is not to air your grievances with the prosecution. It's to win over jurors who are not yet on your side. And I think a more sympathetic tone would have helped there. And I think Giraffacy would have been better at achieving that tone. I just don't think it's in Richard's nature. The other thing I thought would have helped a lot was I felt the closing was rather meandering. I think it was a mistake to step through it in chronological order of the witnesses. I think it would have been much more effective if they'd crafted kind of a story arc that they could, because that's how people love to hear things, learn things, come to decisions. We love stories as human beings. And I don't think you gain much value by repeating the chronological order of the witnesses that the jury's already seen going through the trial. I think it would have been much better if you started with kind of a sympathetic toned opening to kind of get the jury open to hearing you, not have them close their ears, and then kind of tell a more natural story of the events, of how the law applies, why this prosecution is being brought. Then you can touch upon kind of maybe some of the political dynamics, but in a single place in the closing. There was lots of things kind of scattered around, like a box of Legos had been dumped on the floor. And I just don't think that's the most effective way to communicate to the jury this compelling narrative of innocence that you want them to take into deliberations with them.
And to the chat, I see you guys spamming that the jury is back. The jury is not back. I am watching the feeds. You cannot fool me. You cannot do it. It will actually probably be lucky if the jury does come back today at all. But I am watching, so it's not there. I don't know where that rumor started, but knock it off, you nasty kids.
So when I come across as critical of the defense closing, I don't mean that in kind of an absolute sense, but in a relative sense. You know, what I would have liked to have seen is perfection.
Yeah.
You can't get perfection, but as close as we can get that as possible is what I would have liked to have seen. And I felt there was room to be more perfect than it was.
I agree. I thought largely I was surprised. I thought that may have been Richard's best day in court personally. I thought I was really concerned about how his closing would come across, but aside from it being a little long and a little meandery at times, and I do agree with you that that sort of narrative structure would have been preferable. But I was actually pleased with his closing, and I think he came out with some good indignation against the prosecution and how they've been treating this case, and I got very much a sense of the come on, come on, jury, you know this is nonsense, you know it is. That's all they've got. Here's what we know. Here are the facts. And
I think there's a place for that, but I think you have to build up to that, right? You have to kind of seduce the jury to that point. And he kicked open that front door with that from the very beginning, his first sentence in the opening. And I think if you're a juror who's already amenable to the defense argument, that's fine. You're on that page. But if you're not, it's pretty abrupt way to try to reach out to those jurors.
Andrew, this is Matt Wilson. I'm from Mississippi. I don't think we've ever met. So what I'm hearing you say, if I'm hearing correctly, is that the art of persuasion is trying to make the jury believe that it's their idea, not yours. And so if you lay enough of the facts that are very small, bite-sized, leave them a trail, one after the other, one presumption is met after the other, until finally psychologically they're hooked, they will make the decision that you want them to make. Is that what I'm hearing you say?
That's right. And you do need those facts. I mean, obviously you can't leave the facts out. I would have liked it, frankly, if they were, how can I put it? I mean, more structured along the lines of what the self-defense jury instruction is, what those elements or self-defense is for each one of those encounters. Point to the specific fact that meets the conditions, or at least shows that it hasn't been disproven beyond a reasonable doubt, especially with respect to Roosevelt. Because the prosecution pounded relentlessly on this nonsense of you can't shoot an unarmed person, which is ridiculous. In any case, he wasn't unarmed. He was arming himself with a rifle. He was arming himself with Kyle's rifle at the time he was shot, or attempting to do so. In any case, hundreds of people every year in America are killed with nothing more than fists and boots. So, which are obviously, that would be a deadly force consequence of those attacks. So you have to look at the circumstances of the attack, not just the fact that somebody was unarmed. And I think they should have hit that harder, because Rosenbaum's really the linchpin here. Because if you believe that was an unlawful killing, then it's very easy to believe the rest of the prosecution narrative that all the consequences that followed are also Kyle Rittenhouse's fault. If you believe that was a lawful killing, well, then Kyle Rittenhouse is an innocent person running to the police for help and getting assailed by a mob, which of course is the defense narrative. So you really have to, crush it on that Joseph Rosenbaum incident.
But Andrew, have you considered that everybody takes a beating sometimes?
Yeah.
Like, did that thought occur to you? I need to know.
It's amazing. It's amazing. And again, frankly, I would suggest that there were a number of points that Krauss brought up on rebuttal that had not been adequately addressed by the defense cross, and should have been, because they were predictable that they were going to be argued. And you're not going to have a chance to come back after rebuttal. So I did think that was a shortcoming.
Can you give examples of what Krauss said that you thought he failed to address in his?
Well, this whole unarmed thing. I mean, Binger had mentioned that repeatedly over the course of the trial. That's going to come up, and they just didn't adequately address it on cross. They should have made clear you absolutely can use deadly force on an unarmed attacker if the nature of their attack is one likely to cause you death or serious bodily injury, and if they're threatened to murder you, and we have credible evidence that they threatened to murder you, and no evidence that they didn't. Right? I mean, that the prosecution keeps saying it wasn't caught on video. Well, that an absence of evidence is not evidence. That they didn't have a witness testify, hey, I was with them the entire time. I saw everything they saw. That never happened. Right? They couldn't say that. They didn't actually have any substantive counter evidence to the testimony of the death threats. And if someone threatened you with death an hour before and is fighting you for your rifle, that's a deadly force attack. The reasonable expectation has to be that they intend to use that rifle against you. That rifle is the only thing keeping you alive. That's your life preserver. And if all they do is take it from you, then the rest of the mob kills you.
And the of course the big problem for the state is that testimony about the threat came in from state witness Ryan Balch, right? Like they elicited that testimony on their own. They don't get to say, well, the defense gets their convenient. Kyle saying it could be very convenient, but Ryan Balch was brought by the state. They asked him the questions. He's like, well, he did threaten to kill us that one time.
Right. It's a very common pattern you see in these politically motivated trials. And of course, I'm speaking mostly about these self-defense trials, which is my area of expertise. But same thing in the Zimmerman trial, same thing in a lot of these trials. The prosecution starts to present their case, and they call witness after witness after witness. And you're waiting for them to show you the substantive evidence that's inconsistent with self-defense, right? They have to disprove self-defense beyond a reasonable doubt. So that's a high threshold. And witness after witness after witness for the state appears, and their testimony is either ambiguous on self-defense or it's actually favorable for the defense. Happens all, and it's because they don't actually have a meritorious prosecution to bring.
And I think that the defense failed to make that point very much, if at all, that all these witnesses who were so favorable to Kyle, that Balch was put up on the stand, they were brought by the state. The state's own witnesses are the ones who said that there was a threat to his life, that Rosenbaum threatened to kill him if he ever caught them alone. That's the state's witness, not our guy who we found and plucked out. The state knows this is true, and they're going to sit here and lie to you and tell you, well, this person we put on the stand, don't believe them. Disbelieve this person. We put him. Why would the state put him on the stand if they think that you shouldn't believe him? They put someone on the stand who they think you should believe, you should trust, and that person who the state thinks you should believe, you should trust, told you under oath that he and Kyle were directly threatened that by Rosenbaum that he would kill them if he ever caught them alone.
Yeah, guys, I should mention I'm Italian by heritage, so I tend to talk a lot. So don't just let me dominate the conversation. Feel free to jump in any time. But if there's silence, I'm prone to fill it.
Well, I think we're really happy to have your specific expertise on this type of issue. I mean, like again, I said when you came on, you're the guy. You're the guy to have on a show like this. So it's really great to have it. So I know, as for me, I mean, I'm going to personally hold it against you, but I'm just like to listen and absorb what you're saying. But I do want to ask Mr. Barnes, how's it going, man? Welcome to the show.
Good. Yeah, I mean, Andrew was one of the people that I wanted as part of a dream team for Kyle. And I think as we've witnessed in the trial, and we'll see, if it goes past today, they did not do their job on jury selection.
Yeah, I concur.
Again, that was totally the choice of Richards and some people around him. I thought Richards' close was the best close he could give. That's not saying it's the best close a good defense lawyer could give. He's a bulldozer. That's who he is. And the reason why he did the chronology, or it was recommended to him to do the chronology, is that it stops him from meandering even worse.
That could be.
It keeps, it's just his limitations. And I mean, I thought Kyle got a poor defense, frankly. I've made that clear all the way through. I thought he deserved a much better defense. There was the funds raised and the lawyers available. And the assistance available to do it. There was tons of people who were willing to help without any advance guarantee of payment. So it's if this goes past a day or two, then there's a real risk of a mistrial. From what I heard, the 12 out of the 18 were considered, at least by the journalist watching, as a more pro-prosecution 12. That it ended up being 7 women and 5 men. 1 Mexican-American man, 4 immigrant men from different backgrounds, but like several very blue-collar Green Bay Packers, probably gun owners, were excluded out of that group. Kyle got a little unlucky on the draw, it appears. You never know for sure, and I don't have any confidence in the jury selection of either side, honestly. Now, Andrew, were you surprised that neither side talked about much of the jury instructions and close in detail? Like, usually what you're talking about is you go through the instruction, you give the jury a roadmap. You're asked this element. Here's the evidence that proves it or disproves it.
That's exactly.
I mean, they had to
exactly
ask
what I
for
would
it
have done.
because it was clear they were still not really sure what self-defense was in Wisconsin.
Right. So, I mean, apparently there's 36 pages of jury instructions, which are going to be pure legalese for lay audience. It's going to be intimidating in the extreme, very easy to misunderstand, especially, by the way the judge read them the instructions, which was
God.
meandering and confusing. I mean, he confused himself reading the instructions. He's the trial judge. So what are we supposed to expect from the jury? You have to baby walk them through. You have to say, here's the first element of, and of course, just do it for self-defense. I mean, frankly, I would have told the jury explicitly on closing, look, you're doing yourself a huge favor if you just look at the self-defense jury instruction before you do anything else. Because if you do that and you find in your judgment as the jury that self-defense has not been disproven beyond a reasonable doubt, you can go home this afternoon. You're done.
Did you?
That's a very good point, because the jury at this point is probably just exhausted. They want to go home, I would imagine.
Right.
So,
they
that would
could
be a very
read
tempting
one
offer.
jury instruction. They could read jury instruction 805. It's the only one they have to read. And if self-defense is not disproven beyond a reasonable doubt, their job is done.
Did you?
Now, the good news is that's what they requested.
Yeah,
I heard that. Yeah.
1 through 6, but that's mostly just the self-defense instruction.
I heard that. That's very encouraging.
It's the self-defense and the first charge, which, as Andrew said, and similar to what I've said, that the first charge against Rosenbaum is the linchpin of the whole case. If he's justified in shooting Rosenbaum, it's going to be very hard to say he's not justified in the rest of his activity. But if he's not justified in shooting Rosenbaum, it's very easy to say, yeah, now he's an active shooter. Now he's a murderer in a crowd of people trying to stop him. And that, of course, is a narrative the state's tried to build. But hopefully they'll just look at those two things: self-defense, crazy man chasing you down into a place where you have nowhere to go and catching you. And I think that maybe is a criticism of the defense. They didn't ever expressly say he wasn't chasing Kyle Rittenhouse. He caught Kyle Rittenhouse. He caught him. It's no longer a chase at this point. It is now, what do you do when you're caught? I mean, sure, we can argue over distances, but if his hand is on the barrel of the gun that you're holding, then he's caught you at that point, because it's just that next second is him grabbing you. And we know with Rosenbaum, that's a problem that he tends to have.
Plus, withdrawal is a defense, is an exception to provocation in the sense that they find provocation. If he withdrew and gave notice, all his self-defense privileges are restored. The duty to escape, that's only triggered by provocation. If you look at it, they could have broken down the videotape to show he really withdrew and gave notice of it 3 different times just within those few seconds in the parking lot, because he sees Rosenbaum. Let's take the prosecution's theory. He points the gun at Zeminski. Then he sees Rosenbaum. What does he do? He does my version of explaining retreat or withdrawal to a jury is Leonard Skinner's song, "Give Me 3 Steps," because that's what that is all about. Give me 3 steps and I'm out the door. Everybody cool. No shooting. He tries to step back and flee back up the road, but he can't because he's blocked. And then what does Rosenbaum do? He comes at him. So that was the first that was the first retreat. That was the first withdrawal. That was the first notice of it. Rosenbaum's reaction is to attack again. Then he's going across the parking lot. Something gets thrown at him. He hears a gunshot. He stops, turns around, shows he has the gun to Rosenbaum. Really gives him the second chance to withdraw. He himself is withdrawing because he's going to turn around and run again. And Rosenbaum chooses to follow him again and run after him and chase him again. Then really at the third time, I thought the defense could have done a better job of explaining what happens at the end, because my interpretation of that video drone evidence is Kyle realizes he's trapped. He turns around and really shows Rosenbaum the gun. He gives Rosenbaum a chance to do something. And Rosenbaum instead, as Richie McGinnis's great testimony attested on Binger's foolish cross redirect of him, he yells "F you" and lunges for the gun. And then you have the medical examiner's testimony that the way in which his hands were injured is consistent with him having a hand on the barrel and lunging for the gun. The prosecution tried to lie about, mischaracterize that evidence in their close.
Oh my gosh, their thing with the hand being like this and trying to explain that the bullet went in here and came out here. It's like, what? No, there's no evidence that happened. His hand was like this. That's how the bullet would come in here and come out towards him. That was infuriating.
Kyle gave through, Binger wanted to break down Kyle's decisions in the milliseconds as if he had hours. But take that and flip it around. Look at what he does. He tries to retreat, tries to retreat, tries to retreat, tries to withdraw, tries to withdraw, tries to withdraw, does it repeatedly. And it's only when he is trapped and at the third time where Rosenbaum is within inches of being able to possess that gun and use it in whatever manner. And as Andrew notes, my understanding has always been you put your hands on a gun, you're armed. You're not unarmed anymore. Kyle shot 2 people that night that, in my view, were armed, and then the third person that everybody admits was armed, because both of them were going for or grabbing the gun and had their hands on the gun, and there's testimony from independent witnesses and visual and photographic evidence of that being the case. Those weren't unarmed people. You go for the gun, you're responsible for that weapon. You're considered armed under the law. There are people that have been prosecuted on those bases in different states.
I mean, police officers routinely shoot suspects who are fighting for control of the officer's gun, and that's completely justified.
Police
Absolutely.
officers would have shot when Kyle turned around the first time. I mean, let's be honest. And been likely justified in doing
they would have
so.
shot Zemitsky and Rosenbaum right when they said something threatening to them, right at the very when he's walking up. They would have dropped the extinguisher and gone boom, boom. Plenty of cops would have.
Yeah, Zeminski's armed
and
at
they
that
would have been
point.
considered a justifiable shoot.
Yeah, so the whole narrative about provocation is frustrating, and yes, to the people in the chat, we know. Well, I shouldn't assume. I know, and I assume everybody on the panel agrees that Kyle Rittenhouse, there's no evidence that he actually raised the gun. What we're doing is talking through the alternative.
I told them it was coming all the way through. There was a lot, but hey, credit to I think Good Logic interviewed him. A lot of the stuff that came over the weekend got to the defense team. Praise God, because on Friday they were not alert for this. And on earlier in the week, when Andrew was talking about here's where they're going, they should make a motion to exclude where this theory is because it's an impermissible application of provocation. They were frankly behind the curve, despite me telling them before the trial, months before, this is where he's going to go because he's going to misapply provocation for the liberal Democratic juror who believes Kyle never should have been there, Kyle shouldn't have a gun, and don't like AR-15s. That's
right. So
what
they're trying to.
That's
They're
exactly
trying to.
what he did with his closing.
They're using provocation. Binger he's trying to apply it in a legal context, like the normal common usage of the term. Like anything can be provocative.
Right.
But that's not the legal meaning of the word. The legal meaning it has to be attached to some immediate forcible response.
Much more limited.
Right.
I've been describing it as an overt act.
The fact that he showed up with a rifle, I mean, in a general sense, might you argue that's provocative? Well, maybe, but unless it triggered an immediate violent response, it's irrelevant for legal purposes.
Right. And under Wisconsin law, your provocative act has to be an unlawful act.
Unlawful, right.
So if it's not an unlawful act...
That's why they fought so hard for this ridiculous bullshit gun possession charge before they had the hocus pocus photo, because they needed the unlawful act as the predicate for the argument for provocation. And they didn't have anything except for this gun possession thing, which, by the way, I did my legal analysis of that charge the week after the event, and it was clearly bullshit then. I was shocked that it didn't get dismissed long ago. I mean, thank God Judge Schroeder finally dismissed it, the day of closing arguments, the morning of closing arguments. I mean, just any plain English reading of that statute makes clear that Kyle is exempt from it. But the state had to have it because if they didn't have that unlawful act, they had no predicate for provocation, and they had to have provocation because the other evidence was overwhelmingly in favor of the elements of self-defense.
That's why they shouldn't have let the curfew charge go so easily, because that would have given him a thin but still a rail to say, hey, he wasn't even lawfully there. And they just were lazy about that. And I assume that's why they were going to pursue it, but they just dropped it effectively.
Yeah, I don't know the backstory on that. I don't know why they let it go either. Perhaps they felt they had him snowballed on the gun possession thing.
Apparently, there's an issue about whether it was actually a lawful curfew order that's being tested in another Wisconsin court, and they didn't want to relitigate it.
Yeah, I think in Kenosha, a different court in Kenosha or maybe in Racine, they said that it was not, but it was just at the
Kenosha.
district
Another
court level.
Kenosha court, fellow judge, of Judge Schroeder, said that that there was no lawful curfew order because the order itself was unlawful.
I think the lateness of the dismissal of that 6th charge for gun possession probably worked to Kyle's benefit, because they had their photo slides all set up there as to how they were going to structure everything. They start having technical issues and can't figure out what to do it, because I'm sure a lot of Binger's closing argument was built into predicating it on that gun possession issue. And once that was stripped from them at the last second, they were left trying to scramble and adjust their arguments without relying on using gun possession. I think that they're a very slow moving boat. They're like the Titanic with a very small rudder in the back. If they have to change directions on the fly like that, I think both teams were very weak at showing that flexibility. So that last second change probably really hurt the state a lot.
And it was
I don't understand why they
inexcusable
didn't
of
have.
Binger to not.
Yeah.
Sorry, just inexcusable of Binger not to know what that law says. I mean, I call it the Wisconsin Farm Boy exception.
Well, he
It's been there
knows.
for forever. They
Well,
want
also-
a 17-year-old. They know that the oldest son is going to sometimes need a shotgun or a rifle on the farm to make sure no problems happen. They passed those gun control bills to deal with Milwaukee criminals and handgun violence. They didn't
Yeah, but
draft it. That's why they
Binger's
made
like,
clear this is exempt.
He's
Well,
like
they
a
also-
Chicago lawyer imported into Kenosha.
Yeah, exactly.
I mean, his
Exactly.
mindset.
I don't understand why he didn't have a backup closing, because they had notice over the weekend that this was maybe going to get tossed out. They had 2 days ostensibly to put something together, like, okay, just in case A scenario doesn't happen, we need to prepare for B scenario so that, we have something smooth to put together.
Little
I'm
Binger is good at
so
being
surprised.
sleazy. He's not good at recognizing his own limitations or restrictions. He lives in his own little world. That's why you saw him make the mistake. Like, if you'd studied McGinnis at all, you would know to be very careful with him as the prosecution on direct or redirect. And he just walked right into it. McGinnis just smacked him across the face. And he kept doing that. And then Sauerkraus, when he got up there at the end, he can't help himself. You poke him a little bit, he just loses his mind. And he was just off. I mean, there's an old saying in Florida, never talk about rope in a house where there's been a hanging. Well, in the same sense, Sauerkraut, there's no reason to go back into, hey, how we tried to suborn perjury from one of the witnesses. I mean, just skip that. You're in rebuttal. You got tweaked, move on.
He just got completely off mission. He just personalized everything. That was him speaking as a person, not speaking as a prosecuting attorney. And Binger is one of these guys. We've all met people like this. He's not stupid. He's a clever guy, sneaky maybe, but he's not nearly as smart as he thinks he is, and that leads him to be vastly over clever and get himself jammed up.
I would describe him as the typical federal prosecutor I've dealt with. Smart. Probably did decent in law school. Knows how to argue certain things. Knew how to work the judge well. I mean, for all the yelling that took place, he knew all he got to do is take the yelling, then move it a little, he'll back off.
And also,
he worked the judge very, very effectively in that sense.
And he displayed that over and over again. Every time there was emotion, so many times we would hear the judge come out of the gate in a direction that sounded completely favorable to Kyle. Even when he was talking about that photo evidence, he's like doing his own discovery, saying, "Hey, when I enlarged my phone, I realized that everything became much blurrier here. I don't understand how we're able to trust this thing." And we here on the panel sitting here cheering, like, "Yes, thank God! Finally, he's realizing that these pixels are not enhancing the image; it's making it impossible to tell what the image is actually showing." And Binger just kept adroitly just pushing forward, and not caving in until he basically wrapped Schroeder around his finger for like the 15th time that we had seen over the last couple of weeks. And I think that's Binger's experience with Schroeder personally. He's had like 400 trials in front of him, and he knows how to push Schroeder around and make him pretty much his bitch as far as doing what he wants, even in questions where it's questionable as to whether it's compliant with basic evidence or trial law.
Well, it's one of the first things I was introduced to in family law and state court. It's a lot of state court judges are this way. They want kind of people to get along. They don't want to make tough decisions. They don't want to be seen as, fair. And I learned that like the lawyers that kept whining after they lost kept getting relief, kept getting remedy, it was like, okay, the judges say they hate it, but the people who do it keep getting rewarded for it. So you learn how to, and Richards, unfortunately, Nick pointed it out live during the jury instruction conference. When he walked back, we've already litigated it, he lost it. All you need to do was whine 4 more times to the judge, and the judge would said, "You're right. This is nonsense. Not going to bring it in."
Also, making decisions is hard, right? Making decisions takes effort and thought. And most of us, I do this in my own practice. You come up with rubrics, algorithms for making decisions so it's more efficient. And Binger had clearly identified the algorithm that the judge liked for making decisions. And he would just check off those boxes, and the judge would go, like a little computer, "Okay, I guess that's it. We'll go your way then." And the defense simply didn't have that nailed down.
Yeah, and it was so baffling. And that particular moment, I think, is a big failure of Richards and Shirafisi. Because Shirafisi says, it's already been hashed out, Judge. We're gonna, whatever. that was a mistake. But also, right before that, SureVC was making a compelling argument that it doesn't show. Their expert wasn't good. Judge, they're not able to do this. And then Richards comes in and he gives the judge the excuse he needs. He says, Judge, even if he's raising his gun at Zeminski, does that give provocation for Rosenbaum? And now you've just asked the judge a question that he wasn't needing to ask prior. And the answer is probably yes. And I don't know, let's ask the jury. And so now you've just said, well, there is a potential fact issue here when they should have just stuck with, no, this can't come in because it doesn't show it. You just watched it 10 times and you still don't see it, Judge. I know you don't see it. You know you don't see it. They know you don't see it.
Another big difference between the two sides was, and you see this a lot with Binger, so he'd have some argument he wanted to present to the judge, but he wouldn't present it once, right? If it was like a 4-point argument, he'd say it in one giant paragraph 18 different times. And it made it sound like it was 18 different arguments, but it's just the same thing. It's just like with this ridiculous drone video footage, right? They made it appear like it was 5 or 6 different pieces of evidence, right? Oh, we got the drone video, and now we have the slowed down version, and now we have the enhanced version, and now we have the enhanced zoom version, and now we have 2 photos, and now we have the detective look at the photo and tell us that he sees the gun being raised, as if those were all different pieces of evidence.
And now I have it on my phone. You looked on the screen. You need to look it on my phone.
And now it's on the TV, and now we got a pointer. And it's all one piece of evidence. And Binger did this with his arguments in front of the judge too. He would just keep talking and talking and talking, and it was the same thing over and over again. Whereas Giralfasi would sometimes have a good argument to make, and the judge would say, "All right, well, do you have anything else to add?" He's like, "Nope, I'm done." Holy crap! Just make the same argument again. I mean, as long as the judge is going to let you to talk, keep goddamn talking.
Yeah, and you got to keep pushing every trigger the judge has. And one thing I thought one of the disagreements we had was I wanted to go at Binger all the way building up to trial because he was going to do a lot of this stuff at trial. So you had to prepare the court of public opinion and prepare the court and make the court feel, at least what I wanted was the court to feel guilty about having a corrupt prosecutor doing a corrupt prosecution right in his courtroom. Because he was already bothered by the fact that Binger was even bringing the charges. There was attributes of Binger he already didn't like, and they needed to be highlighted and enhanced and pushed back. The court of public opinion media was always going to try to hammer the judge. Push back. This is about governmental corruption, prosecutorial misconduct. This case wouldn't be here but for Binger bringing it. 99 out of 100 prosecutors do not bring these set of charges. And go through Binger. Binger has a history of this in Kenosha. He has a history of people like Binger don't suddenly wake up and start breaking the rules. They don't, accidentally violate somebody's Fifth Amendment rights by accident. They don't accidentally try to suborn perjury. I think he did suborn perjury from the 2 car source witnesses. There's no way he didn't know they were completely lying and libeling. They effectively helped Grosskreutz hide evidence because they selectively applied Macy's law in a way that prosecutor's office in Kenosha had not done previously.
That was insane.
It was just one after the other, after the other, after the other. But that would have had, I think, more dramatic impact on the court if it had been built up. Because what he was also doing was lying in bail proceedings. I mean, people forget this dimwit Binger, a little Binger, this corrupt hack, went out and told the court that the 8th Amendment right to bail he didn't think applied in Wisconsin, the way he interpreted it, the constitutional right to bail. I mean, that was an absurd argument, asinine argument, what he was trying to make a claim toward. So it should have been built up that this guy is a corrupt, rogue prosecutor who's going to go rogue at trial. He's going to make up facts, going to make up law. He said there was a duty to retreat outside the context of provocation in the beginning of his closing. I mean, I had no reason. I have no doubt the jury went back and was like, what exactly is the law? Because you have the judge's version of it. The other thing is they shouldn't have read the combination. Like the combination of reckless endangerment, there's a part of reckless in self-defense that doesn't apply to reckless endangerment, and there's a part that does. And ultimately, the court determined if he had self-defense against Rosenbaum, then he had self-defense against McGinnis.
Well, that was a lucky break for the defense. I mean, because that's a admittedly confusing area of the law. If you're just a layperson, it looks like circular reasoning, very difficult to understand, and the judge simplified it. I mean, frankly, probably more than the law actually calls for in favor of the defense.
Yes, because the idea is that if I shoot at Andrew and hit Runkle, I don't have self-defense as an argument against Runkle even if I had self-defense against Andrew in certain circumstances. That's where that language comes from in reckless endangerment. But in this context, it becomes tricky and confusing. And the judge, in the same instruction early on, he said, by the way, there's no self-defense here. And then he said, oh, there is self-defense here. So that was why it's critical that he gave that clarifying instruction. That if there's self-defense here,
I mean, for all you lawyers know this, but for people in the comments, I mean, the way this is supposed to work is if you're attacked by an armed robber, and you pull your gun and you shoot him once, and the bullet goes through him and strikes somebody else, right? Your conduct was reasonable in defending yourself. It was lawful self-defense with the robber, and it wasn't unreasonable and unjustified risk with respect to the bystander who also got hit. So it covers you there. You don't have a right to self-defense against the bystander. They weren't threatening you, but the fact that your conduct was reasonable means it wasn't reckless, because reckless conduct is by definition unreasonable. The alternative scenario would be if you were faced with an armed robber and you pulled out a machine gun and sprayed 50 bullets all over the neighborhood and then hit innocent people. You still have your privilege of self-defense against the robber, but now your conduct was reckless with respect to the bystanders.
And the state is trying to play a game with the type of bullets you use to imply that that's like using a machine gun. That they say when you use a full metal jacket, that's likely to pierce through the body, come out the back, and end up hitting McGinnis or anyone else who's behind.
I mean,
and that your choice of bullet now makes you reckless. But as we were discussing earlier, that's a game that they'll play, because if you use a hollow tip, which is more likely to blow up in the person's body, they'll say, well, your conduct, your self-defense was unreasonable because why'd you have to use a hollow tip? That's more likely to spread his body and kill the guy.
It's never the right
damned
bullet.
if you damned if you go A, damned if you go B, and that's intentional by the state, I believe.
Andrew,
the prosecutor doesn't have a preferred bullet type that's acceptable to them.
No.
The
Have
common
you ever
sort of
seen
wisdom.
Anybody, a prosecutor, actually point a gun at the jury with his finger on the trigger before?
No.
That was new to me.
Ian,
Bronco, what were you asking?
The sort of common advice, and I don't actually know how it plays in court because I've never been in the position of making this particular argument, but people always say, get whatever the local police department uses for their handgun ammunition, because then you can easily turn it around. It's like, why do you use this? Well, because the police do. Tell me it's unreasonable.
It's it's simple. For handguns, police use hollow points, and for AR-15s, they use full metal jacket rounds.
I mean, I carry the same ammo, whatever it is that the FBI is issuing to its special agents that year. I have a friend who works for the firearms training unit there. I say, what are you guys using? Gold dots? All right, I'll get a box of that.
Yeah. So I was looking for opinions on this. The judge gave Kyle the opportunity to scrap the lesser includeds and just go with the original charges. They declined to do that. Do you guys think that that was a wise or unwise decision? We had a Tennessee defense lawyer on the other day who suggested that, and he has a personal preference towards never having a lesser included because he wants proper charging just in general. But in this case specifically, good move, bad move, why would they make it? Why would they not make it?
I mean, do we know whether in Wisconsin the defendant has the privilege of rejecting the lesser included? Because that's not the case everywhere.
I think that's what the judge. I think that's what the
it
judge
creates
said.
a different appellate standard. He doesn't have an absolute right to reject it.
Okay.
But it's that it could be considered ineffective assistance if his defense counsel didn't object and he wanted to object. That's how. That's
most
why
of the trials
judge
I've
did that
seen, the
rule.
defendant doesn't have the state is privileged to have those lesser included. When they gave you the higher level charge, gave notice to the defense of the higher level charge, they implicitly also gave notice of all the lesser included charges.
What about
it was really
that's
weird.
Wisconsin's rule. I mean, the key was once Kyle testified, those lesser included were coming in. That
And
was
what
a
about
risk of
that
Kyle testifying.
At the end of the jury instructions, I believe, didn't the judge have a colloquy with the defendant? And
Sure
and I
did.
thought,
Yeah, that's why.
This is
to
what made
deal
no
with the,
sense.
Try to move.
I mean, if he has no say in whether or not you have lesser included, and if it's just strictly the judge's discretion, then why even ask him? I mean, being
because of the
practicing in Mississippi and Tennessee, we don't do that.
No,
because
Robert
of
has
the
the answer.
Th-
Robert's
There's
got
been
the
a
answer.
court case in Wisconsin where a defendant objected to the defense counsel's failure to object to a lesser included, and it became an ineffective assistance of counsel issue. So now courts do a colloquy to make sure the defendant's on the same page as counsel at the time.
But here's the thing that's so weird. They spent 3 hours trying to knock out every lesser included, arguing that the state would say we want to have this lesser included, where the state and the defense counsel ended up taking opposite arguments. It sounded like we were in Bizarro world, where it sounded almost to to a layperson like the defense was arguing, for all these terrible things that he did as a basis to establish that those lesser includeds don't make any sense. So you spend all these hours with your counsel sitting there trying to fight and keep out all the lesser includeds, and then you get to the very end there and they ask Kyle, so you want these lesser includeds? And he's like, yeah, I do. Well, if you do, then why did your counsel spend the last 3 hours trying to strike them all down?
Well, I think what Barnes, you're saying that Kyle could not have objected to, or could not have revoked them. He just could have objected to them if his counsel had not, and then that would preserve on appeal ineffective assistance.
So then why not object to them and then preserve that at least? You lose nothing by objecting to them.
I don't know why they didn't object. I mean, it depends on how you see the case. For some, they think it's better to put lesser includeds in if you think they're going to get concluded, on a life imprisonment charge. As a defense lawyer, you want the lesser included. If you think that they would never convict on the higher charge, but they might on the lower charge, then you don't want the lesser included. But once they put Kyle on the stand, it was a guarantee the lesser includeds would be there.
I think that was a big risk of Kyle's testimony that came out as they were arguing the lesser includeds. Most of their argument was based on his testimony on cross.
Yeah, I mean, I agree with Andrew who said before the trial, the only two ways you can lose this case is you could take a gamble of putting Kyle on the stand or you get a rogue jury. And I think they've managed to create both risks in the case, unfortunately.
I'd like to switch gears for a second and ask Andrew or Robert a question, because this is something I had a conversation with several people. This is not designed to fluff myself or the panel here, but you brought up earlier, Robert, that you were saying that I don't know if it was a stream that I did or something that I did that got to the defense counsel. If you could clarify that, you can clarify that for me off camera. I'd be really curious and flattered to know that if any tiny little 10th of a percentile I was able to help Kyle's defense, that's amazing. But my question is this: I've had conversations with people about the social significance or potential social significance of this panel and what we've been doing here, because this is a brand new thing that I don't think the world has ever seen, where you can watch multiple attorneys weighing in with their honest opinions, fact-based opinions about what they're witnessing at trial, and that this could have unique social significance, and from the perspective of looking at it going forward. And I was wondering, and when you made this comment about the fact that, hey, I was able to potentially have some impact in a way that a week ago I never would have imagined would be possible. So that only strengthens my perspective on that. I wanted to ask you whether you thought this is something that is unique to Rittenhouse because of the great passions on both sides of the aisle. Usually there's only passion from the left, not so much passion for the right. There's no passion for the right for Chauvin. There's no passion on the right for McMichaels. But for Kyle, there's passion. So now you have passion on both sides. So I think this case is special and unique. Or do you think that, this could potentially have social significance even on cases that are less passionate concern to the right side of the aisle? I really would like to get perspectives from attorneys who I respect. Robert, you've been contributing it all on the panel, but you have far more important work that you're doing. And Andrew, you've been watching also. So I'd really like to get your perspectives on that.
Well, first of all, I don't know how you guys do it. I mean, kudos, especially Nick. It seems like you're on my computer 24 hours a day doing live stream this or that. And Robert, you're almost as frequent between locals, and I don't even know how all that social media stuff really works, to tell you the truth. But I keep getting notices and stuff popping up on my computer all day and all night. So congratulations for that tremendous effort and exposure you put out. I suspect it does make a difference. I mean, I had the Rittenhouse legal team reached out to me about halfway through the trial. Nothing ever of substance came of it. I mean, frankly, I told them everything I have to say about the trial is free. I mean, it's on my blog. I'm not hiding anything. I'm not holding anything back. That's my, so I mean, a large part of my practice is doing legal consulting on these kinds of cases. But if you're willing to wait until the trial's in progress, you get it all for free because I'm talking about it publicly. So I know they became aware of me. I don't know. It's hopefully we can have some beneficial influence. And by the way, I should mention Normally, most of these cases, I mean, this one's a little different, but I don't know any of these people. I don't know any of these defendants or any of these lawyers. I don't have any personal investment in them. I'm not picking sides. I call these cases as I see them, and sometimes half the country hates me for that, and sometimes it's the other half of the country that hates me. But all I can do is do the legal analysis I do and share my opinions with people. Hopefully, we end up with something that's more informed. And my goal is just that we have pretty good self-defense laws in this country. We really do, and the legal standards are pretty good. They could use some tweaking, but they're pretty darn good. And if we apply them in a fair and impartial way, most claims of self-defense are, let's face it, they're bullshit. They're bad guys who doing bad things, and just their lawyers raise the legal defense because that's what you do as a criminal defense lawyer. But the good guy cases of self-defense are different. And the way the laws are written, if the evidence is at all consistent with lawful self-defense, it ought to be an acquittal. It ought to be no charge in the first place.
Right.
But people don't understand the law. And frankly, many lawyers, many judges, many prosecutors don't really understand self-defense law. We're not taught this stuff in law. I don't know about you guys, but in my 3 years of law school, we barely touched on justification at all. And if you're not a criminal defense attorney, you don't have any professional need to know this area of the law. And if you are a criminal defense attorney, most of your clients are criminals, and they're just bad guy cases of self-defense. Most of the lawyers I talk to tell me in their entire careers, they might have 4 or 5 good guy cases of self-defense come in their office. And that's just not enough to develop any high level of expertise. I mean, I'm very unusual because I kind of do a legal consulting practice. So I work on cases, nonstop. That's all I do. And I work on cases all around the country. So I have an exceptional degree of exposure to these legal principles as they're applied in all 50 states and Guam and everywhere else. But most lawyers don't have that. I mean, they just don't have that depth of experience. You could not support a law practice just doing self-defense cases in your local area of good guy cases of self-defense, because you're going to have 4 every 20 years. That's not enough.
Well, right. Even self-defense cases in general, if you're talking about homicide self-defense cases, you're talking about first spreading all of the homicides out and then having a subset that have any even colorable claim of self-defense. Right. is a tiny subset. So it's difficult. And you're right. They don't teach it in law school. In fact, criminal law is not on the bar, I believe, and was an elective in my school. So it's like, oh, well, I guess if you want to have even a basic background in criminal law, you have to choose to do that.
So there was no mandatory 1L criminal law class?
I don't think so. I'm pretty sure
No,
I chose to take it.
Like for Wisconsin, both criminal procedure and substantive criminal law were both required. But to give an example on self-defense, the law professor who taught me that told me that he thought there was a problem for Kyle because he was, what's a 17-year-old kid doing with a gun in the middle of a riot? And that's my criminal law procedure professor. So Viva. Oh, but two good logics. Two things. One is to show the power of the court of public opinion and the involvement of the ability to access experts outside of the gatekeeper institutions. I knew about Andrew because of his Law of Self-Defense channel, also because of his book. But it was enhanced by getting to see somebody visually. You get a sense for who they are. Because sometimes people write books and it's their book. Sometimes they write books, Donald Trump maybe, and somebody else wrote the book. You don't always have a sense for who they are. And so it was my advice for the Kyle Rittenhouse, the whole team, to bring you in, to bring in several other people. That's why they reached out. But that's an example of the utility of independent commentators. Then Richards wanted to go do his own thing. That's another story for another day. But to Good Logic's point, Good Logic interviewed, I said the other day, I never thought I would thank someone called Darth Crypto for a case. But there's this guy, Darth Crypto, that was breaking down the video actually months ago. He'd been sending me stuff that I've been forwarding to the defense team. But he did a great job of breaking down. He was anticipating what Binger was going to say 4 days in advance. He was sending it to me saying, here's what he's going to do. Here's what he's going to do. Frankly, the defense team unfortunately ignored it all the way through Friday. But after they saw what happened Friday, when Good Logic had Darth Crypto on his channel, Jack Posobiec promoted it, other people promoted it, Andrew promoted it, and all that intel got to the defense because you saw a very big difference between their argument in court on Friday and Richard's close, explaining how this is a blurry video. It goes from left-handed to right-handed. That doesn't even make sense. You get Sauerkraus had to lie about whether there's left-handed or right-handed guns. in order to try to retort it. Anybody on the jury that knows otherwise is like, this dimwit's lying about that. What else is he lying about? He could have easily lost a juror just on that issue. And really blew up that part of their close. And that was entirely thanks to crowdsourced information and independent panels of people getting that to the defense team. There was a bunch of stuff Richards, I don't think, would have had in his defense, in his closing, but that I thought were important points. Like what Yellow Man actually said was not Kyle pointed it like this. He said Kyle was like this when he pointed the gun. Totally different story.
That's what Darth Crypto
That point Richards made on close. Had not made it before that point. Indeed, didn't really even prep Kyle for his Karas on that point because he could have corrected him in live time. And with this judge allowing speaking objections, heck, he could have told Kyle what to say with a speaking objection.
Yeah. The I want to say we were talking about criminal law in law school. I did have to, I was required to take Con Crim Pro, which is one of my favorite classes, constitutional criminal procedure, 4th, 5th, and 6th Amendments. But in my criminal defense or my criminal law class, our criminal law professor skipped over sexual assault because that was an uncomfortable topic.
Nice.
So that's the status of law schools going out there anyway.
Oh, we didn't skip over it.
We did.
We went
And
right through it.
I want to welcome to the stream, Mr. Viva. Hey, what's up, buddy?
I'm at home with 2 kids who have the sniffles because when kids have the sniffles and a cough these days, they are worse than Typhoid Mary. But I've been watching In and Out. Andrew, nice to meet you.
Nice to meet you, sir. I'm a big fan.
No, I know of your work, and now it's good to meet in person, at least digitally. And I just heard Joe's question. There's no question that crowdsourcing information is just as valuable as crowdsourcing money, crowdsourcing fundraising, and it will be the status quo going forward that people will be watching social media in real time for these types of trials to get the aggregate knowledge of the internet, to do information research, pull up stuff faster than they could have otherwise done on their own. So
you think we need to do this more going forward? That we need to just continue?
It's going to be a thing going forward. It's just going to be a question of which trial is of interest to which lawyers and which trials are being broadcast. My prediction, they might not be broadcasting. They won't be broadcasting these trials quite as often as they might have been in the past if they see, the power that people have to bring this Rittenhouse trial to 100,000 people in real time. The shutdown yesterday was not an accident.
No, I agree. It was not an accident. And the fact that the mainstream media sources remained up is testament to that, because if it was an accident, one stream would have remained up and all others would have been shut down because they're all broadcasting the same audio and the same video. I want to read this super chat because it goes right to Joe's question. This is from Little Rock. Says, I'm a defense attorney in Little Rock, Arkansas. I've been following Viva and Barnes for more than 18 months. What you guys do here and list servers in my jurisdiction is great help on legal theory. And the crowdsourcing, to Viva's point, is going to be the future of all this. But the risk of crowdsourcing, and this is what is going to have to be carefully managed, and I don't know that lawyers and law firms are ready for this, is the influx of information that you get. The more notoriety your case has. Can you imagine Richards' law firm's email inbox right now? Like, and this is a problem because you've got probably 10,000 emails coming in and you have to find the one with like Darth Crypto's video or whatever. And now, fortunately, as Robert was saying, a whole lot of people were talking about the same specific thing. They're pointing to the same piece of evidence, and that's the Darth Crypto video showing that he wasn't actually reaching for the gun. And even Richard said what's supposed to be his hand was the mirror of the car, right? He did say that, so we know that they got that information, and that's wonderful. But the risk is that you're flooding in tens of thousands of pieces of evidence, which inflates billing, which increases confusion and increases fatigue. And if law firms are not properly set up to manage that influx of information when their case goes viral or whatever, they're really going to be in trouble trying to deal with the info. So I think it is the future, but I also think business idea. I think there's a consulting firm out there that would be that would be in good company of business to figure out how to help law firms navigate this type of stuff?
Well, the organic way of navigating it, because there is an influx of useful, useless, distracting, correct and incorrect information. It is exactly what this microcosm of lawyers on YouTube is doing. Basically, is filtering the information up. By the time Nick, any one of us, does a video, talks about it, in theory, it's gone through something of quality control. So it's not a question of retweeting a bogus video or a doctored image or whatever. We've all done something of a due diligence before republishing it ourselves. So that's what's going to end up happening is people are going to go to certain sources for the latest, filtered up information so they can get the best of it. That video showing that the mirror was there and that it wasn't actually Kyle's hand, it's incredible. You have to be careful when you retweet it so that you're not endorsing something that might be someone else's opinion and factually incorrect. But by and large, by the time it gets to any one of us, it's gone up the chain in terms of verification from the aggregate knowledge of the internet.
And that's a really great point, Vivo, because what happens is, and we are pretty much the gatekeeper, the final gatekeeper with respect to our own content, which we realize that our own reputation is on the line. None of us want to be humiliated by promoting something that later ends up being factually false. We saw one person here on the panel, I'm not going to mention any names, that I saw who was very upset that he felt he got something wrong on the law. And it's like, it looked like his soul was crushed. And so we are all... You think I'm talking about you?
No, you might be talking about me. I remember once when I did a video on Kinder eggs, and I
mean, the only one that's effectively ruled out is me because I'm the only non-he, right?
I just feel bad for you, Joe, talking in the third person. That's what I feel bad for.
I'm not going to say any. I'm not going to say any names. Those people know. His name might rhyme with Kung Kimmel Paw. But
what? I don't even know who the heck you're talking about anymore.
No one does.
You don't know how to rhyme.
Look, Viva, I don't know what you're talking about with this, this spreading of false information. But we have this new picture here shows what happened in Las Vegas that fateful day.
But the funny thing is the internet doesn't have a sense of humor when it doesn't want to have one. And someone will take this out of context, say Nick Rekieta promoting conspiracy theories about the Mandalay Bay shooter.
Yes, it was Binger the whole time.
Joe, can you pull up Matthew Modine's tweet that I retweeted? I mean, when we talk about idiotic takes, I'll read it from the interwebs. Matthew Modine just tweeted something. And you have to wonder what celebrities who have a big platform, like it's LeBron James level idiocy. Matthew Modine writes, is Kyle Rittenhouse wearing surgical gloves? If so, why? To cover his fingerprints. Why would he load a weapon with bullets, to travel to an event, aim the rifle at people, pull the trigger of the rifle he'd loaded, unless he went there with the intent to kill?
Oh my God.
So
wow.
Somebody is now just getting one piece of information of this file, because if he's shocked by the fact that Kyle Rittenhouse is wearing surgical gloves, he's new to this case. But can you imagine someone thinking that someone would put on surgical gloves to cover their fingerprints, go somewhere with the intent to kill, and they wouldn't cover their face? I mean, this is the thought process of those who would promote false narratives.
Yeah, well, that whole nonsense about they spent time. What blows my mind is that they spent time and resources at trial on the surgical gloves. The state did to try and get some sort of gotcha. But it's like, wait a minute. So there's no dispute, though, that this gun was the weapon. I shouldn't say the murder weapon, but the weapon that was used. But this is the state's perspective, right? Like, there's no dispute. We know that this is the gun fired. We know that Kyle's the guy who fired it. It's all on video. I don't think at any point in this case, the defense has ever done anything other than stipulate to the fact that Kyle Rittenhouse shot 8 times specifically, and nothing else has been alleged. So it's like, what is the purpose of the surgical gloves? Like, why are we doing that? You're going to try and prove that a guy is intending to not
he's trying to cover his fingerprints, but not cover his face. While and
at
giving
an event
interviews.
that is being video broadcast by how many people?
And giving an interview in real time to McGinnis, who he knows is from the media, but doesn't. I mean, but it's just, this is how people convince themselves of their stories. But they go out and tweet that. Modine doesn't have a big Twitter following, but then you get, the LeBron Jameses, who I will not refer to as His Majesty, tweeting his own version of events, fake tears from someone who's suffering clearly from PTSD. What's the news? What's the latest? I've been watching, but so far I would have lost a bet because I thought they would be deliberating for less than this time.
I've lost the bet too. I didn't think they would actually be less than 2 hours and 45 minutes, but I hoped and wanted it, and no one else was taking the bet other than Legal Mindset. But no, the main news is that initially, they went into the jury room after 90 minutes of deliberation. They sent a request out to the judge for the first 6 pages of the instruction. The first 6 pages entitle encompass the entirety of the self-defense, and along with the first charge, so the shooting of Joseph Rosenbaum as a reckless homicide. And actually, I had a question about this. We talked about it earlier, but Mr. Branca and Mr. Barnes were not on yet, so I wanted to pitch it to you guys. Do you think that the charging of the reckless homicide was an attempt to sidestep self-defense in general, or what is the idea behind that? Maybe is a better question, because as far as I can tell, there's no evidence that this homicide would be reckless. It would either be intentional or intentional with premeditation. But that's
I'll
what I've
defer to
got.
Robert, because I'm bewildered by this decision to charge it as reckless as well. Unless they just they were in such a rush that they picked something they thought would best fit the threat and all the other circumstances, and then they were stuck with the charge.
I mean, I think what's interesting is prosecution completely failed to go into detail about imperfect self-defense in their close. So technically, that can be a difference in the gradations of the crimes in Wisconsin. That they could say, yeah, Kyle thought he what he was doing was self-defense, that he was at imminent risk, but his belief wasn't reasonable.
Well, it's in the instructions.
Yeah, it's in the instructions.
The jury got those instructions.
They
so
did.
Those were some of the...
I just thought prosecution would help explain that gradation. Say, okay, even if you think Kyle thought this, you have to separately decide this is what this is about. Instead, I mean, they basically jurors' eyes go glazed when they're listening to the instruction, especially when it is as confusing as you mentioned, Andrew. And so usually, I've never seen a case where neither side went into great detail in the jury instructions in closing.
Yeah, I don't understand that.
Especially in this case, you have gradations of charges, and you have self-defense plus provocation plus duty to retreat based on provocation that changes when it's like I thought there'd be more there.
I think the state
I believe in making the jury's job as easy as possible in my favor. So step here, step there, step there, step there, acquittal.
Exactly.
I think the state is very wary about bringing up the idea that his self-defense would even be subjectively reasonable, right? Like, I think they made a big mistake in rebuttal, bringing up this whole like he shouldn't have used his gun. He should have just thrown hands like a real man would have. I think that was a big mistake because it just told the jury it would have been reasonable if he would have defended himself with fists, but not a gun. Like that's too far.
Well, now it's an attack. Right? I mean, basically, the state conceded it was an attack, just not that much of an attack. Before, it was just he's chasing him out of the area to, save people.
Yeah, and so I think that was a mistake. And I think in planning their close, they wanted to stay away from the. But even Kyle's perspective was something he could reasonably come to. They wanted him to be a murderer because if they introduced to the defense that he's actually defending himself, or to the jury that he's actually defending himself, and that it's not all just a post facto lie, then the jury goes, you know what? Actually, if I do put myself in his shoes, yeah, I would have shot the crazy man too.
It was, I could not believe what Klaus said on closing. Klaus, that he was too much of a coward to use his
Sauer
fist.
Klaus.
It's Kraus, isn't it? It's with an R, because Klaus would be too funny. Right? Like he would be in a red suit tomorrow.
You know what? It is Kraus. Never mind.
That was a Freudian slip.
The memes would have already flowed.
That he said he was too much of a coward to fight fist to fist with they don't know that the guy's a convicted pedophile, but to say that and then to say sometimes you just take a beating. I mean, I can't imagine how stupid it was to concede the fact that he was in fact being attacked by these people, and his two choices were to give up his superiority equalizer of the gun, or just to take the beating. I couldn't understand it. but it is going to it's going to complicate or confuse the jury as to what what they convict him on at what point in time, when and where. But
well, thank God for Krause, because to the extent I thought the defense could have done a better job on closing, they made up a lot of ground, thanks to Krause, for sure.
Yes. Sauerkraut was the gift that kept on giving.
But I can tell you one thing: we should fully expect. I don't know about the politics of these things being broadcast, but we're not going to get fewer of these cases happening, because there's powerful drivers for these cases to occur, both monetary and political. You see these,
especially if there's any convictions. There's any convictions that every little wannabe little binger in the country is going to say, "Wow, even that
doesn't
case
matter.
worked out for him."
You don't even need a conviction for guys like Binger. These trials are win-win. They can't lose. I'll share an anecdote from the Zimmerman trial. The attorney there, Angela Corey, was a prosecutor out of Jacksonville. She was running for re-election. She was going to lose because it had a large part of the demographic was African American. She had prosecuted some African American cases that were controversial. The Marissa Alexander case, who purportedly fired a round into the air in an abusive relationship, and then a 14-year-old who had murdered someone, and she prosecuted him for murder. Frankly, I think both of those were appropriate prosecutions, but the community didn't like them. There were marches against her. She was going to lose her office. And then the George Zimmerman case happened, and she got herself, a completely different judicial district, put in charge of that prosecution. And suddenly, instead of marches against her in her district, there were marches she was at the front of in her district. And she won re-election. And when she lost the case, he was acquitted on all charges unanimously. That wasn't a loss for her. I mean, sure, she lost the trial, but was that her real goal, or was her real goal political capital to get reelected? Because if you look at it that way, she won. And it'll be the same for Binger. If he wants to run for DA again or some political office, or it's a win-win. Either he gets the conviction, and look, I was right, the guy's guilty of murder, or he doesn't get the conviction, but he fought the good fight regardless. There's no loss here for him. And in terms of the money, there's a lot of money in these cases, right? Not so much the Rittenhouse case, although there's $10 million lawsuits flying around this too. But any of these cases that involve a cop, I mean, these cities, politicians who run these cities are more than happy to spend other people's money to make their political problems go away. And that's why you see in the Chauvin case, 20 million here, Jacob Blake, 27 million, whatever these numbers are. This is just, and by the way, the lawyers, what's his name? The Benjamin Crumps of the world. It's like an ATM for him. I mean, 3-4 times a year, he's getting a third of those settlements. It's unbelievable. And he doesn't even go to trial. He never goes to trial. They're all settlements. So as long as there's that much money to be made and that much political capital to be made, we're going to see more of these cases, not fewer.
And then you throw in the GoFundMe's now, where somebody, if they can create a big enough scandal within 24 hours of an incident, the family's raising money. I mean, Michael Brown's family ended up fighting over who could get the profits from selling various Michael Brown paraphernalia in Ferguson. So their incentive is to narrate the story to go viral on social media, because all of a sudden you can raise $250,000, $500,000. Your life is set for somebody that may not have a lot of means to begin with.
Look, I have no idea what you guys are talking about. There's no money in any of these cases. I don't know what you are saying, and I am frankly offended by the imputation of my character here. I want
you definitely haven't made a dime over the last week.
I want it to be known that that Binger's TikTok has actually been uncovered. Here it is. 4 fingers more Binger.
The aggregate knowledge of the internet and the aggregate humor of the internet. This is.
This has been the meme case of all memes. I've never seen more memes. There's just so many. I mean, like that now that there's like memes, but of the Binger Kyle interaction on the stand with just all kinds of fictional questions, and like Binger asking, "Is it okay if my wife sleeps with another man?" And it's always that Kyle shocked look and response.
I know this probably dates me or ages me a bit, but seeing Binger with that AR-15 aiming, it reminds me of Mike Dukakis on the tank back in 1988 when he was running for president. I mean, if that doesn't just make a person look idiotic, I don't know what does.
And that's why I'm like listening to Andrew. You're making amazing points about there's a gain in this politically for everybody. But I like to still think reasonably optimistically, and that even if someone is politically leaning to Binger's side of the aisle, they would look at that performance of, on the one hand, overt dishonesty and judge him for it. And they would look at that moment where he with his finger on the trigger. We didn't know at the time, pointing the gun at the jury, would say, holy cows, this man has poor judgment. But the way politics are, they'll look at him and say, yeah, he fought the good fight. He did what he thought was right. And I agreed with him. And I still think Kyle is a killer. And so let's get him in for, I don't know, what would he run for? Judge or?
They're going to blame the
depends.
judge. And what's coming
ADA
next
or
is,
DA first.
I don't think any African American ended up on the jury. So the media narrative you're going to hear, you already saw him testing it out last week. It's going to be the judge and an all-white jury. They're going to say
there was
the same
one person
thing in
of color.
McMichael case if McMichaels get acquitted.
The person of color is a Hispanic male.
Yes.
Oh, does that count or not?
That only counts sometimes.
Kyle
George
Rittenhouse
Zimmerman.
is also a Hispanic or half
true.
Hispanic male. So who knows?
George Zimmerman went from
But
being
Viva,
Hispanic to white
to respond
overnight.
to
He
respond
went
to
to-
what you were saying, I think that people's opinions of this case differ drastically, and I'm sure everyone here will agree, differs drastically depending on whether they actually saw the testimony themselves or if they got the highlights from the legacy media or the mainstream media. I mean, just a polling of people that I know and people that, you know, asking my friends who have you talked to about this case and what are their thoughts, and even people that were left leaning that actually saw the testimony themselves, they were like, man, self-defense. I think he's innocent.
It's a dangerous tendency of we lawyers to think that the world looks at these things like we do, that they look at evidence and apply powers of reason and come to rational conclusions. That's not how normal people operate. Normal people, first of all, they're busy with their lives, so they're hardly paying any attention at all. What little attention they are paying is being consumed by the mainstream media, who's serving them massive doses of propaganda, whatever they want the spin to be. And people don't magically know the truth. People only know what they're exposed to. And propaganda works. That's why people do it. So I periodically teach at the FBI Academy at Quantico, and I talk about these high-profile cases that have been propagandized. And I'll ask an audience, 300 senior law enforcement special agents, I'll say, hey, you're all familiar with the George Zimmerman case. How many people here believe that he got out of his car after the dispatcher told him not to get out of the car? And every hand in the room goes up because they saw that a million times in the paper. And then I'll play the 911 call with the dispatcher, and I'll say, all right, I'm going to play it. Now I want you to raise your hand when you hear the dispatcher tell him, don't get out of your car. And it never happens. I mean, that's a complete myth. It literally never happened. Some of you probably think that's what actually happened, but it never happened. People believe it because they saw it 1,000 times. And you can see on the faces of these senior law enforcement officials, they still can't absorb that it didn't happen. Their faces go blank because not only did they hear it 1,000 times, they've said it 1,000 times. They're emotionally committed to this version of the truth that's untruth. And it's very difficult for people. You can't simply present people with proof that what they think is untrue and they just go, oh yeah, okay, I guess you're right. That's how lawyers may think because we're argumentative and that's the nature of how we work. But that's not how normal people think. You show them counter evidence to something they believe in, and it's like it's invisible. It's like your
they
hand is
they
empty.
go even deeper. That's been in psychological studies too. When you present people with contrary evidence, it just winds up digging them even deeper into the hole. So it's a real problem.
With the Zimmerman case, I have now fully relinquished or abandoned any opinion I had because I realize now, discovering in this trial and others, what I probably did not get exposed to in the Zimmerman, I can no longer have any initial opinion of it. But watching this one in real time and seeing people out there who still do not know or did not know that Grosskreutz had a gun. And then you say, I say, how can anyone not know that basic fact of this? But then you realize how, and I put out a video yesterday where the video got demonetized because it had an image of Grosskreutz with the gun in his hand, not the graphic image of his arm blown off, just the image of him with the tip of the gun pointing to the ground, and another image of Binger with his finger on the trigger. And the video gets demonetized, so I re-edit and take out those images. Still have the other unedited version on.
Whereas,
locals,
by contrast, the media images of Kyle with a gun have been broadcast over and over and over and over.
And now that I think about it, we've talked about it. I know I've used the image of Kyle with the gun. Never had a problem on YouTube.
It's in all my thumbnails.
Well, did you not have problems with YouTube for using an image with the gun in your thumbnail?
Nope, not when Kyle's holding it.
Well, I can tell you that my own YouTube videos is this, what you're looking at right now. It's me talking in my office. I very rarely include any images or any video clips of anything. And every YouTube video I put up is demonetized from upload. And then I hit the little review button and 24, 36, 48 hours later, I get an email saying, oh, yeah, we've reviewed it. It's fine. But of course, then it's not timely anymore. So no one's going to look at it.
Yep.
Of course.
And that's every single video. And all I do is sit on my desk just like this, talk legal analysis, and I get demonetized.
Yeah. You and me both, brother. But
Well,
forget the fact about the guy not having the gun. I mean, I've seen tweets this week where people are saying, I'm just learning for the first time that Kyle Rittenhouse didn't shoot a black person.
Yes.
Insanity. Insanity.
You know what? And it's funny you should mention that, Kurt. Now the cynical pill is going off in my head. They've suddenly discovered Jump Kick Man, who happens to be a black male. And so now I'm wondering, do they throw that in at this point?
The prosecution knew him all along. He said he would testify as long as he got immunity for his other crimes. The prosecution didn't want him to testify, so they wouldn't give him immunity. I mean, they've completely controlled who could testify.
But they can't represent to the court that they don't know who he is, which they did.
Oh yeah, they lied, of course. Shock. I
still have hope that I hope. I know we're pushing the lines a lot, but I still have hope that he's just not out and out lying to the court and misrepresenting something like that.
Oh,
maybe I'm a naive person. Maybe this is a sweet summer child.
It's who he is.
Moment.
When someone tells you who they are, Kurt, listen. I mean, he's told us he's a liar from the beginning.
Damn it! I want to have faith in my profession. We're good people.
Oh, you have faith in the profession, just not faith in Binger. Binger has proven himself. There's no question.
Prosecutors are barely people. They become people when they're former prosecutors. No, but
Emily
going
Baker
back,
has entered the chat.
Yeah, going back to what Andrew was saying about the Zimmerman case, and you were talking about the lead prosecutor on that. But if you go, there's a guy who did the documentary just like last year or the year before on the Zimmerman case. And I was reading the synopsis of it. And when you follow the career path of every state attorney involved in that case, you're like, oh my, like all of them got just monumental promotions, either politically or just straight up the chain bureaucratically. And it's without exception.
Now. One of those prosecutors, John Guy, is now and I hear he's a good judge in family court. Local lawyers tell me he's a good judge there. He was the guy screaming on closing in the trial that not only did George Zimmerman, not only did he have a gun, he had a round in the chamber in the ready-to-fire condition. Like you would carry a gun any other way if you're carrying a gun for personal protection.
Really.
By the way, if he didn't have a round chambered, he'd be dead. If he'd had to rack, because he only had the one hand free, if he had to rack that slide, he would be dead. He would have his head broken open on that sidewalk. But
you never
people always ask me,
chambered.
One of the most common questions I get from normal human beings is, Andrew, if I do this, that, or the other thing, could that be used against me in court? And I have to explain to people, everything can be used against you in court. If by used against you in court, we mean, is a prosecutor going to talk about it in front of the jury to try to make you look bad in their eyes? There's almost no limit to what they can use against you. They'll use anything. The question is, how much is it likely to hurt you, and how effectively is your defense counsel going to be able to blunt that damage? But whether they'll use it, listen, if you're a trial, they're there to convict you. They're not there to lose. They're there to win.
And to Andrew's point, the reason why I believe you have to go after prosecutors personally for their political aspirations and everything else, and make them put them on trial in a case, and lead investigators too, is precisely what he just described. In Zimmerman, they got exposed at trial, and they also got rewarded. Yet, unless you create personal risk, professional risk for them, you're not creating any disincentive for them not to march forward. Because Binger could lose completely in this case, and the left is going to love him. He'll probably get a CNN contract tomorrow if he wants it, and he'll be on path. And that's why I'm creating my Disbar Binger campaign. Now, it's also because the head of Office of Lawyer Regulation I've had run-ins with before, who runs Wisconsin's ethics for the Wisconsin Supreme Court. And my argument to him for 2 decades now has been he goes after little people and he lets prosecutors walk. And I want to use this case as a test case to force him, Keith Saline, been there a long time, time to step up or prove that I'm right and that, OLR is a joke. Hopefully use it. But that's why I think it has to be done. It's not just a matter, it is tactically necessary to deter and discourage the misuse and abuse of prosecutorial power to put the personal and professional reputation of the prosecutor and investigators themselves at risk.
So hard to do. And if it can't be done, what happens in 5 years when we have the next Kyle Rittenhouse case, and the judge in that case is not Schroeder, it's Binger?
Yeah,
exactly. And
why would you do that? Why would
you
say that? That is rude. I'll be right back.
The
Well, and
listening
what
to
you just said, Andrews, that's the norm. That's what we face more like in federal court, and a lot of that you don't get judges like Schroeder. You get judges that are there to railroad your client.
Yeah, Schroeder's. I mean, listen, the guy's ancient. He's 100 years old, and his demeanor and his decisions reflect that. But
he's a Southern judge who happens to be in Wisconsin.
Yeah.
And isn't it sad that when we're talking about someone who's considered a based judge or a right-leaning judge, it just means that they actually issue fair decisions as opposed to being completely slanted when you're looking at a leftist
They
judge?
think about it, they apply reasoning.
Well,
and explain
judges,
it.
Judges come from the population of lawyers. Lawyers come from law school. Have you been to a law school lately?
No.
It's nothing
Not lately.
but
What I
social
hear gives me
injustice.
chills.
It's the floors are drowning in social injustice pamphlets. They're completely politicized institutions. I speak at them and I show up, and it doesn't look like anything resembling a law school to me. It looks like some kind of political indoctrination factory. But all those people are going to graduate, be lawyers, and then in 10, 15 years, they're going to be the judges. And it's going to be a different legal landscape.
I went to school 2002 in Quebec City. It's a 99% French city. And one of the first classes I had with this teacher who was controversial, Régent Breton, for anybody who is watching from Quebec, the first class he gives, it was labor law, and he goes into a diatribe about how America is racist and all this stuff. And then he asks the class, he says, do you know who the most powerful person after the president is in America right now? And at the time, it was George Bush Jr., who was the president. Nobody raises their hands. And I say, I think it was Colin Powell or Condoleezza Rice, because both of those answers came up. And this teacher was, informing a class who had these preconceived notions of the injustice in the United States by highlighting, premises that would undermine their most core beliefs. It was social justice back 20 years ago. It just didn't have the name. And now it's got the name, and it's been concentrated through evaporation over the last 20 years, and all that's left. I mean, I wouldn't want to go to university now.
As has been pointed out many times, critical race theory did start itself in the law school. So yay for us for starting that whole train.
Well, first semester, first year law school for me, back in the old days, but it was already it was already beginning. We were being taught in legal writing to disguise our subjective preferences as objective legal analysis. And it was a basic case. It was about, is there a right for an adult disabled child to make a loss of consortium claim in Wisconsin? You research the law, it turned out there isn't. Why, probably some bad policy reasons why there wasn't, but that was the reality. And I kept getting bad grades. And I was like, what's going on? And then it became clear there was a template written, and the template was pretend your subjective biases, you want this person to win the claim, is the objective law. And I was like, that's not the assignment. The assignment is to teach us to distinguish between the two. And they were teaching, no, don't distinguish between the two. Lie to yourself and lie to others that your subjective personal preferences are really objective law. And now we're seeing the consequences of it, and it's going to get worse rather than better.
Yeah, that just makes you a bad lawyer.
Absolutely, it does.
If you can't, I mean, even if you're thinking that you're, I mean, we're all gonna have that thought from time to time that our subjective thoughts are better than others, right? But I mean, at least you should be able to tell the difference between the two,
or at least attempt to try.
Yeah.
Is it going to make you a bad lawyer if the forum for arguing law shares those same biases?
Well,
or does that make you a good lawyer in that forum? If the forum's not demanding reasonableess and objectivity, then showing up as a reasonable, objective lawyer is a good way to lose cases.
Yeah. And Andrew, to that point, look at the human rights tribunals or the administrative tribunals of Canada. The judges who are appointed. They're not lawyers become judges then appointed. They are special appointees. Some of them, I'm not even sure that some of them have to have been lawyers in the first place. You have these hyper politicized administrative tribunals that operate on their own, by their own system, where the judges are, what's the word I'm looking for? Not radicalized, but getting there with very specific purposes for existence, and their rulings encourage the reason for their existence in the first place. And then you end up with decisions like fining a comedian $43,000 for making a joke about a celebrity kid who happens to be handicapped. You end up with another decision where tens of thousands of dollars for misgendering an employee who had worked at a place for 1 month. That's what you get. And you can see it in Canada if you want a foreshadowment of what it would look like in the US.
I see it coming. I just hope the train is moving slow enough that
They accuse
it'll be
me
my
of
kid's problem.
blackmailing. Jesus Lord.
Say that again, Kurt.
I say they accuse me of blackpilling. Lord have
Yeah, I was
heaven,
gonna
man.
say I'm much more. I think I'm much more white pilled than OCU because I see. I'll tell you what. This stream here is evidence to me that the silent majority we're constantly hearing about does exist. Because here it is, we have a channel which is an independent guy. He's a small town, know nothing, nobody lawyer from Minnesota. No, I'm saying he's a small channel guy.
He's the leader of our cause at this point.
And right now,
Bury the flag,
he's
bigots.
he's the king of law of YouTube lawyers, and he's the most popular channel to watch the most significant trial of the last generation. So, I think that speaks volumes about where America's mindset is compared to what our overmasters would have us believe it is.
Look, I'm
Hey, did you
normally
guys hear-
black-pilled, but I believe in the power of love. I just want to say, this is a new book that is coming out soon, and
I believe in the power of the
it-
Rekieta law
it will
court.
be, it will be a
Did you guys
bestseller.
hear-
What was saying?
Hear about this on Twitter about 10 minutes ago. Apparently, the jury asked for 11 copies of pages 7 to 36 of the jury instructions.
But tomorrow morning they're going to come back and
I'm
ask
surprised
for
they didn't
copies
get it all
pages.
in the first place. I'm surprised they didn't get
Yeah,
all the
I'm
36
surprised by that
pages.
too.
My
a bad
read on
sign.
that, my guess would be there's some holdouts, because usually
Sure.
what that happens is they're arguing with each other about what the instructions really mean.
Yeah.
You just don't know which way that breaks. But if I were to guess, I would guess they got some rogue jurors on there.
That's what I mean.
What I would call rogue jurors. They
Jack
got jurors
Posobiec-
who came in presuming Kyle guilty and have stuck with that belief. And
And
that was a
Jack
big
Posobiec did-
problem from pretrial prejudice in Kenosha. It was almost 2/3 when we polled it.
Yeah.
Almost 2/3 of the jurors presumed Kyle guilty, and there were a third that were hardcore, that were
Yeah.
basically impossible to move. As going to Andrew's point earlier, that the cognitive dissonance, the nature of the psychology of mind, pre-committed opinions on the I call it memento memory. I've had it several times in cases. My favorite one is a case where there was one key point I knew I thought would be important, so I talked about it about 60 times, so much that the judge warned me 3 times to quit being so repetitive. And at the end of the trial, this one juror voted against me. It's like, man, I really wish I would have heard about that fact. And I was like, oh, you mean this one? Like, yeah, that one. I was like, the one I said 60 something times. So it's just the
I got
nature of
yelled
juror-
at for you.
Exactly. But my read on this at this point is because also yesterday, half of the jurors were wanting to go home and come back. Half of them wanted to stay. The half that wanted to stay, my guess, were ready to make up their minds and be done with it. So my guess, you got 2 to 3 holdouts. And from people I knew in the jury, or from journalists I heard from in the jury, watching the trial, they said that the way they put it is, quote, there are definitely a couple of Karens on the jury.
It was
Good.
Jack
Good.
Posobiec put out a tweet that said there's at least one rogue juror, and Jack tends to have pretty accurate information earlier than most people. So I don't know what the definition of
And,
rogue juror is here.
Nick's high school friend, which I could be misinterpreted, but Nick's the high school Kenosha kid that had been in the courtroom talked about the mask wearing ones, and a couple of those were people told me seemed like Karen personalities. That was just their read on it.
Yeah, and it's certainly possible, and that is the question.
One addendum: there was one
yeah.
juror who cried all of yesterday, in prosecution and defense, just was crying all the way through.
Like, oh God, make these bad speeches stop. Just weeping. I could be watching this on YouTube.
I got a jury notice just about a month ago, and I cried when I got it. But thankfully, they didn't want me. Fortunately,
no. But this is
somehow I've never got a jury notice. I must be on some sort of list.
When hearing someone cries, it might be my it has to be my own bias. I cannot imagine anyone crying in that context, except for the fact of what's going on to Kyle. I could not imagine anyone crying for someone who got their arm blown off because they brought a gun and pulled it, or someone smashing someone over the head with a skateboard. I could not imagine crying for that side of the pleading. But
they might be feeling a lot of pressure too, though. I mean, I would imagine that over the weekend they probably had some conversations. I mean, let's be real. They probably had conversations with people around them.
Or some threats. I could see them crying about the decision they have to make.
I was being nice when I was calling them conversations.
Well, I think what Andrew pointed out yesterday is you have a percentage of people who feel very sympathetic for Rosenbaum and Huber. It's shocking to us because of all the facts
Right.
we know about them and their behavior. But the liberal Democratic types, that's who they were sympathetic for. They had no sympathy for Rittenhouse.
And if all they're seeing is what the media reports, it's not hard to imagine how you end up with people in that position. And it's not because they're bad people or malicious. It's just we only know what we're exposed to, and that's all that they're exposed to.
Did
You
y'all
have
think
to,
about
you have
Crime
to
to
find
watch
out
it.
that he raped children. Like you have to go work to find out that this guy in the most high-profile case that we've seen in a while, coming out of a state anyway, rather than a federal case, raped 11 children or has 11 counts of rape against children. Like that we even have to go find that independent of the media is exactly the problem with this. And it's why if independent media like this type of show eventually becomes the de facto way that people watch these trials and cases evolve, it's going to be that. It's going to be, oh yeah, did you know that this happened? Oh yeah, did you know that this happened? And CNN, have they ever reported the criminal history of Rosenbaum or Huber, that he threatened to murder his own grandmother?
That goes against the
Right?
narrative.
Oh, it's
Yeah, I mean, I was
insane.
just on Megyn Kelly right after Robert today, actually, and I mentioned to her. She played some media footage of them saying outrageous things about the case and reporting misinformation, and what can you do but shrug? I mean, anybody who doesn't understand yet that the mass media, especially the news media, is really just a propaganda arm for the political left, and that's what they do. They're propagandizing. And by the way, propaganda is done because it works, because it's effective. Otherwise, people wouldn't bother. And that's all people hear all day.
That was my constant argument with Richards. He didn't get that. It was driving me absolutely berserk. I was like, look, I get in a certain world, this in a case without pretrial publicity and without political undercurrents, yes, you don't have to worry too much about the jury. A random Kenosha jury will be an acquittal jury. In this case, if you remove both of those factors, but you can't in this context. The risk of rogue jurors was so high, and he didn't accept that idea.
It's hard because, I mean, normal trials aren't like this. You know,
Right.
you could be a criminal defense attorney your whole career, never have a case like this. And it's really kind of boring. And you really do get a blank slate jury that doesn't know anything about the case when they come in. And, jury selection is an hour and you're all done. And it's about as fair and impartial as you could expect. And if that's a person's experience, and that's the normal experience, you suddenly find yourself, under 3,000 feet of water of news media coverage when you're in one of these cases. You can't believe it. I mean, it's impossible to conceive of what it's like if you've never been through it. And by the time you realize what's happening, you're halfway through the trial.
Yeah.
I'm
I'm
still blown away by the fact check, PolitiFact fact checking the.
Yeah, they
the-
lied the
gun.
first time about the gun law, and they just came back and said, no, it was okay. We lied about it the first time.
Oh no, they said he said it was clearly legal, and it's not clearly legal because there was some discussion. So therefore, the statement that it was clearly legal is false. So they can double down on their initial lie.
I mean, then it's an opinion disputing an opinion. That's all it is at that point.
And that's what these fact checks have turned into. If they're opinion pieces, call them opinions, but don't call them fact checks. And and we'll yeah.
So I wanted to ask about that charge 6, which was dismissed. This is the minor in possession charge. And we went through the statute early on in the stream, which was great to just go through and reiterate that. I did that with Hogue Law. The judge said that the pleading standards were actually sufficient to sustain the charge through its initial motion to dismiss. Basically, they've met the probable cause pleading standards of a criminal complaint. But I don't think they actually did.
There were never relevant facts in dispute. So relevant facts. There were things they were saying, but they were not under any normal reading in the statute.
But they
none
never
of the facts were
pled. They never pled that he was carrying a short barrel rifle, which ended up being the issue on which Schrader threw out the charge, right? Well, if it's not a short barrel rifle, I agree with the statutory interpretation of Sheriff Easy, and he argued this exact statutory interpretation in oral arguments, and I assume in his brief at the pretrial motion to dismiss. But he then says, well, if the state is alleging that this is a long-barreled rifle, then I'm going to dismiss. But he defended his decision to not dismiss earlier by saying, well, I was just judging it on the pleading standards and the facts were sufficiently pled. But They weren't, right? Like, am I
Well,
crazy on this?
The truth is, and this is just my opinion, I don't know how you guys feel about it, but I think the whole probable cause standard in America courts is profoundly broken. It's nothing. It's a piece of tissue paper that the prosecutors just blow their nose right through. There's no actual threshold to prevent someone from being dragged into trial. The prosecutors routinely say things on criminal complaints, on informations that are not true. They just made it up. And then when he gets a trial, and they, for example, I'll refer to the George Zimmerman case again. He was finally dragged into court, charged with second-degree malice murder because they had to charge him with murder for political purposes. Well, they had no malice. Malice is an element of the crime. So they allege in the criminal complaint that he racially profiled Trayvon Martin. That was the malice. They got him charged. They drag him into court. You know how many times in the actual trial, weeks of trial, that racial profiling was referenced as evidence? None. Not once. They never had it. But no one ever goes back and says, holy cow, the whole charging document was corrupt from the very beginning. Why are we here in this trial? They never asked that question. And so we end up dragging people into these courts, and they should never be here. And the reason the probable cause doesn't work is because it serves the interest of the efficiency of the criminal justice system not to have a genuine probable cause standard, because they're funneling so many criminal defendants through the system. If they had to do a genuine probable cause hearing every time, it would simply clog up the system beyond belief. So we pretend there's a probable cause hearing. The prosecution shows up, makes a bunch of claims. We're all supposed to pretend that it's true, and that's sufficient. That's nonsense. That's not the way the system is supposed to work. And when we're talking about, lifelong criminals, who cares really? I guess, they're going to be going through the system cyclically anyway. But when you have a good guy case going through the criminal justice system and treated the same way, you end up with these travesties of justice. There's no reason Kyle Rittenhouse should be at trial right now.
And for those that are out there, in the federal system, probable cause is determined by the grand jury. In state systems, it varies, but many state courts have what Andrew's referencing. You're entitled to a probable cause hearing to contest probable cause. And what's happening is they've substantively eroded both of those. Grand jury is supposed to be a restriction. To me, it's not supposed to be interpreted like a civil complaint. That grand jury is a whole different kind of limitation, and yet they're applying looser standards to indictments than they do to civil complaints. It's getting absurd. So completely gutting the point of the grand jury clause of federal and analogous state constitutions. And on top of that, like when I tend to always demand and find an excuse to get a probable cause hearing in my state criminal cases, but man, they hate me for it. The judge hates me for it. Prosecutor obviously hates me for it. Everybody hates me for it, though it's almost always beneficial to my client because of evidence that develops at those hearings. It's really unique in the state. A lot of state systems, you don't get a chance of doing that in the federal system, that too many lawyers don't take advantage of because they're beaten down by the intimidating effects of courts who don't think they have the time to calendar them, and prosecutors who don't want the exposure and risk that comes with them. But there needs to be a lot more of them.
I hate to say it, but it's not necessarily in the financial interest of the criminal defense lawyer to have the matter dismissed at a probable cause hearing.
No, it's not.
Right?
That's
If you're
the
a criminal
problem.
defense attorney,
I always tell clients, beware of what you ask for. You want a lawyer who's priced to get you the best outcome the quickest, not a lawyer who's priced by making sure you go through as much misery as possible before you get any good outcome, because that's what maximizes their fee. And I still think we should be allowed bonus fees as criminal defense lawyers. If there were bonus fees as criminal defense lawyers, I would have retired a decade ago. But you're not allowed to. It's like, why? Well, why can't I allow? Isn't my duty as zealous advocacy to make sure my client wins anyway? I'm going to suddenly break the rules now if I have a bonus versus whether I don't.
Right.
I mean, that's not really what happens in the way the system works. So, but because of the financial, ethical limitations on the criminal defense lawyers and the way a typical contract works, what Andrew's talking about is if you're a criminal defendant, your lawyer is disincentivized to get you the best outcome the quickest way. They're incentivized to protract the proceedings.
Listen, he's got a mortgage, he's got a boat payment, he's got the Mercedes payment, and he can, a lot of criminal defense practices, they sit there and they're cranking the handle on the practice.
And
that's it.
You didn't even mention the three mistresses.
Well,
Matt, what were you going to say?
Well, I had a case one time where I was at a preliminary hearing, and it was, it was a murder preliminary hearing, and we had a very strong case of self-defense. So strong, in fact, that even though it was bound over to the grand jury, the defendant is yet to be indicted. because the case for self-defense was very strong. But to play on what you're talking about, the financial motivations that some might have, at this hearing, the judge, even though she bounded over to the grand jury, she entertained a motion to lower the gentleman's bond. And I won't say how high the gentleman's bond was, but it was very high. But it got lowered to the point where he was able to get some money to get out of jail that day. And I can assure you that bail bondsman got more money getting him out of jail than I got him from not having to be indicted. And so I see where you're coming from. I mean, so many times when you have the temptation, and I haven't had as much of this as some attorneys might have, but when you have the pecuniary temptation to string it along, like you said, because that guy in jail, if he's not paying for the bail bondsman, at least he's paying for you. So I'm going to make it as hard as possible for him to stay in jail so I can keep my lights on. That just isn't right. And
it's
yet
not right,
I think
but,
that is
but
one of those situations where it can tend to happen.
It's not right, but the incentive is real. And
yeah,
we can't pretend to live in a world where we can expect people to do what's right when all the incentives are in the counter direction. I mean, listen, I do okay for myself. I have the luxury of doing the right thing, but I can tell you, we get a lot of cases coming to my office for consulting on self-defense, and just a superficial look at that decision, at those facts. And I'm like, listen, I'll do the consulting if you want for the price that we normally charge, but you're not going to like the result. I mean, this is not self-defense. So I don't want to take your money if you have the expectation you're going to get a positive report from me, because that's not going to happen. So of course I don't get the money. Naturally, I wouldn't expect them to, but it would be very easy for me to say, oh yeah, no, there's something we can really work with here and collect my normal retainer. And I could do that a couple hundred times a year.
Well, and you get that with jury consultants too. Jury consultants who may
say they
know
never got
that
a report. I'm sorry,
jury consultants that may want to think a defense lawyer wants a particular approach, and it may not be the best approach for the client, may not be the best approach to understand the jury, but rather than give honest feedback, they go along with whatever the defense lawyer wants. They structure mock trials to feed the defense lawyer's preconceived perceptions of the case rather than show them the risks and the warnings. And so you see that in multiple layers, that when there's a financial disconnect between who's paying you and how they're paying you and what would be in the best interest of the client, and now my view is the system does this because it profits the system at the end of the day more often than not to structure things this way.
It does, for sure. Any of you guys work in family court? I mean,
No,
family
I
court
have never touched that ever.
It's
back in the day.
outrageous in this respect. I mean, the family court exists to serve the interest of family court. It's unbelievable the way they
Bankruptcy
drag out
court,
these
same way.
divorces and oh my God, because the court has all kinds of little projects they like to run, and I'm sure they're all good causes, women's shelters and things like that. But the court doesn't get funding for that. The court gets the money for that from all the parties coming through the court system. So it's in the courts. You wonder why a divorce takes 4 years to happen. That's why it takes that long. It could be an efficient process.
Between Andrew and Robert here, I'm just getting so many black pills about the reality of the practice of law in your guys' world.
Kurt, I'll tell you.
Wonder, maybe I've been right all this time, and over where I'm sitting in this nice little transactional IP world where everything is nice and clean, and I'm just dealing with these really big corporations instead of the stuff you're dealing with, man. Jeez,
that's why
I look
where
at you guys
am.
and I envy you, and now I'd be like, damn, Lord, what's going on?
Kurt, I'll give you one of my early black pills. Was this was not an attorney with whom I worked. It was opposing counsel in a file. We were having coffee or something after the hearing, and then we're talking. I said something about settling files. We settled, and he says to me, "Yeah, settled, just not too quick." And it was like,
I can't decide if I want to ask you guys to give me a job or never talk to me again.
Well, I haven't even gone into personal injury work. There you can really find about that. You know, the dream client, the client that calls in and says they're going to be, ideally, you don't want them dead. You want them in constant, permanent pain and just waking up every hour just enough to remind them of the horrible things that go on. That's your ideal client.
It's like that scene out of My Cousin Vinny, right? It's the second My Cousin Vinny moment. He sees the guy with the neck brace, and he's like, car accident? Yeah, somebody hit you? No, I tripped and fell. So he's
I'm thinking the Simpsons reference. Lionel Hutz prepping Bart when he got hit by Mr. Burns, and he goes, "How you doing today, Bart?" He goes, "Fine." He's like, "Oh, isn't that fine? Bart's doing fine." "You're not doing fine. You're in constant anguish and pain." It was a good episode.
Ideally, their anguish is highly visible. where you can show a day in the life of this guy who now is a quadriplegic and has to be a guy who used to be making lots of money,
And in the prime of their
now,
life, right?
yeah, and yes, in the prime of their life, and now is being spoon-fed through a machine, and you can actually have the jury crying there as they watch what it's like to live. And yeah, that's when you get eight-digit verdicts.
He's also a former CEO with a traumatic brain injury and a key player insurance contract with a $80 million payout.
Well, my first
you need a deep
introduction to
pocket
this
too. You need a deep pocket also.
Was a great plaintiff's lawyer that I worked for. In his opening line in his opening statement that I was help working on for him was home is where the heart is. And the reason why home is where the heart is her permanent need for care at home was worth double as much as if she was in the hospital. So home is where the heart is because home is where the money was.
Nick, do you want to remind the chat that you have the live feed on the side so that if the jury is back, you will bring it to our
I
attention?
think it's a meme at this point. They're just going to say jury's back every 2 seconds.
If they ask for 26 more or 30 more pages, we're not getting a jury verdict today. There's a couple.
I don't think so.
Yeah. I'm waiting for the judge to come back and dismiss the jury for the evening. I think that's the likely outcome. That's going to be another hour, 2 hours. But I wanted to say about the probable cause thing, how we do it in Minnesota. This ruined me because I had a client who was held over in jail for a significant amount of time, and the probable cause you get a probable cause hearing within 48 hours of being arrested. You're constitutionally entitled to this. It's a California federal case. But basically they have to do a probable cause assessment or hearing. Well, those hearings happen on Sundays. They have to, because if you get arrested on a Friday, 48 hours, they have to hear it on Sunday. And if they don't do the hearing, they have to release the person. It's a constitutional right that you are released from jail. So, but they happen on Sunday, and here's how they happen. The prosecutor walks in Sunday morning, 6 a.m. They have a big stack of files. They call up the judge on the phone, and the judge is at their house, and they just read them the probable cause statement or a summary of it. And the judge says, yep, hold them until Monday for their first appearance hearing. And they never say no. I mean, they never do, because it's just a prosecutor saying this is what happened. And the judge says, yes, of course, hold them till Monday and then we'll deal with it then. And then in my client's case, this did not happen in a timely manner. And I argued it at the subsequent probable cause hearing, and the judge ruled that there was no error because my client was not prejudiced by the delay of their constitutional rights. So my client, who was in jail, however, he was severely disabled from a car accident, in constant pain, was denied meds for 70 hours, and the judge said, no prejudice, too bad. And he ended up pleading and not going to jail permanently. But it was like, what the hell is this? I mean, you violated the guy's constitutional rights. You admit to it, and it was all fine.
Yeah, one of the things. Go ahead.
Last bit was just in Minnesota. You were talking about, or Robert was talking about the scheduling of those probable cause hearings. We call them an omnibus hearing here. And if you go to schedule one of those, they schedule them uncontested. Even if you say, I'm going to contest probable cause at the hearing, say, well, we'll schedule it uncontested. If you get there, then we'll reschedule the contested hearing later. And it's like, no, I'm going to contest it on grounds of probable cause. Like, we'll schedule it uncontested. Welcome back to the stream, Hogue Law. Richard.
Yeah, 5 hours later, you look all the same. I thought, hey, I don't think you got enough transactional lawyer representation. So I just got out of the Activision mines after the Wall Street Journal blew open the doors. So thanks for having me back.
I saw you put up another video.
Yeah, I couldn't, even with my voice somewhat shattered from illness over the last week, I can't ignore the Wall Street Journal impugning the CEO of a public corporation, embattled by 4 separate sets of letter regulatory investigations. So we'll put up a video.
Robert, I have a question for you about the process here, if you know. Is there a limit to how long the jury can deliberate on a particular day? Like, will the judge give them a hard cutoff at 5 or 5:30? Or will he permit them, if they say, hey, no, we want to stay longer, to go till 7, 8, 9? What's the... Any idea on that?
totally up to the judge. But I think the judge implied that he would let him go home early, that he would give the jury pretty much whatever the jury wanted. He let them vote yesterday. Do you want to go home now? Or do you want to stay? So I think there was a few jurors during jury selection that talked about like 6 o'clock, 6:30, scheduled events they needed to be for. So usually that's picking up kids, starting a work shift, depends on the scenario.
Going to talk to the media about their experience as a juror.
Robert, I mean, if anybody has had meaningful experience with this, I've had none. If they're going to come back with a verdict, which they're going to come back with a verdict, if it lasts longer than a certain period of time, is it more likely that they want to get the verdict out by the end of the day, or do they wait and get it out the next morning type thing?
Well, in my experience, whenever jurors have made up their mind, they want to be done at home. They don't think like, I want to do this time. They're like, done.
No, but I mean, in terms of getting a consensus from holdouts, is that more likely to come after an overnight thought process, or by drilling them by the end of the day to get it out before they close for the day?
I mean, usually they use jury instructions and evidentiary questions to argue with the holdouts. And it depends on how strong the holdout is. And my view was the prosecution, you could argue the defense did this too, but definitely the prosecution argued to their side more than they argued to any perceived neutral observer. And basically they were arguing for a holdout, because I think prosecution knew they were behind. So I think they just, mistrial's just fine with Littlefinger.
How many days do you think they would deliberate before we could anticipate the judge starting to consider a mistrial?
If they haven't come back by the end of Friday, I think the judge, usually he'll listen to the jury. If the jury says we're irreconcilable, this is never going to happen, we want to go home, we're never going to get, then I think he would grant that. But he usually depends on the judge. If they think it's leaning in their direction, whatever direction the judge thinks will happen, they don't admit this, but this is my interpretation, that they will push the jury if they think the holdout is someone that, if they think pushing them will lead to a verdict they think is the right verdict as a judge. But if they can't get a read on it, I think this judge is very sensitive to the jury. So if they really come back, I think initially he would say try again, maybe once or twice. But I think if it's end of business Friday and there's still holdouts, he will probably declare mistrial. The only question is, does he grant a mistrial with prejudice because he sat on that the whole time? He didn't grant it because I think he thought jury verdict's going to come in that's going to clear the kid and that will end it. But I think that because I think he had the same assumption that Richards had, which was that pretrial publicity had not created such a biased jury that unless you had meaningful jury selection. I mean, for folks out there, the Arbery McMichael trial, 2 weeks of jury selection. This took a day. There's no way, and with no written questionnaire. I mean, they had written questionnaires on top of the voir dire, and I mean, I've never seen that. So in a case like this, you cannot do it. And I argued with Richards, the judge did not know what our polling data had shown. Almost 2/3 that everybody in Kenosha had heard about the case. Everybody thought they had seen the videos. In reality, they'd seen misleading videos. And 2/3 presumed him guilty. And a third were locked into that as a matter of emotional commitment. And those are jurors you just don't budge no matter how many facts you show them.
Yeah, in the Arbery case, they had written questionnaires first. Then in general voir dire, the state had an additional 80 questions they were asking the jurors. Plus, then they ran through their usual bullshit witness list of 10,000 people that they're never going to call, of course, but they're just trying to jam up the defense because now the defense has to look at every single one of these potential witnesses. And then the defense had 20 questions of their own. So every single juror had the written questionnaire already and then went through another 100 questions of general voir dire. And after that, they were each subject to individual voir dire.
But Andrew, what explains that difference in treatment? Is this a state issue, or is this how they're dealing with the trial issue? And then what would account for that difference practically?
The lawyers in the court, that was the difference. In Wisconsin, I mean, Richards didn't ask for that. Richards didn't. The judge said they could have as much voir dire in person. He said he declined a written questionnaire, but he did because he wasn't told about pretrial prejudice, pretrial publicity. He was never given that information. I think this judge thought Kenosha thought of this case like he did, and they would hear the facts and just grant acquittals, and that would end it, and vindicate Kenosha and vindicate him. He did not know how much pretrial publicity had really saturated the community to a unique degree. Because he's used to seeing pretrial publicity. The other thing is Andrew can attest, 20 years ago,
Sorry, guys.
a Rittenhouse case would have probably only had half of the jury being really contaminated. Today, because of social media, everybody sees it. Even people who never read the local newspaper, never watch local news. Somebody's on Facebook, somebody's on Twitter, somebody's on YouTube, somebody knows somebody who is. And it's, I mean, like in the Chauvin, I mean, it was complete saturation. And there was such saturation with so many false stories that about a third of the jury pool was hardcore rogue jurors that required probing jury selection to filter out. Otherwise, you're just gambling. And unfortunately, that's what they gambled because they chose to gamble. Is bottom line with Richard.
I mean, a lot of those prospective jurors in Arbery, at least they were willing to say, I can't change my opinion. I'm locked in. I think they're guilty, and I respect those jurors. They're being honest. They cannot be fair and impartial jurors, and they're taking themselves out of the running to be seated. And that's amazingly to their credit. They're incredibly honest in that they can't be fair and impartial. Those aren't the people I'm worried about. The people I'm worried about are those who know damn well they're not going to be fair and impartial, and they will lie to your face all day long. They will say all the magic words. They will say, yes, Your Honor, I can be fair and impartial. Do anything to get on that jury as a personal and political mission, because you have one of those on your jury and you are done.
By the way, someone in the chat said, how would I pronounce voir dire? Robert and I have discussed this. It is proper. I think it's supposed to be voir dire, which is voir, say, which is what you're doing basically to the evidence. But question for
not voir dire.
Yeah, voir dire.
Voir dire. And you have to roll the R.
The New York way.
The question is,
depends on where you are.
Each part of the country. In New York, we say voir dire. Voir dire. Like
you got a lot of those the snow geese from Canada.
But for me,
it happen here. You know, it is what it is.
For those who know, what freedom or liberty does the judge have to have one-on-ones or like direct interactions with holdout potential rogue jurors?
He can do whatever he wants.
Can he do one-on-ones in the absence?
Individualized voir dire. He can.
Actually, I need to correct
myself.
What he's
obligated to do, because the great advantage that Rittenhouse had was pretrial publicity. The U.S. Supreme Court has said you have to screen out for it. So like in the Snipes case, the judge said we're only going to get an hour of voir dire. Said never taken me longer than a half a day to pick a jury. In this case, ain't going to be no different. But pretrial publicity and racial prejudice were the two areas they had to inquire about. So people accused me later of creating pretrial publicity about racial prejudice because of some motions we filed. Take it as you wish. We got 3 days of voir dire and got rid of most of the bad jurors. Well, now we still got 3 bad jurors on that case because that's how contaminated the jury pool was in that kind of case. But I mean, Rittenhouse was much worse. The pretrial publicity was off the charts and in surprising places. Like you had a lot of Republicans and Trump supporters and conservatives and who also doubted whether Kyle was innocent because that's how bad the pretrial prejudice. Fox didn't come around on this case until the trial itself. Then Fox became, hey, you know what? This is problematic, what's happened to this kid. But until the trial, they had been a little weak. Tucker had been good, but the rest had not.
I'm perfectly willing to admit that the trial was convincing to me. That's what it needed was the prosecution and seeing what the witnesses said. Now, I followed it rather than the headlines, and I followed this because of broadcasts like this one. But it's hard to blame people that look at what are supposedly upstanding institutions in the United States and say everybody is lying.
Yeah, it's well, and you know, we all know this because we deal with it in some stretch, right? That you deal with the media bias or media lying. No matter what, we all you're either doing legal work that entails research into something that the media misrepresents, or we're covering topics on a show and you see them misrepresent something in real time. You're like, I know the opposite to be true, but most people don't deal with that at all. So, but I wanted to ask the panel's thoughts. This is a tangential question to the Rittenhouse case, and I thought it might be interesting. So with what has come out in the Rittenhouse case, we know that his brother, quote unquote, Dominic Black, is charged with 2 counts of felony giving a minor, I guess, felony distribution of a handgun to a minor. I don't know how it's worded.
That resulted in a death.
Right. Yeah.
Providing
so
a
it's,
firearm to a minor that resulted in a death. That's why it's a 6-year
Right.
felony sentence.
That's it. So what is there anything that has changed about this charge, or how do we like Dominic Black's chances on that? I mean, it looks like he's going to plea out with an unspoken plea deal that his counsel clearly had arranged with Binger pending his testimony. I mean, I'm cynical like that, but that's what appeared to happen in court.
When was he charged with that?
He was charged with it a while back.
But yeah, right away, because they wanted to lock him up and
Yeah.
keep him from being a favorable witness for Kyle.
And his case was continued recently to to January, I think it was, at the dual
All
request
of them
of him.
All
and
of
the
them
state.
are
Yes.
magically moved to January.
You got to wonder what's going to happen to
Well,
them.
look,
if-
Robert, in Zeminski's case, look, they had a witness conflict, and the witness just couldn't be around till January. So you know,
trust
it's-
me.
Yeah.
We see this
Who
trial.
was the witness who had the conflict?
Just
I mean,
just
really?
not. The witness wasn't available between November and January. At no point were they available. So
If
don't
you
go
guys
back.
believe Zeminski themselves counts as a witness. They are a witness. They may not be able to be called by the state, but they're technically a witness. So yeah, we have witness conflict. Zeminski.
If there's a
Couldn't get
mistrial,
him.
though, every one of those is going to have some magical delay yet again, because they're going to want to. They're never going to want to have
There's a lot
that
of
brought
delay.
before a jury until after the whole situation with Kyle is fully adjudicated.
Which is crazy to me. But what do you guys think about the charges?
I mean, I don't know enough about that statute. Is it per se? And by the way, good morning, everybody. If you believe that those delays weren't intentional, I have a
morning.
bridge to sell you in North Korea.
It looks like evening outside your window to me.
Yes, it indeed is. It indeed still is. One thing I want to know is, so if it was a quote unquote good shoot, right? If self-defense does apply, does that invalidate an element of that statute against Dominic Black? Robert is shaking his head. So then, is that statute, perhaps unconstitutional? Is that perhaps something that could be challenged?
You know
in
what?
Dominic
No,
Black's
because
case?
the intent part is giving him the gun, knowing he's a minor. The
Well, it's-
consequence part isn't required. It's kind of like burglary and theft. You get into those issues. There at some point there's a due process issue, but where that point is, the courts have been very flexible on.
I think they move for immediate dismissal. Here's
Isn't
why.
there? I thought there was a section beneath this that goes into how subsections, or maybe it's above it, something where subsection C doesn't. There's still a violation if you give it to someone, even if the gun is legal for the 17-year-old.
Well, so here's this, right? Whoever violates paragraph B, guilty of a class H felony if the person under 18 years of age, under paragraph B, discharges the firearm and the discharge causes death to himself, herself, or another. However, we still come against the 3C,
Oh, 3C
which
lives
applies
there.
to the entire section. And it says, here's
you're
the
right.
following. This section applies only to an adult who transfers a firearm to a person under 18 years of age if the person under 18 years of age is not in compliance with sections 29304 and 29593, or it's the same language, it's just reversed, to an adult who is in violation of section 94128. I think, and Schrader's the judge on Dominic Black. I think you go straight to Schrader, say motion to dismiss. You ruled in Kyle Rittenhouse's case that this is not the thing. We have it on the record, all of the facts about the gun of this case in the same way that you did, and in Kyle's case. And so we know that he is not under this statute. I think Dominic Black.
What in the world
wins.
is the word adult doing in there? This statute, man.
Yeah, there should not be an adult here.
I've seen
But-
worse.
So if you transfer a firearm to a person under 18 years of age, if the person under 18 years of age is, and then we can take out that next part, an adult who is in violation of section 94128.
They were too excited about all the ninja weapons. They
Maybe
weren't paying
they're
attention to what they were
emancipated.
drafting in 3C.
Yeah. But I know people have asked me quite a bit about this. I haven't looked at the statute in regards to Dominic Black. I actually thought it was a separate statute. And so I just checked it. This is the statute, and the same exemption and the same facts exist. And you've got the same judge. I think you go straight to him with the record, say, Judge, dismiss this. You just ruled on this and dismissed it against Kyle. Under the same logic, it cannot possibly apply to my client. And therefore, we need immediate dismissal on it.
You're not going to
Any-
get that motion dismissed until the bitter end, of course, with this judge. But sure.
Right, but any counter
Him and
thought
all,
on
he'll have
that?
a story to tell you.
Does anybody read that differently?
No, I agree.
I concur. Having read that, that's the first time I've read it, and that's pretty clear meaning to me. Yep.
And you have to
I
ask
disagree
yourself,
because
why
it was
didn't
a short barrel rifle? We tend to offer evidence of the short barrel rifleness in that case.
why didn't
They do-
Dominic's lawyer raise that issue rather than try to push the kid into
Well,
testifying against somebody unnecessarily?
Do you want my cynical answer? Because he was represented by a guy named Robert Keller. Robert Keller withdrew, and he's been represented by a public defender ever since.
That's a black pill.
That's why it's very, if you're smart, you help. If you have a potential co-defendant or a defendant that's related, it's smart to create a joint defense agreement, help them get funded, to help them have counsel. There's certain people in the alternative product distribution business that understand this very well.
Yes.
Good friend, bro.
Okay, so that's resolved. Okay, I thought that conversation was going to take longer. Sorry. To the panel, as all of us are in some level of social media aware attorneys, right? I'll qualify myself as the lowest aware, but and some of us are specifically in the idea of in the realm of consulting or money management. Crowdfunding is a thing in lawsuits and criminal defense. How is crowdfunding going to be something that is reined in or attempted to be reined in by the state? Are we going to see judges acting on this? Because in every crowdfunded civil case I've seen, the other team's lawyers want a piece of that crowdfunded pie. They're always after the crowdfunding. They're always raising it as an issue. What is the future of crowdfunding in lawsuits? Because I think Andrew's right in his assessment earlier that there's a ton of money to be made in any level of publicity around the lawsuit, and crowdfunding is a huge factor of that. I think in Kyle's case, last I checked, over $2.6 million total has been raised.
Nick, the first thought that comes to my mind, and granted, in some of these, this would relate more to plaintiffs' litigation and not so much to people who are being sued civilly, but some states have laws against maintenance and champerty.
Right.
And in fact, in some states, it's actually a crime. So if you want to support somebody who is doing litigation, and that person is a plaintiff, and that person is trying to sue someone else in some of these jurisdictions, if you incentivize the litigation by raising money for the plaintiff or something like that, you're opening yourself up to criminal liability. Now, that's not. Now, if you're trying to defend a lawsuit, that's a little bit different, because in that case, you're trying to protect yourself or to protect the defendant from the unnecessary litigation that he was not asking for. In other words, you're not trying to drum up litigation in that point. Like I said, it varies from jurisdiction to jurisdiction, and that's something people who are crowdfunding need to be mindful of, because you don't want to run afoul of champerty laws.
Wasn't there a U.S. Supreme Court case on that point, or am I hallucinating about the funding of lawsuits and it being okay? Am I making something up?
I mean,
I
look,
don't know.
if I was counsel for a platform that was, hosting crowdfunding for litigation, I would be nervous. I'm just saying that, if I'm sitting there saying, hey, we've got to hold this money for the purpose of litigation, it's something I would say, hey, I
They
might
don't.
not be totally comfortable with.
I would
don't
think
hold the
that
money.
I would think that anything that's going to impact a litigant's ability to crowdfund would have to be enacted by legislation, not by any member of the bench.
What are the rules
Right.
in the States about getting money as an advance for legal fees? Does that not have to be kept in a trust account?
It should be.
I see the judge's head here.
We got Judge Head.
I see the judge's head.
Nice.
Yeah, I saw
Someone's going to clip that.
Judge Head's a little bit different.
I saw a tweet that around 5 p.m. he was gonna ask the jury what they wanted to do.
5 p.m.
Like what they
what
wanted for
time?
dinner?
Eastern or Central?
Commit
I think
seppuku.
I think probably Wisconsin time. Whatever
Then
time.
we got
it
an
is.
hour. We got an hour 5 until that happens.
He's toddling away.
But No, Matt, thank you for bringing that up. I have been directly accused of champerty, right? I've been accused of this because I was involved in creating a crowd fund for a plaintiff, and people then automatically assumed that I told the plaintiff that they had to sue and all of this stuff, and that I encouraged them to sue, which is flagrantly untrue. But you know, Twitter lawyers are Twitter lawyers after all. But that being said, it's an interesting sort of idea, because I've always been under the understanding that third-party funding of lawsuits is just fine so long as that funding has no interference with the attorney-client relationship. And so I think planning through that is very important, exactly as you say, especially for a plaintiff, because of that. You cannot be seen to be leading a plaintiff into litigation for your own purposes, which is weird,
But there's
because
already rules on that.
but Peter Thiel kind of did it, right? With Hulk Hogan and Gawker. I mean, that happened. What?
Who's Peter Thiel? What happened?
Peter Thiel funded Hulk Hogan's lawsuit against Gawker for the sex tapes, and
I mean, they forum shopped. They did everything. Like they
for individuals, it's not for citizens. It's not an issue, right? As far as I understand, it only becomes an issue for politicians.
No, I mean, for everybody. Because, like, take Kyle's case. You had crowdfunding. Some of the people who end up controlling that crowdfunding ended up controlling his defense, more so than he did, frankly. So that's the kind of issue they're worried about occurring. At what point does it compromise the attorney-client relationship, the client's direction of choices, the client's, et cetera? That's the fear. And there's ethics rules that try to do that without impinging on a client's ability to raise funds for their defense through such crowdfunding.
And the right to
And
the
it was
counsel
particularly
that they
complicated
want.
in Kyle's case because the crowdfunding started when he was 17, so he's a minor. So the custodial parent, there's a role there. And then the people raising money for him purport to be a charity. When they were a charity, that creates a whole different sets of rules or restrictions. So there's all these both ethical rules and then sometimes legal rules depending on how the funds are raised.
Right, and that's why someone mentioned. Pardon me for not remembering who, but shouldn't they be in a trust? And this is one of the reasons why they should be held specifically in trust, in my opinion, is that if the client who has the freedom to choose new counsel decides to choose new counsel, then that trust creates a legal right to the beneficiary of the trust, which can then be enforceable against a law firm, for example, who might be trying to otherwise hold those funds and say, no, if you're with us, if you're not with us, you're going to lose the funds, or against the funder or the grantor, as it were, saying, no, you got to do this. But it's,
and I get the exposure risk. My concern is always when we're talking about regulations and the ABA model